I don't like the sound of that. All right. Thank you all for being here. Today is Tuesday, March 10th. This is the hearing of the House Judiciary Committee. We are going to start with Delegate Embry, HB 1441.
Madam Chair, may the panel come up?
Yes, please.
Your Honors, if you'd like.
Great.
Take whichever seat. And I don't see Robert Hill.
I think he's going to be virtual.
Oh, okay. And Madam Chair, we have one virtual witness possibly, we believe.
You need to pull the mic. I can't hear you.
Oh, I'm sorry. We believe we have one virtual witness as well.
Okay, thank you.
Thank you so much. Shall I start?
You may proceed.
Thank you, Madam Chair, and all my wonderful committee members. I hope this is a non-controversial bill. I hope. Currently, certain citations, and specifically the ones that are covered in this bill relating to public consumption of alcohol in open container, are must appear. That means you cannot prepay the ticket. You have to come to court. The problems with that are, of course, it's preventing a person from, dealing with it quickly and expeditiously and not having to go to court. A lot of people don't come to court, and then the judges have to proceed with contempt actions, and it's pain for them, and then the person has to deal with even more court actions. And also it requires the police officer to come to court as well. So this would make it prepayable. It would allow the court to set a prepayment schedule that would be up to the maximum amount. We're not exceeding the $100 maximum. And so I think this benefits all parties involved. There is no opposition. And with that, I will turn it over to Chief Judge Morrissey.
Thank you very much. Good afternoon, Vice Chair Davis, members of the committee. For the record, my name is John Morrissey, and I'm Chief Judge of the District Court. And the Maryland Judiciary supports and thanks, I know it's unusual for me to say that, but we do support House Bill 1441. We'd like to thank Delegate Embry for bringing this bill. As you heard what the mechanics of the bill are, Maryland has previously taken a similar approach to civil citations along the same way. If you remember back when we were in that phase with the cannabis legislation, the law that took effect on January 1st of 2023, individuals receiving a citation were given three options. They could pay the fine, request a trial, or take no action, in which case the court would enter a finding of guilt and impose up to the maximum fine. This system has proven effective in reducing mandatory court appearances while still preserving the right to contest a citation. It's allowed individuals to resolve these matters without needing to miss work or rearrange their schedules to attend court. House Bill 1441 proposes a similar framework. This amendment also aligns with the district court's goal of expanding Maryland online resolution programs, or something called MDOR, that we're currently in a pilot right now for traffic fines, and it would be a remote type of where you could contest a citation online. We have it piloted in 4 different counties. Once that proof of concept is done, we hope to expand it for traffic citations statewide, and then phase 2 would be these other type of citations where people can, it's a one-stop shop on the internet. You can pay, you can contest your case, you can plead guilty with an explanation, or you can request a payment plan. It's only been in operation for 6 weeks in 4 counties. We already have over 1,000 registered users, and we haven't even promoted it. You have to find it on our website right now. We're actually looking forward to promoting this by the end of the summer is what our target is. And I think it's really been beneficial to the users and to the court system. So I appreciate your listening to us, and we would hope for a favorable support of House Bill 1441.
Good afternoon, Vice Chair Davis and members of the House Judiciary Committee. My name is Eric Ney, and I'm an Associate Judge of the District Court of Montgomery County, Maryland. I'm here today to urge you to support House Bill 1441. First, I would like to thank Delegate Embry for reviewing our proposal and agreeing to sponsor this bill. I would also like to thank Judge James Green, Senior Judge Norm Stone, Attorney Suzanne Peltz, and Chief Judge John Morrissey for their assistance in drafting this bill. This is a very simple bill. Drinking and public citations are by statute classified as must-appear tickets, meaning anyone who receives one must go before a judge to resolve their case. These citations carry a maximum fine of $100. This bill changes these citations from a must-appear case to one which may be resolved by simply prepaying the fine. This matches the current practice for many common citations, including parking tickets, red light, and other non-jailable traffic violations. While those who receive these citations will still have the option to come to court to plead their case, allowing prepayment will reduce the volume of these cases and free up time on the court's docket for more serious matters. It would also solve a major problem with these cases, which is non-appearance. In my experience, most people who receive these citations do not show up for court. It also avoids the need to begin civil contempt proceedings against someone who does not appear, which are time-consuming for the court, police, and the state's attorney's office. Recently, I had a docket where I had 8 alcoholic beverage tickets on my morning docket. Only 2 people showed up. They pled guilty, paid their fines that same day. The other 6 cases had to be continued. This bill is a win-win for police officers who issue these citations, for the courts and other personnel charged with processing them. If enacted, House Bill 1441 allows that if a person does not respond to the summons to appear, the court may hold a hearing if the evidence supports a guilty finding, impose up to the maximum fine of $100 and court costs $5 against this person. This simple change is also a win for defendants who will not have to take a half day off of work on a must-appear citation just to plead guilty. So I urge a favorable report. Thank you for your time and consideration.
Thank you. We have one virtual witness, and it is Robert Hill. Okay. Okay.
By the way, it's horrifying seeing yourself.
Mr. Hill, you may proceed.
Yeah. Good afternoon. Good afternoon, Madam Chair. Robert Hill. I don't know why my video is not working, but I want to thank Delegate Embry for her sponsorship of this bill. I've spoken with my good friend Judge Nee about this, and we're coming from this from the standpoint of prosecutors. The Maryland State's Attorneys Association, as well as the Montgomery County State's Attorney's Office, is in support of this bill. My name is Robert Hill. I'm a prosecutor with Montgomery County, and I handle cases in the Special Prosecutions Division. This bill makes a lot of sense, and as Judge Nee said, it's a win-win. I think it's a win-win-win, a win for the court and the judges, a win for police, and a win for prosecutors, because it will make the docket smaller. And I think maybe even a win for members of the public who won't have to, get in the car and come to court and wait to deal with their case. So for these reasons, I would, in adopting the testimony of Judge Nee and Judge Morrissey, I would ask for a favorable report. Thank you.
Thank you. Colleagues, any questions? All right. Seeing no questions. Delegate Conaway.
Thank you, Chair. Thank you, panel, delegate and panel, for coming and testify. How much did you say the fine was? Did I hear something?
It's up to $100.
Up to $100. Thank you very much.
Thank you. Any other questions? Thank you so much for being here. That concludes the favorable testimony and the entire testimony on HB 1441. Thank you so much.
Thank you very much.
Thank you.
All right. We have some visitors today, and my colleagues have asked to be recognized. We want to start from this side and work your way around if you have any shadows today that you'd like to introduce. Delegate Cardin.
Thank you, Madam Chair. I'd like to introduce Daniel Turner, who is sitting on the right. If you want to stand up and just wave, say hello. Thank you. For those of you who might remember, he served as a page a few weeks ago.
Awesome. Anyone else in line? I'd like to introduce Frank Monroe. Would you stand? Thank you. From Charles County. Thank you so much for being here. Anyone else? Delegate Woods.
I would like to introduce Johnny, and we never got your last name. We've just been talking. Can you stand and then yell out your last name for everybody?
My last name is Albrecht.
Johnny Albrook, and we have been having a wonderful conversation. He's been asking a lot of questions, and so it's been a wonderful experience. Thank you, Madam Chair.
Great. Delegate Arcan.
Yeah, thank you. Okay, Judah, you want to stand up? He hails from Montgomery County, and he's here for the day, and he's going to head home. Actually, he's going to head to the speaker soon, I think, and talk to the speaker, so that'll be fun. Thanks for coming down.
Okay, seeing none, thank you all for being here. I know you have a tight schedule today, so I made sure we got you introduced early. So now we're going to call the second bill, which I understand that HB 987 has been withdrawn. If you're here for Delegate Ivy's bill, that bill has been withdrawn. We're going to go to the third bill, and that's...
Is it a slightly different schedule? It's on top of here from what's on the desk, I'm sorry. So it's going to be Delegate Schmidt's bill.
Okay. Delegate Schmidt, HB 1053.
Thank you, Chair.
Thank you.
I think I have a few people here to testify.
Okay.
You want to join me?
You want me to call them, Delegate Schmidt?
If you see them.
No, it's just you.
Is it just me? All right.
All right. You may proceed.
The lone wolf. I know, right? Thank you, Madam Chair and esteemed colleagues. Great to be back in front of you as always. I miss you dearly. All lies. This bill has been introduced for many years. It's moved in the Senate a couple different times, never officially made it through, but it simply adds sports officials to the criminal law section 3-203. House Bill 1053 prohibits a person from intentionally causing physical injury to another if the person knows or has reason to know the individual is an official, an umpire, referee, or a judge officiating a sporting event. This bill also authorizes a police officer to arrest a person without a warrant if the officer has probable cause to believe the person has committed such an assault. If you refer to basically on page 2 of the bill, it simply adds the official, the umpire, the referee, or an officiating judge to that code. Sports are a great and fun way and a fun part of American culture. For sports to happen, there must be sports officials. Actually, my son and I did the umpire class this past January and February, and I got to tell you, it is a whole different perspective from an umpire standpoint than it is from a coach's or a player's standpoint. Without the umpire, the game doesn't take place. The National Federation of State High School Associations reports that 80% of new high school and youth sports officials will quit within the first 2 or 3 years of becoming a sports official. And I will tell you, it is not cheap to become a sports official, not just the uniforms, the application fees, the technology fees. It is quite an endeavor to become a sports official. We will end up with about 40 classroom hours to be a sports official and 12 training hours on the field. This bill helps ensure that sports officials can officiate games safely so sports can remain a strong part of the American culture. Currently, 24 states have added laws addressing assaults against sports officials. Unfortunately, assaults on sports officials are becoming more frequent and more violent. I'm sure we've all seen different videos. There have been officials attacked on hockey rinks. There's been officials attacked in parking lots. And we need to put an end to it, or at least put some sort of a deterrent to that. Sports organizations across the country are also working to strengthen protections for officials. Last year, the U.S. Soccer Federation implemented an abuse prevention policy. We also have that at the state high school level now as well. As a state, we should support sports organizations with laws that complement and reinforce their policies. At the federal level, there is also bipartisan legislation known as the Protect and Serve Act, which would create a federal offense for deliberately targeting law enforcement officers with violence. This bill is similar to that, and the proposal protects law enforcement. House Bill 1053 seeks to provide similar protections for all of our sports officials. Keeping sports officials safe helps keep sports safe. I respectfully urge a favorable report on House Bill 1053. Thank you for your time.
Thank you. questions. Delegate Simmons.
Thank you, Madam Chair, and thank you, colleague. So when you look at sports, is there any conversation around training of de-escalation with the players as well as the officials that are monitoring these games and officiating?
You know, that's a great question. I think that came up a little bit last year when I presented the bill. I will tell you, going through the class recently, it's explained to the sports officials to almost kind of get out of the situation. The times that the sports official tries to de-escalate a situation could sometimes almost lead to it being a worse situation. I will tell you, as an umpire, there's typically 2 of us, sometimes 3 of us. Before the game even starts, we already have a plan where the exit strategy will be. And that's how things have gotten. So as far as de-escalation, we're instructed to basically step away from a situation, especially if it's 2 players. Now, if it's a player on a sports official, we're instructed to basically get away from the situation. So I don't know if you mean verbally or physically what your question might be. But both. I mean, we do have some de-escalation methods with the coaches to kind of walk them kind of away from a situation or help them explain a situation to where it's not a talking down to each other, but a more cooperation with each other. And right at the end of the day, we're setting an example for the kids and for the players. So we want to make sure that we're doing the best job that we can to de-escalate any situation.
Sure. May I follow up?
Yes.
So when you're looking at such a rise in violence at these type of games throughout the industry, do you think there's a need to have a more law enforcement presence there for safety?
You know, you see it at our high school basketball events. You see it at our big football events where there are police presence. Unfortunately, I'm sure that there's probably not enough to go around. As the weather gets better and we have multiple fields being used right now as opposed to maybe one football field or one gym for football and basketball, I mean, a police presence probably would help a little bit. It's just hard to probably police 3 or 4 different locations at the high schools. So I guess it could be needed, but I think at the end of the day, we want to put any measures in place that it doesn't have to get that bad.
Thank you.
Great question. Thank you.
Thank you. Delegate Cardin.
Thank you, Madam Chairman. So if somebody hits or batters a person, regardless of whether they're an official.
No pun intended?
No pun intended. Without a deadly weapon, just hits them. Is that a second-degree assault?
I would say yes.
Okay. And if...
In my 3 years on judiciary, I would say yes.
Okay. And if a police officer... if a police officer wants to arrest somebody without a warrant, if they have probable cause to believe they've committed a second-degree assault, do they have the opportunity to arrest them?
I would say yes.
Okay. So that's what this bill does, right?
Correct.
So what do we do? We're just specifying that if it's against a somebody who's an umpire or a referee, that they have what? What do they have special?
Yeah, I think the idea, Delegate, and great questions, and I always love playing lawyer sometimes in front of you. Referring to kind of page 2 of the bill would be more or less just putting the official in line with, say, a law enforcement officer, parole probation agent, firefighter, emergency, just putting some sort of added layers of protection in for these officials to at least add a deterrent to them having the verbal assault, the physical harm.
And let me just reiterate, I think that there's a problem, and I've watched as a fan, a parent watching kids play, I am amazed with how particularly parents interact with officials. And so I appreciate the issue. I'm just not sure that this does it. But
yeah, I think I would have to defer to the committee to say, hey, look, what would be more of a way to make the bill a little bit better, a little bit stronger? If there's an amendment we need to offer, I'd be open for that.
Okay.
But thank you for the questions.
Okay, Delegate Woods.
Thank you, Madam Chair. Good afternoon, Perry Mason, Delegate Schmidt. How are you this afternoon? So I just wanted to get some clarity, because as I was thinking this bill was doing one thing and had a specific focus, but as I'm hearing you speak, I'm hearing something different. And so I wanted some clarity. Well, actually, before I ask you for clarity, I wanted to understand what has been the main focus of this this bill of assault of sports officials? Is this something that occurs because sports officials have been assaulted by, as I heard Delegate Cardin say, concerns that it's like parents or other people? But you mentioned earlier, which kind of threw me off a little bit, if the teammates, if the people on the team get involved in a scuffle, and then the sports official may or may not intervene. So I wanted to get some clarity, if you could give us an idea of where the major focus of your intent of your bill is.
Yeah, thank you, Delegate. I think the major focus would be sometimes on the field, you have coaches that are verbally aggressive towards the sports officials. Mm-hmm. And so as a contest may get a little heated, we want to kind of bring that temperature down a little bit. And we, to the tune of the delegate's first question about de-escalating, we aim to bring that down just a tad so that it doesn't continue throughout the contest. What we've learned is sometimes the game will end, you'll have a coach either verbally or physically assault an official as they're leaving the facility. We have a lot of issues with in the parking lot where the officials are attempting to get to their car. You have two sets of fans on opposing sides, and let's say you have to exit through the losing team's sideline, then you're being verbally and physically assaulted at that time. And so what happens is the official gets to their car, they may call their scheduler and say, we had this issue at X, Y, and Z field, and the scheduler or the supervisor may say, go ahead and call the police. The police show up, the official explains the situation, but at that point, everyone has kind of left the field and everyone's kind of gone on with their day. So somebody's not going to stick around and say, yes, I was the one that verbally or physically assaulted. And a lot of times we're seeing where it's hard to get other people to say, oh, I know who that parent was, or I know, the coach is pretty easy to find because they're going to be listed somewhere. But the parent is going to be the hard person to kind of discuss the situation. And so these officials are kind of caught between, do we go through that whole process? And yes, it does become a long, litigious paperwork that they need to complete, especially when it's on a high school, because there are a lot of different measures that we have as far as the state's concerned, as far as recording all of that. The issue is that then the police officer has to say, well, what was the person's name? And of course, the official doesn't have that. Right? They're not going to know who it was. And so this is more of a measure, as 29 other states have already put in place, to protect our sports officials, to make it fun for them, to allow them to be there for the kids. And what we've lost, to the tune of what Delegate Cardin brought up, we're losing that sense of community, we're losing that sense of belonging, we're losing that sense of sport when officials don't even want to be there.
Madam Chair, I won't be long. Two things that I heard my colleagues say. One of them was about the de-escalation training. I think that's something that maybe should be included in your bill, that for those people who are together, who we do know, that there's some de-escalation training. And then the second thing, to Delegate Cardin's point, would you agree that maybe you need law enforcement present at some of these games? Because again, as you just stated, if it happens in the parking lot and the coach doesn't know who it is, then how do we track down? You understand what I'm saying?
Yeah, I do.
These alleged persons. So do you think that there maybe should be something put in place where we can assure that there's some type of a security presence already?
Yeah, I believe that would be the case. I mean, obviously it comes down to funding, for those mechanisms to have the support. I'll tell you, my son was scheduled for a doubleheader this Sunday, and he's 18 years old, and he's going to be umpiring a 12 and under baseball game in Prince George's County. I mean, he's going to be a very brand new umpire. And a lot of times these coaches and these parents see a young kid show up they think that they can maybe posture a little bit, they can use his age to their advantage. And it would be nice to have some help, yet I just don't know if we have the funding to do something like that. Even at the high school level, it's going to be challenging to cover all the fields at one time. Now, maybe there is somebody on site throughout the evening at each high school in the state. It's just challenging to cover all the sports fields.
Thank you, Madam Chair.
Yep, thank you.
Thank you. This concludes the favorable testimony on HB 1053, and hearing no opposition, that concludes the testimony on HB 1053.
Thank you, Madam Chair. Thank you, committee.
Right. Delegate Congola, your shadows did not come back yet? No. Yeah, I think, okay, I tried to get them in here. All right. Delegate Valentine. I'd like to call Anthony Flegel, Richard Myers, Laura Wilt, and Greg Alton. I'll start. You may proceed.
Thank you, Madam Chair. I have quite a bit to read, so I will get started. Good afternoon, Chair Davis, members of the House Judiciary Committee. For the record, Delegate William Valentine, representing District 2A, Washington and Frederick County. I'm before you today to present House Bill 1044, Criminal Procedure, Post-Conviction Release, Crimes Resulting in Death of a Young Victim. I will begin my testimony with a brief synopsis of the horrific crime that led myself and Senator Quarterman to draft this legislation, followed by what the bill is intended to accomplish. On August 8, 2025, defendant, I will not use her name, was convicted of the death of her 9-month-old daughter, Bella, by the means of starvation. Defendant was also convicted of associated charges, but only the conviction of first-degree child abuse resulting in death carries a possibility of a life sentence. Upon her conviction by a jury, the presiding judge granted a bond review hearing. Defendant was subsequently released on a nominal bond, $5,000, which was paid the following day. She then subsequently failed to appear for her sentencing hearing. The court sentenced defendant in absentia to 90 years on the top count of child abuse resulting in death and applied credit for the time she had already served. Some of this credit was for time defendant had been incarcerated in the state of Georgia, where she had been arrested after failing to appear on a previous court date related to this same case. Defendant fought extradition in that circumstance and eventually was brought back to Maryland only after the issuance and service of a governor's warrant. House Bill 1044 would prevent future tragedies like this from occurring by the following means. It would state, a court may not release a defendant after conviction, pending sentencing, or exhaustion of any appellate review if the defendant is convicted of a crime of violence as defined in 14101 of the criminal law article, or a violation of 3-602.1, child neglect of the criminal law article, and the crime resulted in the death of a victim under the age of 14 years old. In closing, I'd like to read just a few lines from a Hagerstown Herald Mail article dated 8/14 of 2025 after this all transpired. Later in the hearing, the judge stated the reason he granted bond to the defendant last week was she was, quote, entitled to it under the law. During the sentencing portion of the hearing, the judge said he knew it was a real possibility defendant would not show up for sentencing, and he wanted to see if that would happen. To the first statement, we are legislators in this committee and here in Annapolis, and as such, we draft, modify, and repeal laws every year. I would hope this committee would consider this legislation to prevent future tragedies like Bella's. To the second statement, if the goal was to see if defendant would not show up for sentencing, I believe that only strengthens my argument for the need of this type of legislation to pass and become law. For those reasons, I respectfully request a favorable report for a House Bill 1044. Thank you for your time and consideration.
Thank you. Who'd like to go next? I can go.
Good afternoon, members of the committee. For the record, my name is Detective Anthony Flegel with Hagerstown City Police. I am actually the detective that was the lead in this investigation. In this case, a 6-month-old was basically starved to death by her mother. On the date of the incident, the mother showed up to the hospital. The child passed away. Mom fled the scene immediately, took her other 2 kids and fled the area. We actually had to get body attachments for those 2 kids just to make sure they were safe. The incident was later ruled a homicide, and the defendant was eventually indicted. We were supposed to have a trial on March 11th of 2024. She failed to appear, and we subsequently located her in the state of Georgia. And as the delegate had stated, it took a governor's order to get her back to our area. We went through the trial process. She was convicted, and it was a severe crime against a very young child, and she was given the opportunity to post a bond. And we all knew that she wasn't going to show back up for the sentencing because she had been a flight risk throughout the whole proceeding of the trial from the day she was charged. She didn't show. The trial judge sentenced her to 90 years, and now she is out and about, and we can't find her. And at this point, she really has nothing to lose. So she's very difficult to find, and I think she's a danger now when we do try and find her because of the sentences hold her over her head. I appreciate your time, and thank you very much.
Thank you, sir. Who would like to go next?
Good afternoon, Madam Chair, honorable members of this committee. For the record, my name is Greg Alton. I'm a retired detective lieutenant from the Washington County Sheriff's Office. I also serve on the board of directors for Justice's Sake, which is an organization that raises awareness to the problem of child abuse, and we also support children in many other various ways. One of the ways that we try to fight for victims of child abuse is obviously to come to Annapolis and testify in support of legislation that we believe will keep our children safe. I am here today to offer my support and testimony for House Bill 1044. Throughout my nearly 27 years of law enforcement, I've encountered numerous challenging situations, but this particular incident has left me very perplexed and disturbed. While law enforcement, the state's attorney's office, and most importantly, the jury, all perform their respective duties diligently, the circumstances surrounding the conviction of a woman who starved her own child to death are deeply concerning. Despite the jury's unanimous verdict of guilty on all charges, the convicted individual is permitted to post a bond prior to sentencing. This raises a fundamental question, in my opinion. In what world is it acceptable for a person convicted of such a heinous crime to be given the opportunity to flee and evade justice and continue to evade justice? During the Senate hearing, a question was raised regarding whether this incident represents a recurring problem or was it just an isolated incident. I ask the honorable members of this committee, is the loss of even a single child an acceptable outcome? Thank you for your attention in this matter.
Thank you. And lastly, no, not lastly, Mr. Myers, are you next?
Yes, thank you. Good afternoon. Dear members of the House Judiciary Committee, thank you for this opportunity to testify. My name is Richard Myers, and I'm here on behalf of Justice's Sake also. Today, we strongly support this bill addressing the post-conviction release for individuals whose crimes of violence against a young victim. This bill recognizes the fundamental truth that when the victim is a child, the harm is irreversible, and our laws must reflect the weight of that loss. By limiting the post-conviction release opportunity in these specific and devastating cases, the legislation helps protect the families from ongoing trauma and preserves the integrity of the original sentence. I think it's important to state that this bill does not take away any constitutional rights. The defendant already received full due process. What this bill does is ensure families the ability to heal and not always be trying to look and worry. Passing this bill would affirm Maryland's judicial system values the safety of our children, supports victims' families, and stands by the sentence imposed for the most serious and irreversible crimes. I respectfully urge the committee to support this legislation, House Bill 1044, and help ensure that no family who has lost a child to a violent crime must continue to relive the trauma. Thank you.
Thank you. Ms. Wilt?
Thank you. Good afternoon. I'm Laura Wilt. I'm senior attorney with Maryland Crime Victims Resource Center. I'm located in Baltimore City, but we have attorneys that work throughout the state of Maryland. We are together on behalf of those victims asking for a favorable report on House Bill 1044. I believe the bill is narrowly tailored to ensure equal treatment for those charged, the victims, and the victims' families as well. There are many provisions that are passed into law whose purpose is to ensure that courts are treating litigants fairly. Sometimes our laws are in place to create kind of guardrails to ensure our judges sentence within the same parameters around the state. You know, our sentencing guidelines, we have minimums, we have maximums. Criminal Procedure 5-220 is a related law that's similar to this one, but it guides judges on pre-trial release. There's a list of crimes commissioners can't release if they've been charged with certain crimes or have a certain record. Judges are to presume that they are to be held pre-trial. But there's a gap. There's a hole in our laws. We do not have a law that is similar after conviction. As detailed in the other testimony, this led a judge to issue a ruling that is not consistent with any practice across the state. I've never heard in 29 years of a similar release. This bill will only address those defendants who have been found guilty already, and a judge decides to postpone sentencing. I've heard two objections to this bill. One by the judges because it limits their discretion. I get it. I don't like when my discretion is limited, but you can see in this example why it is necessary so we have fairness in our courts and public safety as well. I would point out if the judge doesn't like it, all they have to do is not postpone sentencing and they can sentence within the guidelines or however they wish. Second, some would argue it should cover all persons' death, not just children. Thank you for your attention.
All right, thank you. Questions? Delegate Arakan.
Thank you, Madam Chair. I have so many questions about this case. It's like one of the most disturbing things I've ever heard, but I'm going to reserve those because they're not really germane to the bill itself. The judge did not have to grant this, under the current law. He could have remanded her to custody, right?
Oh, absolutely.
Okay.
There was no law that made him release her.
Absolutely. What was the judge's name?
Judge Michael.
Judge Michael, okay. This seems like a very small change to ensure that someone who has a real potential motivation to abscond to prevent that from happening. I mean, it's a tiny baby-sized change that could potentially protect tiny baby-sized people.
I think that was the intent, to ensure that it was only the listed crimes of violence, only with a young victim. Other people wanted us to expand it, but it very much is a narrow solution to a problem.
And then for the detective.
And I will add that that is the narrow focus, why we narrowed it so much.
Yeah, for the detective, I have to ask, how were the other two children? Were they okay? Are they okay?
They were actually healthy. Like I said, when her daughter passed away, she fled the hospital. She didn't even attend the funeral for the child that passed away. She took off with these two kids, and we had to get a body attachment. for them, so CPS could view them and make sure they were healthy, and they were completely fine. It was, for some reason, the one that passed away was the one that was malnourished.
To the point of dying.
Yes, I actually believe that the birth weight and the weight that she passed away at was very similar at 6 months old, if I recall correctly.
That's really heartbreaking, because that takes many months to accomplish. It's really a brutal way to kill somebody. Thank you.
You're welcome.
Delegate McComas, did you have a question?
No.
Okay. Okay.
Delegate Arkin did a good job.
All right, great. Delegate Mangione?
Thank you, Madam Chair. Thank you all for being here. And to the young lady, you mentioned it is pretty narrow. I just want to make sure I understand correctly that it's only if you've been convicted and you've caused the death of a child 14 or under. That's how the only people this applies to.
So it would have to be, the crime would either have to be a crime of violence.
Crime of violence.
Under 14101, it's all spelled out, all the different offenses, or a child neglect case under the statute. So one of those crimes, and then it would also have to result, that crime would have to result in the death of a child 14 or younger, under the age of 14.
Yeah, okay, thank you, that answers it. Yeah.
Thank you. Delegates, do we have any other questions? Seeing none, thank you. That concludes this panel. And that concludes our testimony for House Bill 1044.
Thank you.
We're going to move on to Delegate Arntz. Oh, great, there you are. House Bill 1484. And for the favorable panel, you're the only one I have listed. So whenever you're ready, you may begin.
Thank you, Madam Chair, Madam Vice Chair, and members of the committee. For the record, Delegate Steve Arentz here to present House Bill 1484, a bill to establish for the purposes of preventing a state's attorney from entering a plea deal involving a crime against a minor under 18 for the dismissal of a case related to charges. The bill also prevents registered sex offenders from entering places for children such as playgrounds, theme parks, and museums, children museums. Among those most vulnerable in our population are the children and youth. Those who choose to violate the rights and privileges and safeties afforded to them do not deserve to be let off lightly. This bill makes sure that the accused are held to the level of prosecution proportional to the crime committed, ensuring that violators receive proper punishment, will aid in reducing related offenses, as well as further securing the areas where the most vulnerable youth and children are present. Implementing the provisions that makes this huge strides towards achieving justice on behalf of our children. And I'm aware of some of the arguments as far as, I guess I'm unaware of how ensuring a violation of this type is pled out has serious constitutional and practical deficiencies. These are our children. And I understand that plea bargains are resolved with 90% of our criminal charges, but there should be no room in my world for somebody when it comes to a child sex offender. I urge a favorable recommendation on the bill. Thank you.
Thank you. Members, do we have any questions? Seeing none, that concludes this panel.
Thank you very much.
Delegate. We're going to move to our unfavorable panel. Christine Dufour.
Good afternoon, Madam Chairman, Chairwoman, and members of the committee. I'm Christine Dufour, and I'm here on behalf of the Maryland Criminal Defense Attorneys Association. We urge an unfavorable report because we don't want any restrictions placed on the ability to negotiate pleas. A plea offer doesn't necessarily get defined as something where a charge goes away or a defendant gets no time at all. A plea in cases of such of this nature probably contemplate significant period of incarceration, but perhaps not life or something that could be exposed to a defendant if they took it to trial and was not successful. But I think to tie the hands of the state's attorneys in a case as broad as this, there are all sorts of situations where a plea offer might be warranted, whether there's issues with the complainant's credibility or ability to take the stand out of fear or in any other reason. I tried a case last spring where my client was charged with very serious sex offense against a minor. He was offered a misdemeanor plea offer. He rejected it. And when we went to trial on the stand, the complaining witness basically said it was a lie, and he was acquitted. So just because someone is accused of a serious crime doesn't mean, A, they're guilty of it, or B, there shouldn't be some negotiation about how to resolve the case short of trial. Thank you.
Thank you. Members, do we have any questions? Okay.
Thank you.
Seeing none, that concludes our panel and our bill hearing for House Bill 1484. We're going to move on to Delegate Grammer. House Bill 1392. Okay, I'm going to skip Delegate Grammer, and I will go to I'll go to, do we have anyone here for 1583, the department? Okay, all right. Let's go ahead and go to Delegate Archon 1467.
Just about to bite into a sandwich. Thank you, Madam Chair, Madam Vice Chair, my friends at the Judiciary Committee, Delegate Lauren Arkin here, Harford County, on behalf of HB 1467. I'll keep this super brief. Everybody here, except for our new friend, already voted for this bill. This bill passed unanimously out of the committee, unanimously out of the House last year, and got tangled up, as many good bills do, on the Senate side. I'm hoping that we can remedy that this year. If anybody would like to know what the bill does, just for our new member, essentially, this came from a case in my county where there was a, how do I put it politely, a serial buttocks grabber, perhaps, from another state who had come to our state and had continued his habit. And we were unable to introduce that at the sentencing portion to let the judge know that he should probably be receiving a little more enhanced penalties, given that he had a history of behaving in such a manner. So this would remedy that, and it would allow for the judge during sentencing to know that there's a history. That's what the bill does. Happy to answer questions.
Well, great. Members, do we have any questions? This is Delegate Archon we're talking about. You don't have any questions.
Talk to me about my compelling testimony. Yeah,
Delegate
please.
Cardin.
Thank you.
Hit it.
If you are convicted of a fourth-degree sex offense, are you required to register as a sex offender?
No, I don't believe so. I mean, it's up to the judge, I think, if you have to register. And I don't think it's lifetime either. I think it's potentially temporary. But it doesn't affect the sentencing portion. I mean, their conviction's not connected to this. This does not touch conviction. This is only at sentencing, so you can have enhanced penalties. But at the actual conviction, I do not go into that at all. The judge figures that out, or the jury, but this is just sentencing related.
All right, so this bill doesn't deal with that, but I think that you do have to register, do you not?
Maybe you do for a temporary period, but I don't think it's not lifetime.
Right, thanks.
Yeah. Any other big questions that don't get affected by my bill? No?
No.
Come on.
Thank
We can talk about ICE. No.
Thank you.
No, there's no fiscal note. I mean, there is a fiscal note printed. It does not cost any more money. It is not anticipated that it will cost any more money.
Thank you, Delegate Archon.
Yes, God bless you guys. Thanks for working so hard.
And God bless you. Okay. All right. We're going to call up Delegate Grammer, House Bill 1392. And Jill Snyder, is she going to testify virtually?
I would welcome anybody who you want to put on a favorable panel.
Okay. Okay. All right. So, Delegate, whenever you're ready, we'll start with you, and then we'll go to Ms. Snyder.
Thank you, Madam Chair, Madam Vice Chair, members of the committee. For the record, Delegate Robin Grammer to present House Bill 1392. House Bill 1392 eliminates the use of law enforcement quotas in Maryland. When former Baltimore City police officer Michael Wood was asked what his suggestions were for improving police culture, he recommended that we think about what our goals are. He lamented that the metric that he was given by leadership was arrests and spoke about how he would patrol his detail looking to satisfy his quota. He couldn't do that in the rich part of his assigned precinct that was predominantly white. He explicitly stated that he would drive to the black community in his patrol area to arrest people for jaywalking or littering. Proper policing is driven by community feedback. In many places in our state, we implement the opposite. Top-down policing implemented through quotas. Behind closed doors, officers are squeezed to produce higher numbers. Law enforcement quotas destroy community trust and incentivize bad policing. The use of law enforcement quotas are commonplace in our state due to the loose language of our current statute, as demonstrated to us by the formal quota system shared with us by the state police officers. Ask me about the box of chocolates in my district. I appreciate the continued discussion on this bill with the chiefs and sheriffs. This year, they asked that I find a state who has successfully prohibited this practice via law. I found the red state of Ohio, and that is the state after which this year's bill has been modeled. This year's version includes an escalation mechanism to the Office of the Attorney General, as well as an investigation mechanism by that office. I believe this is the best version of the bill yet. We should protect those who protect us, and we can do that by prohibiting the use of law enforcement quotas. Thank you for the opportunity to present House Bill 1392. Be happy to take questions and ask for a favorable.
Thank you. Ms. Snyder?
Good afternoon, Chairwoman Bartlett and members of the committee. Thank you for the opportunity to speak with you today. My name is Jillian Snyder. I'm a resident senior fellow of criminal justice and civil liberties at the R Street Institute. I'm also a lecturer at John Jay College of Criminal Justice and a retired police officer from the New York City Police Department. I believe deeply in holding people accountable for criminal behavior, but also in empowering officers to do their job. When I tell you that quota-driven policing is not the way to keep communities safe, I'm not saying that as an outside critic. I'm saying it as someone who lived it. When I was with the NYPD, I watched officers get pressured to issue a certain number of summonses, make a certain number of stops, hit a certain number of arrests, even when those actions weren't absolutely necessary. Officers who didn't hit those numbers sometimes faced discipline, not because they were doing a bad job. In many cases, they were doing great work, but their numbers didn't check the right boxes. That system tells officers that generating activity is far more important than generating results. Quotas also hurt the quality of policing. Research shows that officers operating under arrest and citation quotas have lower case clearance rates for violent crime. If you're spending your shift writing tickets to hit a certain number, you're not investigating the homicide down the block or building relationships that lead witnesses to come forward. Maryland's staffing reality makes this even more urgent. Baltimore City is short over 500 officers. Baltimore County has more than 200 vacancies. When you're already stretched that thin, the last thing you want is pulling remaining officers away from community-oriented work toward low-value enforcement just to fill out an activity report. Trust matters too. When people trust their police department, they report crime, cooperate with investigations, and they work with officers. Quotas erode that trust. Communities that feel over-policed for minor infractions become less willing to help solve serious crime. That's not a public safety win. It's a public safety loss. This bill has bipartisan support, and that's not a coincidence. Whether your priority is supporting officers, efficient government, or community safety, quota restrictions check all of those boxes. Quotas undermine officer discretion, they strain police-community relationships, and they pull resources from the strategies that actually reduce crime. This bill is a step towards smarter, more transparent, and more effective policing. I urge the committee to grant this legislation a favorable report. Thank you for your time.
Thank you. Members, do we have any questions? Delegate Simmons?
Thank you, Madam Chair, and thank you, Delegate Grammer. I know this is very passionate for you, and you've really been working hard. Can you talk to us a little bit about Maryland and what you see that is taking place in Maryland when it comes to these type of quotas with our law enforcement?
Thank you for that question. I really appreciate it. So, I mean, the most interesting information that we've seen demonstrated to us has actually come out of the barracks, where they've shown to us an actual quota system. This came from the state police. We've seen communication from law enforcement leadership where they've said, you know, who wants a new car? You know, the person who gets the highest number of arrests during a month, the highest number of citations is going to get a new police officer. But the most interesting one was from this past October, I believe. There's a state police barracks in my district, and they put out a box of chocolates. And they left a little note, and the note said, you can get a piece of candy for $1.50, or if you get 10 citations in a day. And they left a note that said, or something else. Well, what is something else? What does that mean? And it's always in these unspoken rules of within a barracks that allow officers to get benefits for, solely for performance numbers. If you're going to get more arrests or citations in a given day, you might get a certain perk, you might get some time off, you might get a more beneficial assignment. And if it's been shown clearly that officers who don't honor those numbers, they might get an assignment they don't like or is really punitive to their career, or they might be blackballed or denied opportunities. So we see these things time and time again. It's quite a weird way to demonstrate a quota with a box of chocolates in District 6, but it's something that's not going away.
Sure, thank you. Do you know if law enforcement agencies here in Maryland have, such as the Office of Professional Conduct, or anything that oversees their conduct when engaging in their duties in public?
Yes.
What is it?
It's this Training and Standards Commission does that largely.
All right. So in dealing with them, has there been any feedback from them in reference to what they're seeing?
There has not to me, no.
Thank you, sir. No further.
Delegate Woods.
Thank you, Madam Chair. Thank you, Delegate Grammer, for this extremely important legislation. I have a question.
Yes.
What is the driving force behind quotas?
That is a great question. The driving force behind quotas is the politics of law enforcement. The public wants to see our law enforcement agencies demonstrate that they're doing everything they can to make our communities safer. And what better way to demonstrate that than to show arrests are going up, citations are going up, we've got guns and drugs on the table. So even though it's been proven that enforcing to make the numbers go up hurts community and police relations and is not a good basis for law enforcement, the community wants to continue to believe and see that law enforcement is delivering. So this is a conflict typically between law enforcement leadership and the frontline officers. And the frontline officers hate it because, people who believe in the mission, officers, what I'm talking about when I say that, like officers who really believe in the mission of their job. They hate being told they have to arrest for the purpose of arresting, or they have to go out and give 10 or 15 citations because some local elected official is getting complaints of something. They want to believe when they go out and enforce the law, they're doing it using their discretion and doing it properly.
Madam Chair, just a quick follow-up, but you clearly said that there are officers who just look in certain directions. There's some clear disparities as to who's focused on. How do they make that balance of wanting to do the right thing when officers will look for a particular neighborhood and a particular type of people to cite?
Well, the officer, and you could look up this documentary. It's a really interesting, really great documentary. The officer's name is Officer Michael Wood. And
Officer Michael?
Michael Wood from Baltimore City. Mm-hmm. And he talks about this principle a lot. And I think about it this way. If you're a law enforcement officer looking to make the number go up, where do you do that? Well, you do that where the river's deep. And you do that where you could find these tiny infractions. Littering's a crime. Jaywalking was a crime. And you go to places where you could just enforce it over and over and over quickly as possible. And he said, blatantly, he patrolled a district. It was the northern part of the city. And he said, I couldn't enforce it in the white areas, so I'd go to the black areas. He said that. and I can send that documentary to you. And it demonstrates, when someone who's given a directive, like that's the directive, make the numbers go up. And I think you see the problem there. I think you see the problem with the incentive. And that's the problem with quotas. It's a problem with the incentive.
Thank you, Delegate Grammer, for engaging me, and thank you, Madam Chair.
Thank you. Members, do we have any other questions? Delegate Grammer, you've been bringing this bill for a while now. Have there been any change in the departments with respect to this practice?
Yes. Well, I'm sorry. The answer is no, but I'll talk about the discussion if it's okay. So I talked with, trying to remember the title, Secretary Jackson. Is it Secretary or is it Chief Jackson? And I said, Superintendent, I apologize. I talked to Superintendent Jackson at the beginning of the session, and we had a bit of a scuttle. And I said, look, let's just talk about it. And we talked about it for a week. And I said, look, whatever you think we can do to make this work, let's talk about it. And I gave them 2 weeks, and they came back and they said, there's nothing we can do with this bill. We just hate it. And I said, look, I don't think this is a chronic and overwhelming problem, but it's definitely a real problem. So they said, show me upstate where they've done away with this statutorily and it's worked, and show me that statute. And I found Ohio. Ohio it's a red state. They've done it completely statutorily, and I modeled this bill after Ohio. But there are states who have clearly done away with this process, and they're clearly still able to enforce the law properly, and that's the bill I offer you today.
Thank you. Members, do we have any other questions? All right, seeing none.
Thank you so much.
Thank you. Is there a representative here from Delegate Healy's office? Okay, great. House Bill 1511, Delegate Healy, please. And it looks like you are the only person who's going to testify. So that's great.
Yes, that is great. Good afternoon, Madam Chair Bartlett, Vice Chair Davis, and members of the Judiciary Committee. For the record, I am Keisha Monroe. I'm the Chief of Staff for Delegate Ann Healy, seeking your favorable support for House Bill 1511, Public Safety Clearinghouse for Missing Persons. Thank you for the opportunity to testify on her behalf. House Bill 1511 reintroduces last year's Clearinghouse for Missing Persons bill, which passed both the House and the Senate unanimously with a neutral fiscal note. The bill changes the term children's to persons and moves the clearinghouse from the family law article to the public safety article. That change from children to persons means missing adults are now included within the reporting requirements. The legislation was originally drafted with a neutral fiscal note, mindful of the fiscal challenges the state has faced in recent years. Last year, the bill was amended to require a study of the department's capacity to report to the National Missing and Unidentified Persons System, or NamUs. That study has been completed, and an amendment has been drafted to remove that language from the bill as passed last year. The study is included in this year's fiscal note for your review and outlines the administrative demands associated with reporting to NamUs. That study was informational and separate from the function of this bill. One clarification regarding the study. It references the Missing Persons Clearinghouse, which exists as a unit within the Maryland State Police. However, the statutory language in the code refers specifically to the Clearinghouse for Missing Children, which established the current statutory reporting requirement in the code today. House Bill 1511 updates that statutory language to require a clearinghouse for missing persons. While the unit has the capability to address missing persons cases more broadly, the statutory language is currently limited to children. According to the National Institute of Justice, 16 states currently require cases be entered into the National Missing and Unidentified Persons System, although those mandates vary. Maryland does not currently require reporting to NamUs. This bill establishes a clear reporting requirement for missing adults in Maryland. It does not require reporting to NamUs. House Bill 1511 closes the gap in Maryland law by ensuring missing adults are included in the state's reporting structure. Our public safety partners continue to support this bill, and I just want to say once more, this bill passed both the House and the Senate chambers and this committee unanimously. And for these reasons, Delegate Healy requests a favorable report on House Bill 1511. Thank you.
Thank you. Members, do we have any questions? Okay.
Great.
Thank you very much.
Yes, thank you so much.
I saw Delegate Ruth. Delegate Ruth, House Bill 1359. So I'm assuming this is Miles Thornton?
Yes.
And do you want Stephen Yates to come up for information? Oh, we can call him the next panel. Okay, no problem. Okay, whenever you're ready. Thank you.
Thank you, Madam Chair, members of the committee. For the record, I'm Delegate Sheila Ruth presenting House Bill 1359, the D'Amica Thornton Act, which requires the Maryland Police Training and Standards Commission to develop a model policy for police departments in the state regarding the pursuit of fleeing suspects, which currently varies by jurisdiction. It does not dictate the details of what that policy might be, instead leaving those decisions up to the experts on the commission. It simply requires its creation. The danger of these pursuits and the need for this bill was made clear to me when I was approached by the parents of Ms. Thornton. Their daughter, an innocent bystander, was killed during a police pursuit that ended in my district. You'll hear her story from her father in a few minutes. While nothing can ever be done to take away the pain of losing a daughter in such a tragic way, the Thorntons are hoping to spare other parents the kind of pain and loss they experienced. These victims were not only residents of my own district, this is a statewide problem that affects all our constituents and communities. Over the last 5 years, 31 people have been killed as a consequence of police pursuit. I encourage you to read some of their stories in my written testimony. Just one quote from one of the stories. When asked what she would say to her daughter if given the chance, one bystander's victim's mother said, "I know we can't get you back, but what happened to you, my love, is going to be heard so that it doesn't happen to anyone else." And I know she would have liked that answer. It bears mentioning that in many of these cases, the person who was killed was not a party to the chase. They did not ask to be put in danger and did not consent to be involved in a police pursuit. These recorded numbers also do not include close calls, how many people were sped past or around or otherwise put into harm's way, or those who were injured but not killed. Any police pursuit policy should prioritize protecting the life and safety of the officers and bystanders. And that's the standard that this bill calls for in the model policy. The cost of catching a suspect is too high unless there is an immediate, certain, and unavoidable threat to life should they not be apprehended. A life is too high a cost for any other circumstances, even when that life is the fleeing suspect. These police pursuits pose serious dangers to all involved. The officers who should not be asked to risk their lives unnecessarily, members of the public who are guilty of nothing but living their lives and being in the wrong place at the wrong time, and suspects who haven't seen their rightful day in court. I also want to mention, you should see in your testimony, the Office of the Attorney General submitted favorable with amendments testimony. The Office of the Attorney General supports this bill with one amendment, and I would consider their amendment to require the commission to define pursuit to be a friendly amendment. Public safety must be a priority, and I ask for a favorable report on HB 1359. Thank you.
Yes, thank you for allowing me to testify today. I'm testifying today in support of the D'Amica Thornton Act, which highlights pursuit of fleeing suspects. My daughter, D'Amica Thornton, was killed as a result of a suspect fleeing police in April of 2024. In addition, the suspect was charged with a max of 10 years, but will only do 5 years because of current state laws governing vehicular manslaughter. Evidence of narcotic drugs found in his system were not admissible in the case because the police officer at the scene of the accident was not trained and certified to authorize the narcotic drug blood test. In my heart of hearts, my daughter was murdered. Manslaughter is a slap on the wrist in comparison to the magnitude of this fatal accident. Although we sought after legal representation for a civil case, we were turned down by 3 attorneys. After the attorneys started sifting through the red tape and laws currently in place to protect the Baltimore County Police, the attorneys informed us that it was not worth pursuing. I'm sure that this is the case of many parents and victims across this state and across the country. We do not feel that full, true justice was served in this case, but was manipulated into having to deal with the results because of the current state laws of Maryland. We plead with you on behalf of countless victims across this state and across the country. Do not let this be the case in the coming days, weeks, and months and years.
Thank you, Mr. Thornton. Thank you for your advocacy of coming in today and testifying. And I'm, on behalf of the entire committee, we are very sorry for your loss. Members, do we have any questions? Delegate Phillips, please.
Thank you, Madam Chair. Often, and Mr. Thornton, we just had an opportunity to meet, and Delegate Ruth had asked me to work with her on this bill. But I'm going to direct this question to Delegate Ruth. In sponsoring this piece of legislation, can you share with the members all of the conversations that you had in an attempt to figure out if there was another alternative?
Yes, thank you so much for the question. We did meet with Superintendent Jackson of the State Police. I have also spoken with the representative for the Chiefs and Sheriffs Association, and we tried to connect with the Police Standards and Training Commission. Unfortunately, our wires got crossed and just we're not actually able to meet, but I'm happy to meet with them again. We also spoke with the Attorney General's office, the subject matter experts in the Attorney General's office, who felt strongly that there needs to be some consistency in these policies. They have investigated just too many of these, and they want to make sure that the correct policies are in place, which is why they submitted testimony supporting this with the amendment that would require the commission to define what pursuit is, because that's, they said, what starts it. And so I believe that's all the conversations that we had, but we just have really tried to work with all the stakeholders to really find out. I did have a brief conversation with the Baltimore County Chief of Police as well, just to really try to find out how to make this work to protect people, to protect life and safety, which is the ultimate goal here. I do understand, although we were not able to meet with the Police Standards and Training Commission, I do understand that they are working on an effort currently to determine if a model policy is needed. I'm happy to support that effort. If there are ways we can amend this bill to better align with that effort, happy to work with them on that. I just want to make sure that whatever they do, that the end result will prioritize life, because life and safety, because that has got to be the most important thing. There are times when pursuit will be necessary for life and safety, but if it's not an immediate priority, then we really have to think, is it worth risking somebody's life?
Thank you, Delegate Ruth, and once again, thank you, sir.
Delegate Cardin.
Madam Chair, just real quick to follow up. Thank you, Delegate Ruth, for the bill, and thank you, sir, and our condolences to you as well. Is it likely or is it certain that standards were not kept in this specific case? Or would there be somebody who might even suggest that they did keep certain standards, there was just an accident?
Oh, and thank you for the question. The Attorney General's office, the IID, I forget what that's. I'm sorry?
I think it's the IAD.
I think it's IID and
IID.
Whatever the division that investigates police-involved deaths. They do investigate these pursuits as a part of their mission. So they did do an investigation on this. They found that given the evidence available, there was no culpability that they could charge given the evidence available. So this is not about blaming anyone for doing wrongdoing. These were officers that were trying to apprehend a suspect that was accused of stealing a car. But this is about making sure that the best standards are in place for all jurisdictions so that when they are faced with these situations, that they can make sure that they're making the best decisions. I know Baltimore County has I spoke to the Baltimore County Chief of Police. They have a comprehensive policy. Their policy and I think a lot of others, it's a matrix where it's like there's low, medium, and high risk, and then they have to balance all these different factors. For me, that's a difficult thing for me to understand, but I also don't have the training that a police officer has. But I think the first question we have to ask, even before we get into questions of, is the road straight, is it raining, is it worth pursuing for a stolen car, right? And if my car were stolen, I would want it recovered. I would want them to catch that person, but not at the risk of somebody's life. So I think that has to be the very first question we ask before we ask the other questions. That probably was more than you asked for, I'm sorry.
There are very few people that do as much research and preparation on bills as Delegate Ruth does. So thank you very much. Is there one jurisdiction that maybe is just the reason to standardize this is because are there certain jurisdictions that do a good job and other ones that don't, or we just want to make sure that whatever we're doing.
Well, these 31 deaths have occurred all over the state, so I would say we really need a comprehensive look at all the jurisdictions. Thank you.
Delegate Mangione? No? Okay. All righty. Thank you, Delegate Ruth, for your bill. Thank you, Mr. Thornton, for being here. That concludes this panel. Do we have Stephen Yates available for information? Thank you. Chief Yates?
Good afternoon, Madam Chair, members of the committee. Thank you for your opportunity to testify and just give us some information about police pursuits. First, I'd like to thank Mr. Thornton for coming and offer our condolences for the loss of his daughter. So it takes a lot to come up and testify on Annapolis. So just want to acknowledge that for him. I'm Steve Yates. I'm the president of Maryland Chiefs, Police Chiefs Association. And I'd just like to give the committee some information on what we're working on. As being chief president of the Maryland Chiefs Association, I am on the Maryland Police Training Commission, and we have a subcommittee currently meeting for this specific reason for police pursuits. We're currently trying to gather data from Maryland agencies and other agencies from around the country to come up with the best practices for public safety. Public safety is our #1 priority, and like the delegate indicated, it's the most important thing. The committee is looking at trends from around the country to get an accurate picture of what has transpired with police pursuits around the country and what other jurisdictions are looking at. For these reasons, we're taking a hard look into it and a deep dive to make sure that if we have to come up with a model policy, it's done correctly and we don't have to keep going back in to adjust it. For these reasons, I thank you for my testimony, and the Maryland Police Chiefs Association and Maryland Sheriff's Association has submitted a letter of information for the committee to look at also. So Madam Chair, thank you for your time, and committee members, I'll take any questions that you have.
Well, thank you very much, Chief, for being here. It sounds like you all and Delegate Ruth will be working together if this bill is passed. Is that correct?
It sounds like it in some
Sounds
form,
like it.
yes.
Yeah, because it sounds like there's some overlap on what the work group, is it a work group?
It's a subcommittee.
Subcommittee.
Yeah,
What the
subcommittee.
subcommittee is working on and what she's asking for in the bill. She goes a little farther than what the subcommittee has, but I think that you all might be able to provide some information.
Yep, I agree.
Delegate Mangione.
Thank you, Madam Chair. Thank you, sir, for being here. My question may be better posed for the bill's sponsor, but I guess I'll pose it to you because I'm very interested to hear in terms of this, I guess, study or work group, if it were to come back and make it, and my condolences to the gentleman who lost his daughter, and make it more difficult for the police to pursue criminals, then, you terminated pursuit, and it's a very serious criminal, and he goes on to harm somebody after the fact because the police were not able to continue pursuing this person, apprehending this person. Who would you look at as at fault? Is it policy like this? Is it the police should have had an opportunity to get somebody who couldn't because the pursuit had to come to an end? I mean, how do you discuss, or what's your take on a situation like that?
That's a great question. And that's why we're taking a deep dive into this and see what other jurisdictions, just not in Maryland, but around the country are doing so we can get this right. If you can't pursue and something happens, then you got to go by the rules that and the policy that may come out. You got to follow that, and that's why it's put into place. And if something would go on to happen and you follow the policy, that's all you can do at the end of the day is you did what you were allowed to do. So.
Yeah, well, thank you. Good luck with it. I know it's a tough topic, so I know I was shocked to hear there was that many, 32. I guess real quick, if I can just ask you, out of the 32, she touched on a little bit, I think 32 fatalities over the last 5 years or so. Are these usually situations where the suspect that's being chased hits somebody, or, I mean, you may not have all that data, or
there's
the police
a lot of
accidentally?
Different circumstances. More than not, the police officer has discontinued the chase, and the suspect continues to flee, and the officer isn't actively pursuing them. And that's what happens. As soon as the police officer turns on their lights to make a traffic stop, they take off, and the officer may shut their lights off right away, but the suspect continues to flee and causes a collision with somebody on foot in a car.
Yeah, that's very important to know when you think about making the decision on a bill like this, whether or not it really was just a criminal doing what criminals do, or whether it's solely, I mean, not whether there is an addition to the fact that the police pursuit caused, in which we know that's unfortunately the harm that comes with it.
This is like a 30-layer cake. There's a lot of layers to unfold about what happens, and a lot of police departments have pretty restrictive no chase policies, and as soon as they turn on lights and they take off, they shut them right back off, but the suspect continues to flee.
Well, thank you for your service. Yeah.
Thank you.
Thank you. Members, do we have any other questions? Delegate Simmons.
Thank you, Madam Chair, and thank you for coming out. So, when we listen to the tools and tactics that law enforcement have, right, we have helicopters, aviation units, drones, we utilize camera systems, license plate readers, all that. Can that be brought to bear during a pursuit?
Some of that stuff, it takes a little bit to get back. And up in Cecil County, where I'm from, it takes probably 20 to 30 minutes for a helicopter from MSP to get up there. So it would probably be over by then. I'm sorry?
License plate readers. Do you have them in Cecil County?
We have a couple. We don't have that many now.
Okay. Do they go directly to your communication system, the comms unit?
No, they don't. They go, no, it's not set up like that.
Okay. So outside of the police presence of the uniform officer patrol vehicle, is there any secondary way of pursuing a vehicle or indicating where vehicle have went?
There could be if a car would go by an LPR. The bridges coming into Cecil on 95 and Route 40 have them, so if they would go that way, I mean, there could be. It just depends where the suspect goes. Each event, it could contain different information depending where they're at.
Right. Do you know, is there a certain speed before a supervisor will terminate a pursuit, although it may be a high pursuit or a dangerous pursuit?
Each agency right now kind of has a different standard for that. If it gets, and a lot of the times it goes on what the crime is. If it's just traffic, it more than not, like 90% of the time.
What about your department? What is your standard?
For
a pursuit?
speed?
Yeah, pursuit.
We don't pursue anything unless it's a felony, you know. So it's just being in a small town, it's just not worth it.
So that's your regulations that if it's outside of a felony, y'all do not pursue at all?
For my department, yes.
Yeah, all right, thank you.
And then geographically too, what fits down around the metro, like up in Cecil, out in Western Maryland, may be a little more relaxed. It just, there's, like I said, there's so many layers to this. It's not one size fits all. It's just so
Do y'all have
complex.
the aid of the state police?
We do, yes. Yep.
Okay, thank you. No.
Thank you.
Delegate Phillips.
Thank you, Madam Chair. And I'm going to kind of follow on with Delegate Simmons. In Cecil County, one of the things that we heard is that in a more rural community or where there are more highways or single lane roads, all of those kind of go into how you decide whether to pursue or not to pursue. Is that correct?
That is correct, sir.
Now, Delegate Ruth mentioned a different factor, and that is the potential for someone to be hurt, even an innocent bystander to be hurt by a chase. Is there any standard that talks about making a decision based on the fact that this is a crime that's being committed against a person and it's associated with that versus something that has to do with property, a property matter?
Yes, they'll ask, usually if an officer initiates a chase, the supervisor asks, what are you chasing them for? What are your speeds? And if it's traffic and it's a high speed, 99 out of 100 times it gets canceled right away.
And if it's a car theft?
It's just a property crime. A lot of times now, in the past few years, I know we don't chase for a stolen vehicle. I mean, the person has their vehicle stolen might be upset about it, but it's just not worth it. And that's agency driven, so it's hard to say what everybody else is doing.
And so some agencies may pursue a car theft.
They may, but
agencies may
not likely. I mean, we've really clamped down in the last few years with what we allow.
The Thornton scenario was exactly that. That's why I asked the question. Okay. And so that's where I think we're trying to go with making sure that there are some a model policy. Mm-hmm. The question about model policy that comes out of MSP, agencies don't have to accept a model policy. Is that correct? They can still make their own.
It's in their best interest to.
And why is it in their best interest to accept?
Because it's a model, and if something would happen, it's good to be within that model. It's all about liability.
Okay.
Yeah.
All right. Thank you.
You're welcome.
Okay, I thought I saw someone else with a question. Well, thank you very much, Chief. That concludes the bill hearing for House Bill 1359.
Thank you, Madam Chair and Committee.
We're going to move on to House Bill, to Delegate Rosenberg for House Bill 1542. And we are joined by members of the Health Committee. We have Delegate Jennifer White-Holland, and we will soon be joined, hopefully, by Delegate Kathy Szeliga. So Delegate Rosenberg on House Bill 1542. We have a few favorable. Do you mind if I call up some folks, or do you have a panel?
Go ahead.
Okay.
Please.
Antonio Jeffrey, Matt Wells, and I may have two people online.
Good.
Okay. All right. So Delegate Rosenberg, whenever you're ready. And I only called up people who were favorable.
Thank you, Madam Chair. Repealing the death penalty in Maryland is the most profound thing I will ever do in my life. And it came through this committee. I came back to this committee because when I had a choice of what committee I could be on, I asked, do we have the votes yet on Judiciary to repeal the death penalty? And at that point, we did not. This was a 6-year effort to repeal the death penalty. I'm back before you today, I'm pretty sure for the first time since then, to ask you to prohibit a company that knowingly has a product that it is responsible for, that it creates or distributes, from doing business in the state of Maryland if that drug or product has knowingly, on the part of the company, been used in another state to execute an individual. This is a logical follow-up to what we have done, that we, as in repealing the death penalty, we said that we as a state did not want to sanction the death penalty, and this is a relevant corollary to that folks came to me and I readily said yes in terms of introducing this bill. And I would urge the committee's favorable report and defer to the other witnesses who are here today. Thank you.
Mr. Wells, would you like to be next?
Thank you, Madam Chair, Madam Vice Chair, members of the committee. My name is Matt Wells, and I am Deputy Director of Reprieve US, an organization that focuses on methods of execution, lethal injection in particular. We support House Bill 1542 and have submitted written testimony as well. I'll focus here on 3 issues related to the drugs used in executions and on why this bill's passage would prevent Maryland from being mixed up in illicit drug deals, protecting public health and business interests. First, this bill would align Maryland law with the long-standing healthcare industry standard. Executions take life-saving medicines meant to treat patients and misuse them in experimental doses and cocktails to end a human life. Not surprisingly, every manufacturer who makes the drug sought for use in executions opposes their use for that purpose. These companies have put in place robust controls to prevent their drugs from being sold or used in executions. Which brings me to my second point. There is no legitimate market for drugs used in executions. The trade of lethal injection drugs happens underground, violating manufacturers' controls and often federal and state drug safety laws. Execution drugs have been delivered in unmarked jars, have been handed over on a roadside in a cardboard box from the back of a car, have been exchanged for wads of cash in a suitcase. This bill protects Maryland and Maryland companies from this sordid execution business, from the black and gray market activity that dominates this supply. Which brings me to my final point. House Bill 1542 will protect prisoners from unsafe, unregulated drugs. It will also help protect patients in Maryland and beyond. Public health experts and drug regulators have said again and again, and this includes a former FDA commissioner, they've warned that the secret supply of drugs for executions opens unregulated channels, allowing dangerous drugs to circulate in the general population. Reprieve's own research shows these secret illicit deals also increase the risks of prolonged and excruciating executions. And Black prisoners are 220% more likely to suffer a botched execution than white prisoners. We hope that HB 1542 will receive a favorable from this committee. Thank you.
Whenever you're ready, thank you.
Good afternoon, Chair Bartlett, Vice Chair Davis, and committee members. My name is Antonia Jeffrey, and I'm the Director of Policy Campaigns and Government Affairs at Worth Rises, a national nonprofit organization working to end profiteering within the prison industry. Thank you for the opportunity to provide testimony in support of House Bill 1542. In 2013, Maryland abolished the death penalty, recognizing the deep racial and economic injustice it perpetuates, its discriminatory application, and its failure to deter crime. HB 1542 is a logical and necessary extension of that decision. If Maryland has determined that execution should not occur within the state, it should not allow companies licensed in the state to supply the drugs, devices, technologies, or services used to carry them out elsewhere. This is not a radical step. It's a measured, forward-thinking policy that aligns Maryland's commercial practices with its moral and legal position against capital punishment. Moreover, HB 1542 reflects a longstanding industry position amongst pharmaceutical manufacturers and distributors. The American Medical Association, the American Nurses Association, the American Pharmacists Association, and the Alliance for Pharmacy Compounding, among other professional associations, have all come out against the misuse of healthcare products and medical personnel in executions. And beyond the healthcare industry, major chemical corporations have also banned the use of their nitrogen gas in executions. This is not a hypothetical concern for Maryland. With executions surging nationally in recent years, states face supply shortages that are increasingly aggressive in seeking new sources, making Maryland businesses an active target. Without HB 1542, Maryland has no way to avoid being drawn into an execution supply chain that the state has already morally and legally rejected. And similar legislation has been introduced and received strong support in Connecticut. Passing HB 1542 would protect Maryland businesses, workers, and reputations from participating in these practices, and we ask for a favorable report for this bill. Thank you.
Thank you. Ms. Lisa Brown. Ms. Brown, we cannot hear you. There you go. Yes, we can hear you now. Thank you.
Thank you. My name is Lisa Brown. It's an honor to speak to you today. I'm an Army veteran, a retired civil servant with a total of 40 years of combined federal service, and I am a strong advocate for justice. I'm here to strongly support HB 1542, which would keep Maryland free from involvement in the death penalty, barring Maryland corporations from knowingly participating in the execution supply chain. In 2020-2021, a corporation from a state that, like Maryland, had abolished the death penalty provided the drugs for 13 federal executions. My son, Christopher Bialba, was the 7th of those executed. I researched the effects of the execution drug pentobarbital prior to my son's execution, but it could not have prepared me to witness the state-sanctioned, premeditated murder of my son. It took 28 minutes for my son to die after the administration of the pentobarbital. Before he lost consciousness, his cheeks puffed out twice and he appeared to yawn once. These are classic signs that someone is having difficulty breathing and is struggling to get more air. His skin turned bluish purple, indicating he was cyanotic. There were tears coming from his eyes as he turned his head to look at me. I still don't know if that was from fear or pain. Every one of those executions were inhumane. Corey Johnson was one of the last of the 13 to be executed. His lungs were already compromised due to him contracting COVID-19 prior to his execution. It was reported by the Associated Press that he suffered from pulmonary edema and that so much rushed up his trachea that some exited his mouth, which would have caused him to suffer excruciating pain while dying. My son was given 52 days after receiving his death warrant to prepare himself mentally and spiritually to be murdered. His death certificate indicated his manner of death as homicide. During the execution, I realized I was witnessing the state-sanctioned premeditated murder of my son. It is not just my home state that bears responsibility for this horror. It is an entire chain of manufacturers, suppliers, and regulators that caused this to happen. Maryland must not be a part of this chain. I ask that you support HB 1542, pass it into law, and make Maryland an example for the other states and for our federal government of what it means to choose justice over cruelty. Thank you for your time.
Thank you, Ms. Brown. And I know that was painful to do and to share, but we appreciate you and your advocacy. Thank you.
Thank you.
Next, we're going to have Mr. Hood. Mr. Jeff Hood. Mr. Hood, can you hear me? Your advocacy. Thank you.
I can. There's a delay.
Okay, so that means you need to turn off your YouTube while you're testifying.
Thank you, Madam Chair.
Jeff Hood.
It's a difficult thing to talk about.
Can you hear me?
Yes, I can hear you. There's a delay.
Okay, so that means you need to turn off your YouTube while you're testifying.
Thank you, Madam Chair.
Jeff?
All right, I think I'm ready to go now.
I think so. Thank you.
Thank you. Madam Chair, thank you so much for the opportunity to be here. I'm coming to you from Little Rock, Arkansas. I am a spiritual advisor to men and women on death row around the country. And in that work, I have witnessed 11 executions. 9 have been lethal injections, and 2 have been nitrogen executions, nitrogen hypoxia executions. And I think that this bill is so important because states are trending towards more and more exotic forms of execution. So it's not just that Maryland is involved in one type of execution. Maryland is becoming more and more involved in, again, more extreme types of execution. I wanted to quickly speak to what a nitrogen execution is like. I went into the room with Kenny Smith during his execution last January. I approached Kenny. They turned the nitrogen on. Kenny began heaving back and forth, over and over again. He had this mask on. His face kept hitting the front of the mask. Saliva, blood, snot kept on coming out of his face and catching on the front of the mask. It looked like a waterfall coming down the inside of the mask. Just back in October, I was with Anthony Boyd when he was executed in Alabama. They turned the nitrogen on. His eyeballs looked like they were balloons blowing up. Again, we are not talking about, we're talking about more and more extreme. And the question is, does Maryland want to participate not just in executions, but in torture?
Mr. Hood, thank you for your testimony.
Thank you.
And thank you for the work that you do. Members, do we have any questions? Delegate Conaway.
Thank you, Chair. Thank you, Delegate and panel, for bringing this bill. So to simplify this bill, are we saying that a corporation in Maryland that makes a product should not, that can be used in a death sentence, should not be able to sell that product out of state? Is that what we're basically saying?
No, I mean, the making of the products, the selling of the product for any of the therapeutic uses that exist, like these medicines all have appropriate uses, and they could still be made and sold for those uses. The bill, and through the framing specifically around an intent threshold of knowledge, of knowing that you are selling to someone that intends to use it to carry out an execution. So the making of it is not a problem. The selling of it for all the reasons that it is made for by the manufacturer, approved for by regulators, is not a problem. It is only if you know when you are selling it that is for someone to carry out an execution with it, right, that the bill
So
would
we're
capture.
saying that a Maryland corporation should not be selling a product that they make to another state that they know is going to be used for that state's executions. That's what we're saying.
That's right.
Yes.
Okay, thank you very much.
Thank you. Delegate Cardin.
Thank you, Madam Chair. Just want to make sure I understand. So if you testified as the gentleman in the middle, thank you very much for your testimony, all of you. If this is used on the black market, or it's traded on the black market for the most part, it's traded by the companies who produce them on the black market?
So the companies who, if we're talking about lethal injection is the dominant method of execution and the one that we work on and I will speak to mostly. The manufacturers who make these drugs do not sell them. In fact, they have it in their contracts. These drugs should not be sold to a Department of Corrections for use in executions.
Got it. So they don't, So how does this legislation, which prohibits the manufacturer from selling, or they lose our business, I guess, if they, or that's not covering insurance, how would this, if it's being done on the black market, impact that? Maybe that's for the sponsor, maybe it's for you.
Well, the bill says you must, the bill takes effect if the manufacturer knowingly makes the product available.
Right, but we just got, the testimony is that they are not doing that. They don't want to do that. In fact, they specifically contract not to do that. They don't want the liability of it. So how is this, I understand what the intent is, and I agree with the intent. I'm just not sure that this is doing what we want it to, so.
In the state of Maryland, there are distributor licenses, there are pharmacist licenses. So some states resort to compounding pharmacies to compound drugs that are then used in executions. The pharmacies that have been outed as being involved in the sale of drugs for executions and compounding drugs for executions have been linked in every single case to a litany of health and safety violations. Okay. So if, for example, there was a pharmacy that has a license and it was contracted to compound for use in executions, they would be captured by this drug.
Okay, so it will be the pharmacy or the distributor as opposed to the manufacturer.
Correct.
Okay.
Correct.
Thank you. Got it.
Thank you. And joining us from the Health Committee, Delegate White Holland.
Thank you, Madam Chair, and thank you, Delegate, for bringing this bill and for all of those who have testified. It was mentioned on this panel that there's similar legislation has been introduced in Connecticut, but I wonder if other states have taken up similar legislation, or would Maryland essentially be leading the way if enacted?
The legislation in Connecticut and the one that we're presenting here in Maryland are both running concurrently. So whoever does it first will be the first. The approach is that states that no longer have the death penalty is where we would be looking to have this legislation and really set the precedent. It's an extension of work that has already been done by several people to outlaw the death penalty in various states, and it's looking to be a proactive measure, just as there are additional ways that that the death penalty has been evolving in other spaces. We're also looking for ways where states that no longer have the death penalty can continue to act on their already stated values against that.
Okay, thank you. Thank you, Madam Chair.
Thank you. Members, do we have any other questions? Delegate Rosenberg, did you want to add something?
Can I ask a question that I think is relevant of Mr. Hood?
We don't usually allow
I know
that.
you don't.
Can you, if you have something that you want to engage him to add, you could do it that way. Okay.
Thank you.
Actually, I do have a question for Mr. Hood. You said that this is, when you've been to several executions, you said, and your purpose of being there is for spiritual guidance. Is that what it said? Okay. I just wanted to make sure I understood your work. Thank you so much. Any other questions? All right. Delegate Moreno.
This is for Mr. Hood. Are there any other situations you want to add, or any other type of materials that are used, whether chemicals or physical equipment used in these types of situations?
Sure. I mean, there's certainly all sorts of materials that are used. You know, I think something that I was thinking about as I was engaging, you know, going to engage this hearing is, you know, obviously right now, this mask is a major component of conversation, especially in Alabama, with regards to executions. And if Alabama was not able to find it in a variety of other states. I found multiple retailers that sell this mask in Maryland. And I think what's important, I think, to note is that, again, there are all sorts of materials, and I think you could get right down to, all the way from IV bags to, all sorts of stuff. But I think that what's important to realize, I think, is what's been mentioned over and over again is intent. And it does seem like, there's a difference between buying this mask for use, for a firefighter to use, or for someone to use in, say, some sort of hazardous environment, and it knowingly be sold to be used in an execution, that I'm going to be in there praying with someone and working with someone and literally watch them suffocate to death. I'll just say this and I'll pause or stop. I mean, we're talking about these nitrogen executions that are lasting, Anthony Boyd's execution lasted 36 minutes. I was standing there next to him, 19 minutes of conscious suffering. And so, again, I think that we're getting more and more extreme, and we're seeing more and more materials used. I'll also add that in Idaho, in terms of their firing squad, instead of their corrections officers firing the weapon, they have come up with a way to have an automatic firing gun that nobody has to touch. And so, again, we're seeing more and more extreme circumstances, and I think it's got to do with intent as much as it does the individual materials.
I think you answered my follow-up question was if there were states that are trying to find other ways to be more humane in their practices, but it sounds like they're looking actually for more cruel ways to go about this.
Yeah, I think obviously I don't want to see anybody executed. I don't want to see anybody I work with executed, obviously, but I can say that when people begin to, I guess, get creative, creativity usually leads to more and more horrific circumstances.
Okay, thank you.
Delegate Woods, please.
Chair, my question is for Delegate Rosenberg. Delegate Rosenberg, if you had a question that you would ask Mr. Hood, what would that question be?
How is Sister Helen? She ministered to people on death row and testified for the bill here and met with Governor O'Malley.
So you would have asked him, how is Sister Helen?
How is she doing?
Okay. May I direct another question, Madam Chair?
Yes, and see, that's how we get around the rules. Go ahead, Delegate Woods.
Thank you, Madam Chair.
Mr. Hood, how is Sister Helen?
Yeah, it seems like she always she comes up so often that Helen Prejean is just the reality is I wouldn't be doing this if it wasn't for her. She's a hero and has consistently created an entire generation of people like me who are desperate to humanize these situations, and not just for the sake of the condemned, but for the sake of all of us.
Thank you, Mr. Hood. Thank you, Delegate Rosenberg, and thank you, Madam Chair.
Thank you all.
She's new to the committee this year, and she's already got it. All right, Delegate Conaway.
Thank you again, Delegate, for bringing the bill panel. Mr. Hood, I guess it is. Would you say that the use of that mask, I guess it's a fire mask, and that's somewhat offensive because it's a fire mask and they're using it for capital punishment, and that's somewhat similar to using these drugs for to put someone to death when they're specifically not prescribed to do that? Is that what we're saying?
Absolutely. I mean, I think what you're seeing with these executions is things that could be saving lives used to end life. And for me, I grew up in Atlanta. My dad was our county fire chief, and he served for 34 years there in South Atlanta. And for him, he had a conversation with me right when all of this was coming about, and he talked about how these respirator masks saved his life over and over again, and how disturbing it was for it to be used for the opposite purpose. And I think you're right; it's incredibly demeaning.
Thank you so very much.
Thank you.
All right, members, I see no further questions. Thank you very much. This panel is excused. And that is the end of our bill hearing for House Bill 1542. And the Health Committee members are excused as well. Thank you for joining us. We're going to go now to Delegate Rosenberg, House Bill 1361. And Delegate Rosenberg, I have some favorable testimony. Would you mind if I call them up?
I would definitely like them to be up with me, please.
Okay. David Wiseman and Megan Green.
And I promise to obey the rules this time.
It was fine. I knew somebody was going to catch on and ask the question, so it's all fine. Okay, whenever you're ready. Thank you.
Madam Chair and members of the Judiciary Committee, the image for many of us of drug dealing is the individual standing on the street corner. But the reality is that that individual is often part of a broad conspiracy that enables that person to sell illicit drugs. And what House Bill 1361 would do is make it treat conspiracies as conspiracies and not have redundant proceedings that treat this conspiracy as if it was an individual separated function. This would be, it would enable a more serious penalty to be assessed if found guilty, if the individual is found guilty, and would also be a more efficient use of court time and procedures. I am accompanied today by two experts from Baltimore City State's Attorney's Office who know this issue far better than I, and I will defer to them and ask the committee to give a favorable report, which I think will be bolstered by, I'm certain will be bolstered by their testimony. Thank you.
Thank you. Ms. Green?
Thank you. Good afternoon, Madam Chairwoman and committee. My name is Megan Green. I am an Assistant State's Attorney in the Baltimore City State's Attorney's Office.
Excuse me, Ms. Green, can we move your microphone over just a little bit more, just so we can hear you?
I'm going to move myself over a little bit.
No, that's good. That's fine.
Okay,
I just wanted to be able to hear you.
Thank you. I'm an Assistant State's Attorney with the Baltimore City State's Attorney's Office. There I am the Strike Force Coordinator with the Major Investigations Unit. I am here on behalf of the Baltimore City State's Attorney's Office to encourage you to return a favorable report on HB 1361. And I just want to take a moment to thank you for the opportunity to provide testimony before you today. I want to use my time before you to underline the intention and effect of this bill, that being that it does not create or allow for any new criminal charges in any given case. It does not change what is charged in a case, but rather where it is charged. When prosecutors charge a criminal narcotics conspiracy or a criminal organization under the criminal organization statute, the underlying acts that make up those conspiracies are already their own separate crimes. However, when these crimes span over multiple venues, the individuals that commit them end up getting charged for both the same set of events in different places. They may get charged in both, for example, Baltimore City and Baltimore County for separate crimes that make up one conspiracy. This bill would end the need for that. It eliminates redundancy in charging and protects against significant legal issues like double jeopardy and inconsistencies in sentencing. So for example, in one case that I worked on personally, we had two individuals that were engaging in a large-scale narcotics trafficking conspiracy where they were using 2 residences and a storage unit in Baltimore County and another storage unit in Baltimore City. Police executed search warrants at all 4 locations on the same day and recovered in total approximately 15 kilograms of fentanyl and cocaine. Those individuals were able to be charged in both Baltimore City because of the storage unit there and Baltimore County for the residences and storage units there. This bill would allow them to be charged in only 1 location under 1 conspiracy. Thank you.
Next, please.
Yes, thank you, and good afternoon, Madam Chairwoman, committee members. My name is Dave Wiseman. I'm the Deputy Chief of Investigations for Felony Firearms and Drug Trafficking Division of the Baltimore City State's Attorney's Office. I'm here testifying on behalf of House Bill 1361, asking for a favorable report by the committee. As Ms. Green indicated, this allows for the charging and prosecution of drug trafficking organizations in a single place. Incorporating our written testimony, which we have provided, one recurrent problem is that members of drug trafficking organizations operate in different localities throughout the state. So frequently we work with law enforcement partners, conducting investigations of drug trafficking organizations that spread their people, their drugs, their product, the things that they're selling, their money, their firearms that they use to protect those things across multiple political subdivisions. We frequently see it in the street-level drug shop operating in Baltimore City. We see it most frequently that way, dealing fentanyl and cocaine, methamphetamine, sometimes fentanyl pressed as prescription pills. And those individuals have sources of supply that leave the city border. Stash locations and manufacturing operations, the residences of the individuals, and money and firearms in those surrounding, in the surrounding counties. We've seen organizations operating primarily in Baltimore City, but with nexuses to Anne Arundel County and Baltimore County, Harford County, Carroll County, and Howard County. And that is not just individuals using the city to bring things out, it's people using surrounding counties to bring things in. These things transcend county boundaries. The bill does not allow for any new charges. It allows us to avoid double jeopardy. It allows for consolidation, efficiency, and economy of public resources, judicial, prosecutorial, and defense resources. So we are respectfully requesting a favorable report from the committee as to this bill.
Thank you. Members, do we have any questions? I have one quick question, and it's probably for Ms. Green, just because I understood your example. What I didn't understand is the benefit for the state, other than having to, being able to consolidate the 2 locations. What happens with respect to sentencing or anything like that? That's
absolutely.
Yep. Thank you.
Yes, thank you for your question. So essentially what this allows us to do is consolidate everything in one place in one case. It prevents witnesses from having to testify twice in separate venues about the same case. It prevents defendants from having to get attorneys for 2 separate cases so that we're only working with 1 person. It also makes sure that we have consistency in sentencing, so we're not dealing with judges from 2 different venues in what is essentially 1 case, and so that individuals aren't being sentenced for essentially the same set of facts in 2 different locations.
That makes sense. Okay, thank you very much. There's nothing that really helps the defendant other than the attorney, but in the sense of like, this isn't part of a plea or anything like that. If you agree to consolidate, then you could plea something or anything like, there's nothing that goes in that direction, right?
So the benefit to defendants is that it prevents double jeopardy. It prevents you from being essentially tried for the same thing twice.
Yes, okay, all right. Thank you so much.
Yes.
Members, Delegate Conaway.
Chair, thank you, delegate and panel, for coming in to testify. So by bringing the two charges together, charge A and charge B, you're gonna get more information you're gonna get B's information at trial A. You're gonna get more information at trial A than you would if trial A was by itself. Is that right?
Not necessarily. There is argument to be had at trial that you would still be able to bring in that information because it's part of the conspiracy. That would be up to the judge that you're in front of, but we could certainly make those arguments. This, especially where a conspiracy is charged, because we, as prosecutors, need to demonstrate the overall facts of the conspiracy. Whether a judge would allow it in would be up to the judge we were in front of.
So the conspiracy could be challenged. You could challenge it and say that you wanted the two cases to be separated?
A defense attorney.
A defense attorney?
Yes.
Well,
yes.
I meant your
yes.
defense attorney. Okay, thank you so very much.
Members, do we have any other questions? All right, seeing none, thank you so much for your testimony. We're going to move to our unfavorable panel with Tiara Bradford.
Good afternoon, Chair Bartlett and committee. My name is Tiara Bradford, and I am Senior Policy Counsel for the ACLU of Maryland. For the record, we urge an unfavorable report on HB 1361, mostly due to potential unintended consequences of this bill. The ACLU has several concerns, including this bill aiding the war on drugs. For far too long, U.S. drug policy has prioritized punitive approaches to drug use and production. The results have been potent and cheap drugs becoming more available and the stigmatization of harm reduction. Additionally, data, studies, reports, and court decisions acknowledge how racially disparate the impact the war on drugs has. We must focus on public health solutions to what is a public health issue. The drug war wastes tax dollars fueling incarceration while bringing harm to people impacted by drug use, all while failing to reduce the abuse of drugs. To save lives and promote healthy communities in Maryland, it's urgent we shift our drug policy towards health-focused strategies. I also want to flag the written testimony of our partners at the Public Defender's Office, who have provided in-depth the general litigation issues that would arise from the passage of this bill. It would allow prosecution to bring charges in any county where the state is considering a violation of any subtitle of both the criminal law and public safety articles. This seems incredibly broad for violations and furtherance of organized criminal activity. We are concerned that this legislation would aid to the pressure defendants are under to accept a plea deal pre-trial to avoid harsh penalties, depriving them of their day in court or an unfavorable plea deal. And for the following reasons and concerns, we urge an unfavorable report. Thank you.
Thank you. Members, do we have any questions? Delegate Conaway?
Chair, thank you, witness, for coming in to testify. Can you comment on part in your testimony that talks about stacking, the stacking concept?
Yes, and I was listening to the first panel's discussion. We were concerned about the potential issue of stacking, which is starting off with multiple charges and bringing that to a potential defendant and kind of pressuring them into accepting a plea deal. That's something we were concerned about. It sounded like the first panel was saying that new charges wouldn't be considered under this legislation, but to be honest, I would want to discuss that more with our partners at the Public Defender's Office and what the application would look like and the potential pressures that could arise from the passage of this legislation.
In combining two cases together, just naturally by doing that, you'll have more cards in the deck, so automatically you'll have more stacking that will be right there in the charges, right?
Yes, and I'm referring to that as pressure because I think
Yeah, I
the term
understand.
stacking is mostly about charges in the beginning, but I believe knowing potential sentencing and
When you
the
stack the
cost together.
charges, you put more pressure on the case.
Right, exactly.
Thank you so very much.
Thank you. Members, do we have any other questions? Seeing none, that concludes our testimony and our bill hearing for House Bill 1361. Now we're going to move on to private passenger motor vehicle insurance, House Bill 1583. House Bill 1583. And we're going to call up Jennifer Bevan Dangle, Nancy Egan, Rob Enton, Marie Grant. I saw these folks here earlier. Okay, there we go. Yeah, yes, this is a great time. Hold on one sec. Let me just do, yep. Go ahead and introduce Delegate Taylor. Thank you.
Thank you, Madam Chair, and colleagues and guests. I'd like to introduce Alzina Jones. Alzina, if you would stand up. She's actually my constituent and shadowing us today from Frederick Douglass High School. And thank you, Roxy, for being here also. She's my intern for this year. Thank you.
So is Bob Minton coming? Is he here?
He had to testify in another committee.
How dare he go to another committee?
He tried so hard to stay.
Okay. So I'm not going to testify, but if Jennifer Bevan Dangle, are you in the middle or here?
I'm the insurance commissioner, Madam
Right,
Chair Marie
exactly,
Grant.
Commissioner. Yes, if you want to go ahead and that's what I thought. I just wanted to make sure if you could go ahead and present the bill, that would be great. Thank you so much.
Yeah, thank you so much, Madam Chair, Madam Vice Chair, committee members. Marie Grant here on behalf of the Maryland Insurance Administration, asking for your support of this departmental legislation, House Bill 1583. I know recently you've been having conversations about Maryland Auto, the affordability index, auto insurance affordability generally. And this was a topic that we took a deep dive into as an insurance department working with legislators and stakeholders over the 2025 interim. We produced a pretty comprehensive report. This is the report. It's lengthy and deliberative. We couldn't reach agreement on a lot of things, but one of the things that we did reach agreement on that was a unanimous support for was further looking into how in Maryland we could consider design of a low-income program to help serve Marylanders. I think as we've all talked about, auto insurance is mandatory here in Maryland. It is also costly, and there are people that are clearly struggling to afford the products. And so this work group study, it would recreate with the same membership that we used last year, the work group that we brought together. It would consider whether a low-cost auto program or economic relief credit program should be open to income-eligible residents across the state with good driving records, or just limited to high-risk drivers insured through Maryland Auto. The study would look at whether and how coverage types and coverage limits for policies offered through a low-cost auto program should be constrained to control program costs. The study would look at eligibility criteria as well as funding. So I also want to share that there are several states that have similar programs. Every state in the country has some kind of high-risk pool, right? In Maryland, that's Maryland Auto. Other states do their pooling differently, and I'm sure my friend Nancy has lots of information about that. But a handful of states also do something for their low-income residents specifically. California has a program that may be the most robust. It has a little over 40,000 enrollees. It also has limited coverage though, right? New Jersey does something for folks who are on Medicaid, but it's purely just personal injury protection. And Hawaii does something as well for folks who are receiving benefits from the state. So those are all the kinds of programs and things that we would take a look into and come to you all with a recommendation. So with that, urge a favorable report. Happy to answer any questions you have.
Sorry, let me just get closer. Excuse me. Good afternoon, everyone. My name is Nancy Egan with the American Property Casualty Insurance Association, and I actually was the insurer designee that served on the task force. And we did look at a lot of different options over the course of the year last year. And one of the things that we did all agree to is to come up with recommendations about affordability and a program for low-cost insurance. Some of the things we talked about is possibly a low-cost auto plan, but the other thing that we have discussed, which is part of the study, is a subsidy for all low-income policyholders throughout the state. Last week, you heard testimony, and I know I answered a lot of questions on Senate Bill 816, where Maryland Auto Insurance Fund was looking about setting up a low-cost program for certain individuals that were insured in MAIF. Our viewpoint is that that was putting the cart before the horse, because this is actually looking at providing such a program across the state so that anyone, not just those in Maryland Auto Insurance Fund, but those that are insured in the private market would have access to some sort of low-cost program or subsidy. And with that, I'm here to answer any questions. Thank you.
Thank you. Ma'am, are you testifying?
Joy Hatchett, Deputy Insurance Commissioner. I'm only here to answer questions.
Okay, great. Okay. And so we don't have Jennifer Bevan Dangle? Okay. Members, do we have any questions? Delegate Conaway.
Thank you, Chair. Thank you, panel, for coming in to testify. On the low-cost subsidy in the state of Maryland, are you talking about making one rate throughout the state for the low-cost subsidy?
So, Delegate Conaway, if I hear your question correctly, because I tuned into the bill hearing last week, and I think there was a lot of great discussion about territorial rating. That is a separate issue, but one I am no less committed to looking at. Like, this would really be looking at, could we design a low-cost auto program for folks that truly can't afford auto insurance, that have lower incomes? Some of the questions that, and I think your question, have to do with what we are charging folks depending on the zip code in which we live in, and how those things get allocated. And that's something we are looking into separately, but it's still an important look we'll need to do.
Sure, but are you looking at one rate for everyone in the state or not?
So no other state does it like that, but some examples of how states put limits around territories. Every state in the country uses territorial rating in some form or fashion. California says you can't have zip code level. You have to be bigger, right? You have to be a certain number of square miles. Connecticut has a mandatory blending of a zip code or township based on the experience in that township and then the state rate. So essentially it takes into account that people are commuting, right, and commuting into urban areas. So there's a number of different ways that we could think about looking at territories for the future, but that's not this bill.
Okay, thank you.
Delegate Taylor.
Thank you, Madam Chair, and thank you guys for coming in today. This, what you're recommending is a study, right? And so you're not sure exactly what the study, what the recommendations would be. If the recommendation is for a low-cost auto program of some sort, would the Maryland Insurance Administration be able to implement it?
So I don't think that, Delegate Taylor, we are a regulator. We have fantastic outreach programs and regulatory programs. We wouldn't necessarily be implementing something. One option that I think this work group would look at as part of the study is whether Maryland Auto is the appropriate body to administer that. In other states, their high-risk pool may administer it, or a separate state entity. So it unlikely that it would be the MIA, and we would probably look to another body.
And it probably wouldn't be the commercial insurers either.
No.
So probably it would be the Maryland Auto. And we have a bill now, House Bill 816, that proposes exactly what potentially this study is going to result in. So, and I heard you, Nancy, loud and clear. You said you believe that that's putting the cart before the horse. Can you explain a little bit more why you think that's putting the cart before the horse when we have a bill that we could implement right away? And
Sure, I would like to talk about that. For example, in MAIF, you have someone with a DWI and 2 tickets, and he would qualify for a subsidy on his auto insurance. But your next door neighbor who has a clean driving record that's insured through a standard company who would qualify for subsidy but is not in MAIF would not be able to qualify under the MAIF guidelines that you've heard last week. We think that if you're going to provide a program for all of Maryland drivers, it should be for everyone and not limited to those insured in MAIF. One of the things that I should say is that low-cost auto was brought before the General Assembly several times. And we did have opposition to the bill because the program that was set up in California has lower limits than what's required under Maryland law. And there was a lot of pushback from other interest groups against moving forward with that bill. That's why we think that a study looking at all the options where we can see something that could work for everyone, and that we set up a set way to fund it without having to go back to the legislature every year or an assessment, et cetera, would be a good program. But that's up to the group to really look at and make great recommendations. And that's my reasoning about a Maryland Auto Insurance Fund, putting that cart before the horse. But thank you.
one more question. I'm trying to figure out how to pose this question because maybe you're helping me understand something a little better here, because the client only gets to utilize Maryland Auto once they have been turned down twice from a commercial, or if they don't qualify in some way for commercial, right? So I'm wondering, so are you thinking that under House Bill, I know it's 2 different bills, but it's relevant, 816, that somebody that was looking to be insured could go directly to MAIF before they were turned down? Just help me understand that.
Yeah, Delegate Taylor, maybe I can try, and I just want to make clear too, I mean, I think there are separate and overlapping issues considered in the 2 bills, right?
Mm-hmm.
So I think last week's bill with the amendments that you brought forward, supported by Maryland Auto, that is a bill specifically about looking at how Maryland Auto forms its rates within the high-risk pool, right? Is specifically for that high-risk pool. And when we say high risk is determined by driving behavior, right? So there may be other factors that folks have, right? They may be living in a zip code that has high risks, but at the end of the day, it's usually their driving behavior that is getting them into Maryland Auto. This is a bill that is looking at the appropriate entity for, is there a base level of a program that we can provide for folks that can address affordability, not just for folks that qualify Maryland Auto, but in addition to. Yeah.
There it is. Thank you.
Great. I'm glad we got to an understanding there. Members, do we have any other questions? I see none. Okay, that concludes this panel for House Bill 1583. We're going to move over to our favorable with amendment panel, and that would be Marceline White, Brian Popham, and Al Redmer Jr.
Marceline had to go to Senate Finance to testify.
Oh, okay. Another person who left us to go somewhere else. That's all right. So Mr. Popham and Mr. Redmer, hopefully the amendments might be the same. If not, we'll read them on her testimony. You can begin whenever you're ready. Thank you.
Thank you, Madam Chair, members of the committee. Bryson Popham on behalf of the Maryland Association of Mutual Insurance Companies and the insurance agents and brokers, appearing on behalf or in support of House Bill 1583 with amendments. I haven't provided amendments, but I did circulate to the committee today a letter from one of my clients that supports the bill with amendments with, I think, an interesting idea. It is a letter they sent yesterday to Insurance Commissioner Grant. She responded promptly that she would take a look at it, and I just want to describe it to you a little bit. During his testimony last week, Mr. Redmer said that the Motor Vehicle Administration provides on a regular basis a number of registrations that are not insured, and that MAVE communicates with them. Now, those are people who have uninsurance, who are not insured. They're supposed to be the ones that go to the private market to get their insurance. So obviously they haven't done that. Why that notice is sent to MAVE instead of to the private market is beyond me. So my client came up with an idea. It is embraced, the concept is embraced in that letter you have before you, and it's to create, under the supervision of the Insurance Administration, a producer directory. We have literally thousands of insurance producers in the state of Maryland. Mr. Redmer testified that MAVE alone deals with 1,400, and some of those certainly represent companies that would write business that does not have insurance today. And we think that's an idea worth exploring. I'll go out on a limb. I don't know if the commissioner's still in the room. Her direct quote was, we'll take a close look at it. And I think I would urge the committee to take a close look at it. So that would be the substance of the amendment that we would proffer on House Bill 1583. And with that we'd request a favorable report. Thank you.
Thank you. Mr. Redmer.
Madam Chair, committee, good afternoon. My name is Al Redmer, Executive Director of Maryland Auto. We would like to support House Bill 1583 with an amendment, and we appreciate the Commissioner and the administration's continued work and commitment to addressing the state's affordability issues in the auto insurance market. Maryland Auto was created by the legislature 50 years ago to assist uninsured folks with attaining coverage, and we are committed to the mission and appreciate any additional tools that can help us insure Maryland drivers. I'd like to draw your attention to page 3, number 5, where it says they will look at the appropriate entity to administer a low-cost program. We're going to offer an amendment to modify that language to say whether Maryland Auto should do that administration. You know, insurance is a complicated industry, as you're finding out, and there's plenty of work to do, and time and resources spent looking around the country for administrators should be invested on the bigger issues that we face. Maryland Auto employs almost 200 experienced and talented insurance professionals that have proven their dedication to the mission of insuring folks with financial challenges. Again, we've been doing it for 50 years. I'll point out our general administrative expenses are less than 11%. We're a very efficient and effective organization. Many of our policyholders are with us because of financial challenges. They would qualify for any low-cost program, and these are folks where we already have a relationship and have earned their trust. So rather than considering outsourcing Maryland jobs out of state, I would ask you to adopt the proposed amendment and endorse the work of these hardworking Maryland-based employees. And finally, with that, Delegate Taylor, if you'd like to ask me about the cart before the horse, I'd be happy to explain it. With that, I'm happy to answer any questions.
Thank you very much. Members, do we have any questions? And what type of horse are we talking about? Delegate Conaway.
Thank you, Chair. Thank you, panel, for coming to testify. Can either of you comment on the part of the bill that says economic relief credit program to reduce the cost?
So I don't want to speak for the Insurance Administration, but I was a member of the work group, and there were a number of ideas floated on providing financial assistance to folks to help them purchase automobile insurance. So as you know, with Maryland Auto, we use an affordability index that suppresses rates. I think what this is looking at is providing additional financial support, similar to what happens in the health insurance marketplace. But I think the point is, I don't think there's any preconceived notion as to where this ought to go. I think we should look at all of the options and make an informed, educated decision. But that's just my own personal opinion.
And my comment, Delegate Conway, is I agree with Mr. Redmer that we have no preconceived notion where this would go, but I'm glad that he brought up another example that we use in Maryland, and that is on the health insurance side. And by the way, in that program, we have 3 insurers that write health insurance, individual health insurance, and you get subsidies no matter which insurer you choose. So I'm not saying that's the model we should follow, and I commend Commissioner Grant for keeping all of her options open, as she should. But that's something that you may wish to look at as well.
Right. I was looking at the title of the bill and the way it was being described, and it seems as though they were talking like one insurance company was higher, like than the MAIF is higher than a regular standard insurance company. But I think what the concept is that the insurance overall is just too high. On the other hand, the study will show the actual reasons why the insurance cost is the way it is. For example, you have vehicles that are worth more, so it costs more for the insurance just in case if you have a collision with Tesla or something like that on the road. Is that correct?
That is correct.
Okay. Thank you so very much.
Thank you. Delegate Taylor.
Thank you, Madam Chair. And Al, I think the comment about the list that we can get from MVA, was that your comment?
Yeah, we get a list every week of folks that have been newly identified as being uninsured for at least 60 days.
So does that mean that they've got a new car? So they're young people?
Well,
or potentially are they on the uninsured list? Because
that's a better question for the MVA. And I probably said this last week. Some of these folks aren't going to be permanently uninsured because if somebody sells their car and they don't turn the tags in right away, they're going to get flagged as being uninsured. So some of it is a timing issue, but I mentioned last week it's around 60,000 folks that were on that list in 2025. Certainly a significant number. Well, if we haven't done it, we'll send you a copy of the letter that we send to folks, and we do remind folks that the law requires them to be insured. We encourage them to reach out to their prior carrier. We encourage them to reach out to other carriers, and as a last resort, if they want coverage and they can't get it, they can come to us.
Okay, thank you. That's a very interesting idea. And does MAIF cover horse and carts? Just wondering.
I'm sorry? So that's a great question. So, the reason for the bill we discussed last week is, there's an MIA order that we mentioned that will require us to raise rates between 30 and 53%, even though this is something we've been doing for 40 years. So that creates a sense of urgency for the 7,000 people that are affected by this. Now, if the work group creates recommendations that affect Maryland Auto or Maryland Auto's policyholders in addition to a broader bill, what's going to happen is there will be a bill, and it will adjust our statute like it's probably going to adjust a lot of other statutes. This happens every year in Annapolis, where legislation comes in and modifies something that was done a year or 2 or 3 years before. That's exactly what would happen here. You can fix our problem today, and if we're back here next year to adopt recommendations, our statute, along with other statutes, would be modified to take that into consideration.
Great, thanks.
Thank you.
Delegate Conaway.
Thank you, Chair. Did you say MAFE is getting ready to have another increase?
So we are mandated between now and the end of 2027 to be rate adequate based on the data, the actuarial data from our last rate filing that would result in rate increases of between 30 and 53% in some zip codes, low-income zip codes. And as I mentioned previously, that's about 7,000 policies that would be affected.
That's 2028?
2027.
2027. Thank you.
All righty, seeing no further questions, that concludes our testimony for this panel for House Bill 1583 and concludes the hearing. We're going to move now to Delegate Jones, House Bill 1389. And I'm going to call up what I believe to be your panel. You can correct me if I don't have it right.
Thank you, Chairwoman.
Susan Rubel.
Susan, yes.
Karen McDonald. Lisa Jordan. I'm sorry, not Lisa Jordan yet. Sarada,
Alisa, Susan.
And Alisa
Deju.
Miles.
Deju? Deju?
And
Karen.
Yep,
Yes.
okay.
Are we all here?
And Delegate Jones.
Yes.
Rumor has it, or the word on the street, or however you want to refer to it, has it that this is your very first time ever in the history of your entire life as a delegate in the Judiciary Committee. Is that correct?
Well, Chairwoman, I would say that I have sat with you all this session alone over audits. So I would not count this as my first time in Judiciary, and it was a pleasure to sit with you through a painful audit.
Okay, all right. We'll see, we'll see. All right, well, listen, it's very good to have you, and welcome. Welcome to your panel, and you may begin whenever you're ready.
Well, thank you. I feel the love already. For the record, I am Delegate Dana Jones, representing District 30A in the House of Delegates. Chair Bartlett, Vice Chair Davis, and members of the Judiciary Committee, I am here today to introduce HB 1389, Public Health Female Genital Mutilation. The purpose of this bill is to update and improve Maryland's FGMC law to protect women and girls across our state. Female genital mutilation, or cutting, or FGMC as I will continue to refer to it, is a horrific and violent violation of bodily autonomy and human rights. These horrendous procedures include any partial or total removal of external female genitalia or any other injury of the female genitals, organs, for non-medical reasons. The vast majority of these victims are between the ages of newborn to 15 years old. As of 2023, Maryland has 31,820 women and girls who are either at risk or have already been impacted by female genital mutilation. The health issues that follow are severe and even life-threatening. In 1998, Maryland became a leader when we passed and became one of the first states in the nation to ban FGMC. However, 3 decades later, our current law is now outdated and unable to adequately protect women and girls. HB 1389 closes loopholes, significantly strengthens protections, and requires education to react to this need. According to the World Health Organization, the health risks of FGMC include significant short-term impacts such as trauma, cysts, and hemorrhages. The deeply impactful long-term risks include infertility, an increased risk of childbirth complications, and newborn deaths. 3 times greater risk of depression and anxiety, over 4 times greater chances of experiencing post-traumatic stress disorder, and more. These victims are violated at an age when they don't even understand what is being done to them. And they have to deal with the repercussions for the rest of their lives. However, the physical toll is only part of the battle survivors must face. FGMC can significantly affect a woman's mental health many years after the procedure has been done. Women with FGMC often experience psychological trauma, including anxiety, somatization, depression, post-traumatic stress disorder, and other mood disorders. To effectively stop this abuse, Maryland's current law must be updated. Under current law, perpetrators can avoid all legal consequences in Maryland by taking a victim out of the state to perform the mutilation. This allows the abuse of women and girls to continue. Under HB 1389, this loophole is known as the vacation cutting. This would be closed. 26 states, including Virginia, Pennsylvania, and New York, have already closed this loophole. HB 1389 includes additional measures to strengthen Maryland's law. The first allows victims to pursue a civil action against their abusers. The second maximum penalty for FGMC is increased from 5 years imprisonment and $5,000 to 10 years imprisonment and $10,000 fine. Lastly, it ensures that if a convicted, the perpetrating medical provider must lose their medical license. Finally, research consistently shows that legal reform alone cannot shift the deeply rooted social norms that allow FGMC to persist. Prevention requires education and equipping communities, professionals, and institutions with knowledge necessary to identify risk, intervene early, and respond effectively. To that end, this bill mandates that the Maryland Department of Health develop and disseminate educational resources on FGMC to a broad audience, including healthcare providers, law enforcement, schools, and community-based organizations serving at-risk populations. This approach, well supported by 15 states, and the District of Columbia have already enacted comparable outreach requirements with meaningful results. I want to thank MDH for their engagement on this bill. Lastly, I want to express my sincere appreciation to all of the advocates and survivors who have worked with me to bring this legislation before you today over the last several months. Their amazing bravery is remarkable, and I'm honored to have them place this trust in me to champion this bill. I look forward to working with all of you and them and my amazing cross-file, Senator Love, as well as this committee, to get this bill to the governor's desk. I also want to say that the Women's Caucus has listed this as a priority piece of legislation, and their letter of support should be in your floor system. With that, I respectfully request a favorable report from the committee on HB 1389 and turn it over to my panel.
Okay, thank you.
Good afternoon, Chair Bartlett, Vice Chair Davis, Delegate Jones, thank you so much, what a champion, and members of the committee. My name is Dr. Karen McDonald. I'm a Maryland resident and a tenured associate professor in public health. I've spent the last decade working with survivors of FGMC and the healthcare providers who treat them. In my professional capacity, I have also worked on the federal Stop FGM Act of 2020. I'm here today to express my strong support for HB 1389, which I love the title. It starts with public health, female genital mutilation, and to urge a favorable vote. As you heard, FGM is a severe human rights violation. It results in lifelong physical and psychological trauma, including chronic pain, infections, and complications in childbirth, to name a few. And right now, our region is the second highest prevalence in the country, with more than 30,000 women and girls in Maryland are living as survivors or currently at risk. Now, as you heard, Maryland first addressed this in 1998, but our laws are outdated. HB 1389 is a holistic bill that closes critical gaps by aligning our definition of FGM with the World Health Organization and explicitly recognizing FGM for what it is. It's a form of abuse, and it ensures, this new definition ensures mandatory reporting. It prohibits vacation cutting, as you will hear about, and it mandates community education and outreach, as well as providing survivors the right to civil action right here in Maryland. We have an important opportunity today to close these gaps and provide a comprehensive public health response that protects girls and supports survivors. I fully support this bill and respectfully urge the committee to move HB 1389 forward immediately. Thank you for your time and your consideration.
Chair Bartlett, Vice Chair Davis, and members of the Judiciary Committee. I'm a licensed clinical psychologist. I was born in the United States and grew up in Maryland. I am a survivor of FGMC that took place when I was a child on a brief trip out of the country. My name is Dr. Alyssa Miles, and I've lived with the repercussions of this for the rest of my life. I was once a child who didn't know there was any such thing as FGMC. I was born to parents from a Muslim sect called the Dawoodi Bohras, known for carrying this out. But it was never spoken about at home or at religious gatherings. This practice was secret and hidden. While I was going to kindergarten and first grade, I did not know that my family was looking for someone to do this to me. First, the licensed pediatrician, who was my doctor, was asked, and he said he didn't offer this, but did not say anything to deter the search. Then another doctor, another Maryland doctor, was asked, and he said he may have done this in the past, but it wasn't still offered to parents anymore. I learned these things as an adult. After I had just finished first grade, I was taken on a trip to Pakistan. That summer, something horrible happened that made me never want to go back there. Something I didn't understand or have words for, something I did not ask for or have ever that was never explained to me during or even after, and something I would never allow to happen to me or any human being if I had the choice. But I was 6 years old. I was then brought back to Maryland, my body altered without my permission, and through elementary, middle, and high school, never learned about what happened to me. At college, when I picked up a book out of the bookstore, I learned about FGMC and had it confirmed by a family member that it did happen. I remembered being far from home. When it happened, I didn't know where I was, and I didn't know how to find my way to any place of safety that I knew. I haven't been able to talk about this openly until well into my adulthood. I experienced many of the typical symptoms of post-traumatic stress, but many therapists I went to were unable or unprepared to address this. The psychologist at college said he wasn't able to work with this. Maybe when I got to grad school, I could find someone to help me, and he never spoke with me about it again. After many decades of therapy, much of which I paid for out of pocket, I eventually found help with this trauma around the age of 40. Now, as a psychologist, I treat many survivors of severe trauma. This legislation you now have the potential to advance could help protect and support Maryland's children and survivors who have already endured this violation of their human rights. If this law had existed when I was a child, including the public awareness and access to support, my life would have been very different and full of much less suffering. Thank you.
Thank you, Ms. Miles, for your testimony. Dr. Miles, my apology. If you would like to go next, thank you.
Good afternoon, Chair Bartlett and Vice Chair Davis. Delegate Jones, thank you so much for believing in us, a member of committee. My name is Jesu. I am the senior representative of Ministry of Planning and International Cooperation of Guinea here in the Washington, D.C. And I'm also the Director Executive of Inter-African Committee USA, an organization established in 2006 to raise awareness and educate American and diaspora community about harmful traditional practices, particularly female genital mutilation, CADI, which severely impact the life of women and children. Our guiding principle is education in order to bring a positive change of attitude and capacity building of effective communities. Our mission is the promotion of gender equality, contribution to the improvement of health, status, social, economic, political, human rights, and quality of life of women and children through elimination of harmful traditional practices and the promotion of beneficial, and particularly in the African community worldwide. I would like to share a brief but heartbreaking story about what happened, or what is called vacation cutting, which highlight the urgent need for stronger protection. A survivor of FGM was married to an American man living in Maryland. Her husband had been married twice, but did not have children from those previous marriages. When he met this beautiful woman, they fell in love, and they were blessed with a beautiful girl. Since the family of the lady had not seen her daughter since she was born, she asked if she could take her to visit her relative back home. At first, the man was hesitant, but eventually he agreed, asking her to watch her daughter carefully. Since the relative knew their daughter had not undergone FGM procedure, they forced FGM on her while she was absent. The young girl suffered severe bleeding and tragically lost her life. This story reminds us that girls are especially vulnerable during school break and when they travel to where these practices take place. Now it is time to strengthen Maryland law and send clear message that we will protect women and girls and prevent tragedy from this happening again. So passing this bill favorably will save life. Thank you.
Thank you.
Thank you.
Okay. Good afternoon, and it's an honor to be here. My name is Sarata, and I'm a woman with many hats. I'm a translator for immigration courts, lawyer's office, and many other places. I'm an entrepreneur, also a mentor for Inter-African Committee. Imagine being all dressed up and being so excited to attend a birthday party. I was about 5 years old when I was told that I was going to celebrate a birthday party. I remember sitting in the van with my cousins, full of excitement. However, this wasn't just a birthday party. We arrived by near bush where elderly women were waiting for us. It became clearly to me that, again, this was not going to be a celebration. As we were in line, frightened and confused, as we waited, we could hear the scream of the girls before us. It was my turn. I was pinned down while a woman covered my eyes, and around me, I heard women sing songs welcoming me into womanhood, they call it. In that moment, I experienced the most intensive, traumatizing pain that I have ever felt in my entire life. It was till later in life that I learned that what had happened to me, they had taken away the most sensitive and most sensational part of my body. The trauma did not stop that day. I have endured years of painful menstrual cycles, chronic infections, and significant physical and emotional suffering. During my first year of marriage, I had visited the emergency room for more than 10 times. That was almost every month of the year. Severe depression, blaming myself for failed marriage because I was unable to conceive due to infertility. This experience, which has happened, was not only was done to me when I was a child, but it have lasted and it have lasting affection on my health, my relationship, and my well-being. The pain, the reality that many women that are taught to be silenced, it's a taboo for me to be sitting in front of you all to be speaking about my experience. The impact is lifelong lasting, and I certainly urge for this bill to pass. When you are voting, please think of women like me, those are not here to have their voice heard, and those that also lost their life. Thank you.
My name is Susan Rubel. I'm a Maryland resident, and I spent 35 years working as a prosecutor for the U.S. Department of Justice. Part of my work there involved investigating and prosecuting perpetrators of FGMC using the federal FGMC law. Excuse me. In the United States, FGMC has been a crime since 1996. Maryland was an early leader among states and criminalized the practice 2 years later. Now, 41 states, including DC and Virginia, have laws banning the practice. The question before you is whether Maryland statute, written nearly 3 decades ago, remains sufficient to protect girls given what we now know about the practice. In my opinion, it is not. Although federal law has been strengthened twice since its passage, Maryland's law has not kept pace. First, Congress amended the law to ban vacation cutting, about which you have heard a great deal today. Most state laws also ban transporting a minor out of state for FGMC. Second, Congress expanded the definition of FGMC so it aligns with the World Health Organization's definition, ensuring that the full range of potential conduct is covered. Third, Congress increased the maximum penalty from 5 to 10 years, reflecting the seriousness of the crime. This bill addresses each of those issues and brings Maryland law into line with the federal law. More importantly, because I believe that prosecution is not going to end this practice, the bill's provisions add mandated reporting and education for service providers. This will ensure that girls at risk can be identified before harm occurs. Maryland was an early leader in protecting girls from this practice. Passing this bill will enable it to remain effective in doing so. I urge you to have a favorable vote on HB 1389. Thank you.
Thank you. Thank you, survivors who testified today. Appreciate you sharing your testimony and your advocacy. Members, do we have any questions? Delegate Conaway.
Thank you, Chair. Thank you, Delegate. Thank you, panel, for coming in to testify. Is this what we call female circumcision?
Female genital mutilation. It used to be called female circumcision, but it's called.
The lady said FGMC. What does the C stand for?
Cutting.
Cutting. So it's not circumcision?
Cutting. No.
Okay. And is this a part of a religious practice or?
No, it's not.
Is it something that's similar to what happens to men sometimes or little boys?
No.
Wait a minute, before you shake your head, when you're born and you're at the hospital and they circumcise the male like that, does it ever happen like at birth in the hospital or something?
No, it does not.
So this is something that someone in the family elects to do outside of the religion and outside of the hospital?
That is correct.
Thank you very much.
If I may add, when I testified that I did mention that it was done to me in the bush. This is not with surgical equipment. These are done with things that are not sanitized. So
I'm sorry, I wasn't trying to be sensitive,
I understand.
but I saw in the movie, I believe it was Queen, where they were circumcising the men as a part of their rite of passage to manism or whatever, and sometimes the men would die because of the circumcision. So I'm aware of what you're talking about.
It's okay. It's just that just by 2 minutes, it's really hard for us to sit here and go into really in detail to explain to you guys what have been done to us.
Yes, thank you so very much.
Delegate Stinnett.
Thank you, Madam Chair. Thank you for bringing this bill. You know, I have 2 daughters, so I can't imagine. But I do want to make clear, and I'm glad Delegate had mentioned as far as if it's based on faith-based. You know, I know my daughters grew up Muslim, and, you know, of course, this is, to me, barbaric as far as when something like this happens. So it doesn't, you know, it doesn't entail as far as the Islamic law, because what we go by as far as what is in the Quran in this type of act is not in the Quran. Absolutely. So it's not part of
it's not in the
Islamic law.
Quran.
Correct.
No.
Yeah. So I just wanted to kind of express that. Yeah. But thank you.
Yes.
Thank you.
Delegate McComas.
I don't want to ask any particular questions because it was horrific, what you had to say, and very, very sorry for what you had to go through, and probably still have nightmares. But what I wondered, is there a book or something you would recommend for somebody that doesn't know too much about it, and how long it's happened in human history, and kind of what is the genesis of it? Because I don't want to burden y'all, because it's pretty heavy stuff.
So thank you. That is and I love that you want to learn more, because I think it's really important that raising awareness is our first step. So what we did, we actually have a toolkit for different audiences, for survivors, for healthcare providers, for law enforcement, for people, the general public. And it is very easy. It's fgmtoolkit.gwu.edu.
All right, let's okay, just give me a second.
You got it. Get your pens out.
Okay.
It's fgmtoolkit.gwu.
Wait a minute, wait. What'd you say? Toolkit, okay.
Yep.
GWU, and that'll get me where I need to go.
.edu.
Okay, all right, great.
Yep, it's an evidence-based toolkit that we have case studies, we have videos, we have books, articles that some of our advocates here are featured on, and we work in conjunction with the U.S. Network to End FGM, SAHIO, Global Women Peace Foundation, advocates, survivors, and many different audiences.
Can I ask one other question? With all of the, this area is very, very good, and I mean it in a bad way, about human trafficking. Is that seen in human trafficking at all? Because of the, where we are, 95, the airport, and I just wondering.
Oh, that they're intertwined? There's always intersectionality with different public health issues, but this is not one that.
Okay, all right.
And if I could just address your question about how long has it been going on? The practice predates Christianity.
Okay.
It has been going on since since as long as records have been kept, and it is cultural. It has no basis in religion. It's something that varies by region. Even if you look at different countries, it's not an entire country, but it's different parts of that country. So it's a cultural practice.
Okay. Thank you. Very important bill.
Thank you so much.
Delegate Moreno?
Thank you, Madam Chair. Thank you, panelists, for sharing your stories. As an immigration attorney, I used to handle a lot of these types of cases, and the road to proving asylum was very easy, but the stories themselves were very, very hard, and get emotional thinking about it. But my question is, as to the statute of limitations, was there any discussion to extend it? Because it seems like it ends at 28 years of age, and the issue I see there is that it can take years for somebody to come to terms and potentially going after their own parents and things like that. So was statute of limitation ever considered to extend it?
We did not talk about that.
Susan might? I asked, yeah. No.
We could get back to you on that if that's a concern.
Thank you so much, Delegate.
It just seems like it would be something that you'd want to make longer, just because it's such a,
I do
a
believe
lot of
that
trauma there, so.
There is,
Yeah.
and that was not in discussions when we were updating. We did have 5 different parts that we were updating the bill on. But if you would like to talk offline about that, absolutely. The federal law did not put in statute of limitations, and that wasn't part of our discussions.
Okay, well, that's fine. Thank you.
Thank you so much for the work that you've done in this area as well.
Well, thank you all for being here. Thank you for giving us more information, and as well as sharing your stories. And that concludes this panel for House Bill 1389. Thank you again for your testimony.
Thank you so much, Chairwoman.
Thank you.
Thank you, committee.
And so now I'm going to call up Lisa Jordan.
Good afternoon, Madam Chair, Madam Vice Chair. I'm Lisa Jordan with the Maryland Coalition Against Sexual Assault. We're here in strong support of House Bill 1389. Female genital mutilation and cutting is sexual violence. It is sexual violence. It is not a religious practice. It is it is sexual violence. And all sexual violence leaves emotional scars, but FGMC leaves permanent, irreversible physical scars, and it is designed to restrict women's sexuality. House Bill 1389 is a comprehensive bill. It addresses civil remedies, mandatory reporting, licensure of healthcare professionals, so people who are doing this may not have a professional medical license. It addresses education. It addresses criminal penalties, and if anything, the criminal penalties proposed are too low compared to other sex crimes. Delegate Moreno, that is an excellent suggestion about the statute of limitations. I recall how many years it took us to move the statute of limitations in child sex abuse tort cases from 21 to 28, which is where this bill was, and then more years to move it to 38 before we realized that people often don't sue until they are in their 50s. So this bill is a great bill. You should pass it. But if you are thinking about amendments, look at those penalties, look at the statute of limitations. I want to especially say thank you to the brave witnesses who testified before me, and to Delegate Jones and Senator Love for presenting this really compelling bill. The Maryland Coalition Against Sexual Assault urges a favorable report on House Bill 1389.
Thank you, Ms. Jordan. Members, do we have any questions? Delegate Conaway?
Thank you, Chair. Thank you, panel, for coming in to testify. Do you consider male circumcision to be sexual violence also?
Thank you for the question, Delegate. Delegate, this bill prohibits a clitorectomy, partial or total removal of the clitoris, pubis, or clitoral hood, and there are more and even more graphic things that I could say here, but I won't traumatize the committee. It's on page 4 of the bill. So I would say, Delegate, that the analogy would be if your penis were removed when you were a small child, not a circumcision.
No.
So no, I do not think that circumcision is the right analogy.
Thing, right? It's not the same thing.
It is not the same.
No, it's not. It's the removal of a penis is not the same thing as the external removal of parts. Would you agree with that?
Going on page 4, excision or partial or total removal with or without the excision of the clitoris, the laboria minor, with or without the removal of the laboria majora, infibulation, narrowing of the vaginal opening, with or without the excision of the clitoris, or any other procedure harmful to the external female genitalia, including pricking, piercing, incising, scraping, cauterizing the genital area. Delegate, in my personal opinion and my professional opinion, I do think that the analogy is apt to think about real traumatization to genitals, and that is what this bill is designed to stop. And I would respectfully say that it really minimizes the experience of people who have suffered the FGMC to compare it to male circumcision.
Okay, I was just trying to get your professional opinion if it was the same. Thank you.
Thank you. I appreciate that.
Members, do we have any other questions? Seeing none, that concludes this panel as well as the bill hearing for House Bill 1389. We're going to move on to Delegate Smith, and this would be House Bill 1406.
Thank you, Madam Chair, Madam Vice Chair, and the hardworking and honorable members of the Judiciary Committee. For the record, I am Delegate Stephanie Smith, here to present House Bill 1406. Now, this bill, I'm offering a sponsor amendment to essentially reimagine the entire bill to become a work group. And that work group would study self-defense mitigation and fairness when trauma victims are criminally charged for acts against abusers. So as proposed under this amendment, this bill would examine the current law as it pertains to battered spouse syndrome and the judicial proceedings article. However, that statute reflects a much narrower understanding of trauma than what modern research and survivor experiences have shown us. Today, we know that survivors of domestic violence, sexual assault, and human trafficking, coercive exploitation, and child abuse may experience trauma that affects how they perceive danger and respond to abuse. In some tragic cases, survivors may be criminally charged after acting against the very person who harmed them. House Bill 1406 takes a careful and deliberate approach to examining whether our laws properly reflect this modern understanding of trauma and fairness in the criminal justice system. The bill establishes a diverse work group that includes legislators, prosecutors, the Public Defender's Office, survivor advocacy organizations, legal experts, and a survivor who has experienced this issue firsthand. The work group will examine how Maryland's laws related to self-defense, partial self-defense, and trauma-informed evidence operate in cases where survivors are charged for acts against their abusers. Specifically, the work group will review Statute 10-916, which addresses battered spouse syndrome, and develop recommendations on whether the law should be updated or expanded to reflect modern trauma, science, and the experience of survivors. Importantly, this legislation does not change the law today. Instead, it creates a structured process for experts, practitioners, and survivors to come together and provide thoughtful policy recommendations to the General Assembly. This bill recognizes that cases involving trauma and abuse are complex and deserve careful study so that our laws balance fairness, accountability, and justice. For these reasons, I respectfully urge a favorable report on House Bill 1406 as amended during this presentation. Thank you, Madam Chair.
Thank you.
Madam Vice Chair, members of the committee, I'm Lisa Jordan with the Maryland Coalition Against Sexual Assault. We're here in strong support of House Bill 1406. Delegate Smith, thank you so much for your leadership on this issue. As many of you know, we have often talked about solutions post-conviction. We've had bills that talk about what happens when an abused person is convicted and what do we do. We've had bills that talk about what happens when we have a juvenile who is in juvenile adult court and it comes out during trial that they have been abused. And one of the concerns the Maryland Coalition Against Sexual Assault has repeatedly brought forward to this committee is that after conviction is too late. We should have juries and fact finders know about the experience of victims of trauma during the trial. So when I have a young woman who is sexually abused by her uncle and she at age 17 hurts him on the couch, that the jury should be able to have that evidence. We're not suggesting that vigilantism is the right thing at all, but we are suggesting that just as we allow this evidence in for battered spouses under the Battered Spouses Syndrome statute, we should expand this law, modernize this law so it assists child victims of sexual abuse, so it assists victims of physical abuse, so it assists victims of trafficking. And this is a longer conversation. It needs to talk about when is mitigation appropriate, when is this actual self-defense. We already do this, again, for battered spouses who either murder or commit first-degree assault against their abuser. But we need to look at that in a more comprehensive way in case it's second-degree assault or some other crime. So this really is an effort to bring everyone to the table, people who may not always want to be at the table together, but make sure that they talk about this issue and come up with a solution that is survivor-centered. For those reasons, we support House Bill 1406 with the sponsor amendments.
Indeed. Christopher Dews, representing Out for Justice. So firmly in support of the legislation, firmly in support of the work group as well. I just wanted to highlight, when we were talking to our members about this, just highlighting that human trafficking, as she mentioned, is a very large contingency of criminalized survivors. And so, of course, bringing on this work group and having the conversation around that also, we just want to make sure that gets highlighted. And I would say so many more things. There's just been so many studies on this. I'm just glad that this conversation is happening. And so Out for Justice is firmly in support. We'd love to see progress on nuancing how the sentencing of this specific population is handled. So with that, I urge a favorable report. Thank you.
Thank you. Colleagues, questions? Delegate Cardin.
Thank you very much. Thank you very much, Delegate Smith. I actually really like this bill. So far, no, it's. I think it's good. I think the conversation needs to happen, and the work group will come up with really interesting. We'll bring together the research. Here's the scenario. I guess this is maybe for Ms. Jordan, but maybe not. You can decide. So we've dealt with boys who have been sexually abused, and then they commit violent acts as either young adults or as older juveniles. Should this information also be used as ways to mitigate? I'm assuming that's what it's the idea is to mitigate the outcomes for these abused people. So you have a 17-year-old boy who sexually abuses a young woman after, and evidence comes out that he was consistently done that to him as a young child. This would go both ways. I'm just making sure that we understand, and Ms. Jordan, because usually we're talking about the abuse of, or mitigating for women who act out. But in this case, it could be for both sexes. Is that correct?
Actually, Delegate, I hope I'm always gender neutral in my advocacy, and we do represent many male survivors. You know, this bill is a bill that starts with the idea of self-defense. I think your hypothetical is probably the next work group, but I absolutely do not dispute that that is an important issue. But this is the pre-conviction phase. So it's especially a response to the issue of timing. As you know from your practice, if you're arguing self-defense, you have to have an imminent threat. And the problem is that for many survivors of abuse, the perception of imminence is different. And what may be eminent to a judge or a jury, kind of there's a gun to their head, is not necessarily what that victim of abuse is experiencing. So they need like a little bit more time because their experience is this is still self-defense, even though the guy was asleep on the couch.
That's why I think this is a great idea. I really appreciate the legislation. And I think that the perspective sometimes of a jury or of a judge is far different than that of a victim or that of a defendant. And so we need to make sure that we understand that and we explain that. So thank you.
Thank you for your question.
Thank you.
Okay, any other questions? Seeing none, that concludes the favorable and the favorable with amendment panel. And that concludes the testimony on HB 1406. Thank you so much. Okay. Next we have Delegate Moreno. Would you like me to call the panel, sir? Yes. Sebastian Brown, Nina Amador Hernandez, and then two virtual witnesses, and Eric Lopez. Okay, let me know if Eric Lopez shows up. Do we have? There she is. Thank you. You may proceed.
All right. Thank you, Madam Chair Davis. Good afternoon, members of the Judiciary Committee. For the record, I am Delegate Gabriel Moreno, and I'm here to ask for a favorable report on House Bill 1415, Law Enforcement Identification Requirements. At its core, the bill is about a simple and fundamental principle. When the state grants someone the authority to detain, arrest, and use force against another person, the public has a right to know who is exercising that power. HB 1415 takes a proactive step in preventing the blurred lines between legitimate law enforcement officers and those who might impersonate them. The bill requires all law enforcement personnel operating in the state of Maryland to display visible identification while performing their duties in the field. The legislation directs the Maryland Police Training and Standard Commission to establish statewide policy requiring body-worn identification for active duty law enforcement personnel. The policy must address clear display standards, including size, placement, contrast, and legibility. Identification would include the officer's last name, badge number, and the department or agency they represent. In addition, the bill requires law enforcement officers upon request to disclose their name, badge number, and agency they serve. These requirements apply broadly to all personnel exercising police authority in Maryland, including local, state, and federal officers, including contractual officers. The bill has a provision exempting undercover officers from displaying or disclosing their identity. HB 1415 is important for 3 key reasons. First, true accountability. Public servants cannot be held accountable if they operate anonymously. Officers acting in good faith have no reason to conceal their identity. By removing this anonymity, the bill reinforces that those entrusted with public authority remain responsible for how they use it. To ensure the law has a real effect, the bill allows for legal action when an officer willfully conceals their identity with appropriate consequences determined by a judge based on the circumstances. Second, universal fairness. The bill establishes a clear and universal standard of transparency for everyone exercising police powers in the state. No individual or agency should be exempt from basic expectation that those who wield government authority identify themselves. Third, public trust and safety. When armed officials operate without visible identification, it creates confusion, fear, and unnecessary risk for both the public, the officers themselves, and other law enforcement agencies. Transparency helps reduce that uncertainty and strengthens trust between communities and law enforcement. Maryland has the opportunity to set a clear and reasonable standard, one that protects civil rights while allowing officers to carry out their duties effectively. There is no legitimate justification for routine law enforcement activity to occur under a veil of anonymity, and the state must act to prevent vigilante enforcement masquerading as legitimate policing. For these reasons, I urge the committee to issue a favorable report, and I stand ready for questions.
Thank you. Delegate Moreno, I did not add Edith Henson to your panel. Is she here?
She should be virtual.
Got it.
No.
Okay, thank you. Who would like to go next?
Good afternoon, Madam Vice Chair Davis, members of the committee. My name is Ninfa Amador Hernandez, and I'm a policy manager with We Are CASA. We Are CASA is a national powerhouse supporting immigrant, Black, Indigenous, and Afro-descendant communities and building and supporting them during this time. We are here in strong support of HB 1415. Trust between communities and law enforcement is paramount to public safety. When residents can clearly identify who is exercising law enforcement authority, it strengthens transparency, accountability, and most importantly, trust between communities and those who are sworn to protect them. When someone interacts with law enforcement, they should clearly be able to see that law enforcement or that individual is a member of a law enforcement agency and what that agency is. Clear identification helps prevent impersonation, ensures accountability, and protects both residents and officers. We see local progress on this issue being made in our counties, in particular Prince George's and Montgomery County, where they have established clear policies in naming their law enforcement agents. This is a standard that we need at a statewide level, and that's why we're here before you for your support. When residents trust that officers are clearly identified and accountable, they are more likely to report crimes and cooperate with investigations and seek help when they need it. Particularly during this time when we are seeing communities across our very own state and this country deeply troubled by incidents where masked individuals are detaining people in broad daylight without clearly identifying themselves. I ask you, when people are masked and taking others off the street, is this not indistinguishable from kidnapping? We should not have this in our streets. No one should have to wonder whether an individual taking someone off the street is a legitimate law enforcement officer of whatever rank, state, local, or federal. We should have a clear knowledge of what this is. This kind of enforcement creates fear and chaos, and I know that we have seen it, and I know that immigrant Marylanders have felt it, even in your very own communities as well. And that's why we are here asking you to support for this bill, and we urge a favorable report. Thank you.
Thank you. Mr. Franklin?
Good afternoon, Chair Bartlett, members of the committee. Thanks for having me. My name is Neil Franklin, a 34-year law enforcement veteran, retired major of the Maryland State Police and past executive director of the Law Enforcement Action Partnership. whom I'm also representing today. 1 week ago, I testified in the U.S. District Court of Maryland as a policing expert on a civil matter regarding the behavior of a Baltimore County police officer interacting with a Maryland resident. The plaintiff stopped his car in a parking lot where the officer was conducting a traffic stop. Once he concluded the stop, he approached the plaintiff with his gun drawn, demanding identification. The plaintiff, with his hands in full display out of the driver's window, just asked, "Who are you? Why are you bothering me?" With the officer's raincoat covering his badge and nameplate, the officer continued barking commands, absent identifying himself or explaining the reason for detaining the plaintiff. Even though it's clearly outlined in Baltimore County Police Department's operation manual that an officer will identify themselves and communicate the reason for the encounter, he failed to do so. This policy is also tied to the de-escalation policy under the use of force policy. If he had followed his policy, the plaintiff most likely would have calmed down, and there's a very good chance that he would not have been roughed up and arrested, as what happened. By the way, the charges were quickly dismissed. Identifying oneself is the first step in de-escalation, a critical tactic taught to every Maryland police officer. And HB 1415 enhances Maryland's 2021 Police Accountability Act. Officers not identifying themselves is a very common occurrence in the state of Maryland that is seldom administratively enforced by the responsible agency, so accountability is paramount. Please read my written testimony for more details and give HB 1415 a favorable report. Thank you very much.
I'm going to move to back to Mr. Brown for a second, Sebastian Brown. If you could go ahead and testify, and then we'll go back online in just a moment.
Thank you. Good afternoon, Chair Bartlett, Vice Chair Davis, members of the committee. My name is Sebastian Brown, Advocacy Strategist at the ACLU of Maryland. By requiring all law enforcement in Maryland to identify themselves, HB 1415 is a critical, logical companion bill to HB 155, which seeks to prohibit law enforcement in Maryland from concealing their identity with masks. Before our eyes, the Trump administration is ordering masked, unidentified federal law enforcement agents and military troops into American communities, building a secret national policing force in an effort to sow fear, silence opposition, and turn the communities we love into places where people feel afraid to even leave their homes. This is not a hypothetical. In Maryland in 2025, ICE's own data shows that of the over 4,000 people who were indiscriminately arrested, separated from their families, 2 of every 3 were arrested in the community by these unidentified agents outside courthouses, schools, workplaces. These agents often do not display their names or badge numbers, refuse to show warrants, and conceal their identities behind face coverings while roaming our streets in unmarked vans and snatching folks off the street. This undermines democratic norms and erodes trust between communities and those sworn to protect them. We're already seeing the fear this creates in our communities. For instance, last fall in Wycomico County, where hundreds of community members attended county council meetings to oppose 287G and local ICE cooperation, countless Haitian, Mexican-American community members, including citizens, also spoke about seeing masked agents and unidentified agents living with constant uncertainty and paranoia, wondering whether the people taking their neighbors were federal agents, or specifically bounty hunters or vigilantes, not knowing because their identities were hidden. When people fear law enforcement, which many impacted communities already do, they're less likely to report crimes, seek help, or cooperate with police, making us all less safe. A true democracy is one where people feel safe in their communities and able to live with dignity without fear of government retaliation. For these reasons, the ACLU of Maryland respectfully urges a favorable report. Thank you.
Thank you. And you're not Eric Lopez, I don't think, but if you could.
Not Eric Lopez. I am his colleague, Edith Henson.
Okay, great. Whenever you're ready, please, Ms. Henson.
Honorable Chair Bartlett and members of the committee. My name is Edith Henson, and I'm a program director at the Amica Center for Immigrant Rights. Amica Center proudly co-sponsors HB 1415 and requests the committee to provide a favorable report. Amica Center is a nonprofit focused on providing legal services to Marylanders detained by ICE. The stories that we hear over and over again about the circumstances of people's detainment are quite frankly disturbing, and today I will share just one. In late June, I received a call that my former client had disappeared. Alexander has a traumatic brain injury and he's an amputee. He lost his leg after being kidnapped and electrocuted by cartels in Mexico. He got into his car one morning to go to his job at Amazon, but was quickly surrounded by men in masks and civilian clothing, no IDs or badges, and with guns. They broke his window and pulled him onto the cement. They never asked his name, and when he asked to know what was going on, they screamed at him to, quote, shut the F up, that they were police and that they were taking him downtown for questioning. He was physically brutalized and had flashbacks to his cartel kidnapping before being taken to the Baltimore hold room. These men were not our local police, and this was not for questioning. Alexander never spoke with anyone the entire time he was at the BHR, and instead, just days later, he found himself at an ICE prison camp in South Texas, being walked across the border for deportation to Mexico, a place where a judge had ordered he could never be deported. It was only through luck and my dogged insistence that he was literally pulled out of the line because ICE had, quote, made a mistake. But this was no mistake. Alexander had reasonably believed he would be kidnapped, and what would have happened if he had tried to run? Would ICE shoot him? Would they kill him? Tactics that we've seen used on the streets of the United States. Why can ICE pretend to be local police and get away with it? That is not fair to our local officers, and it is not fair to us. Alexander's story is the norm, not the exception. All Marylanders deserve to know the identities of the individuals protecting and policing them, and should never be forced to believe they're being taken in just for questioning, only to wind up in another country just days later. The Amicus Center urges the committee to provide a favorable report on HB 1415.
Thank you. Members, do we have any questions? Delegate Erica?
Thank you, Madam Chair. I'm sorry for the case that we just heard. Obviously, that sounds like a horrible experience. My question, Delegate, is there is some opposition here from both the state police and I believe the chiefs and sheriffs. But what the state police says is that under the 2021 Police Accountability Bill, they already require name tags and identification markers in accordance with that law. So that's my kind of first question. I'll toss that one to you. But also my second question is if there's a carve out, and I was reading through the bill and I didn't see it yet. Is there a carve out for undercover operations?
Yes, for SWAT operations and undercover,
so,
yes.
Okay, so because I mean, obviously, look, as a wear and carry permit holder who's always armed, if somebody comes up to my car, does not tell me they're a police officer and tries to take me at gunpoint, it's going to be a firefight. So I can see why there could be some serious concern here, but I want to make sure we are weighing, common police practices that we use in Maryland that our 2021 bill have already covered, and that we're not sort of messing with our undercover officers when they're doing legitimate police work, things like that.
Yeah, I mean, to your last point, I mean, in the situation where you as a civilian are approached by unmasked or masked, allegedly quote unquote officers, you would react a certain way. And the same thing with other law enforcement. If, for example, Annapolis police show up to the scene where somebody potentially is getting kidnapped, and those individuals are masked and they're, they say they're ICE, but then come to find out that they're not, or figure out during the incident, there could be a shootout, there could be some type of violence. So this not only protects the public, but also protects other law enforcement officers. And that's the way I view it. To answer your first question, I think I'll defer to Neil as far as talking about the Maryland Police Accountability Act of 2021, which is something that I remember the reading the Fraternal Order of Police opposed, and others also opposed that. So there was some pushback even then. Yeah. But as you heard from Neil earlier, talking about how the police in Maryland aren't actually, following it. So
that his officer in that case, I think there was and I guess was able to litigate because there was a failure. So in my mind, I'm thinking, okay, we do have the law. It wasn't followed. There's, a private right of action. Such a case.
The idea behind the 1415, it's consistent with the regulations that are set forth under the Maryland Police Accountability, but in effect also codifies some loose ends that also see. So, some people might see this as specifically targeting the ICE, but as the more I've looked into this, it looks like every level of enforcement from local, state, and federal need.
And then my
need this
other
type-
question would be, like, we keep passing these laws with the theory that we can impact the federal government, but they actually don't have to listen to us, I don't believe. Like, at least from their perspective, they're like, pass all the laws you want, we're federal, and we simply won't follow them. Is that true? Do you see this ending up in litigation? I mean, I guess it sort of remains to be seen, but.
It does remain to be seen. I think it's something that we have to address. Us as an independent state, when it comes to like our state sovereignty, when people come into our state, whether it's civilians or, for example, federal law enforcement coming into our state, they have to abide by certain laws and because we have the right to protect our own residents.
Right. I mean, we can try, but the question will be, does the federal courts uphold that? I guess we'll just litigate it like we do everything.
Yeah, I mean, here
Like
we
do everything.
legislate, they litigate outside of these four walls.
Yeah, yeah, okay.
Yeah. But if, Neil,
yeah,
if you wanted to
sure.
address, I don't know if you want to restate your question to Neil. Did you?
Really, I was just wondering if the 2021 laws we passed that have been referenced by the state police actually do already cover this requirement. It says here that they're required already to, what does it say here? Purchase and implement required name tags and identification markers. Is that not true?
I don't think it, from the way I understand it, I don't think it references displaying them and how they would be displayed on the actual police officer. I know that this particular bill would enhance the Police Accountability Act as it relates to de-escalation, because this is the first step in de-escalating an encounter, letting the person know who you are, clearly identified, and clear communication. That puts the person at ease. So I don't think it's spelled out that way. I'll go back and look at the Accountability Act, but I did not see that in there where it specifically talks about and requires that police officer to have it clearly displayed on their uniform along with their badge. So I think that's very important. And I also think this is very important. All you have to do is think back to the Gun Trace Task Force in Baltimore, where you had a team of police officers committing crimes, doing home invasions, and they would not wear ID. And so the good thing about this bill, it talks about intent as well. So I think this is just a great toolbox, and I agree with you on the Fed side. Let the courts decide, but we need a tool. And we don't want to wait till after the fact, till after something happens, at least have this tool in our toolbox to be able to use it if we have a bad encounter with federal authorities.
Are there any other states that have passed requirements for displaying police insignia? Has anybody actually already done this? Do we have any?
I believe California has already done so.
So just the one, though? That's okay.
I'm not.
All right.
There might be others.
But I would add Montgomery County has done this, so Maryland local jurisdictions.
Okay, so the county has their own policy in place, and is it being followed well? I mean, are we seeing violations in that county too?
It was recently implemented, so we would have to get back to it.
And I think PG County as well is kind of in the process, but it's an implementation phase. So for this bill, it's statewide, while we're seeing Montgomery County and PG County kind of moving a little quicker, I guess, than the state legislature.
Okay, I mean, I can certainly see, why in that situation there could be some serious concerns for safety for the officers themselves if somebody does not know, especially somebody with PTSD because they've already been abducted. That could have ended very differently for the officers, and so yeah. All right, thank you.
Yeah, thank you.
Thank you. Delegate Allen.
Thank you, Madam Chair. Thank you, Delegate, and thank you, panel, for being here. My question is to Mr. Franklin, and it's kind of a follow-up to Delegate Erican's question. Based on the scenario or the example you provided with the officer in the raincoat, do you know if in that particular situation that officer was ultimately identified? They were charged with a crime, correct? So the officer was identified?
The officer at the scene never identified himself to the plaintiff, to the citizen. As a matter of fact, they were there for at least 15, 20 minutes when other officers arrived. no one and I watched all the body cam, no one verbally identified themselves to the plaintiff. And they never even told him what he was being charged with until they got him to the precinct there in Cockeysville. So, you know, this is a situation where it was a clear, and this is where it turned out, it was a clear cover-up. They were covering their butts, and none of the officers identified themselves to the plaintiff until later at the precinct. And my point was, if they had done so, if that initial officer had done so right at the beginning, I'm sure that person, that individual would have begun to calm down. Okay, I know you are, you gave me your name, I asked your name, and he asked for his name at least 6 times. 6 times. And he never gave it to him, and it wasn't displayed because his raincoat was covering it up, and he didn't have his name tag on his raincoat, even though there's a place for it.
But my question, ultimately, were the officers identified? I know
yes.
After the fact. So he does have he or she, I don't know if it's a he or she, does have an opportunity for recourse against their actions. Is that correct?
Oh, absolutely.
Okay, so that
Yes.
was part of my question. My second part of my question is I always think about unintended consequences of bills. So using the raincoat analogy, I just want you to kind of walk through something with me to see if this would be applicable. So I use the raincoat analogy, Maryland State Police, okay, when they're investigating traffic accidents on a normal basis, I've seen for many, many years, they typically wear raincoats that may not have name tags or insignias on. And it would be knowingly they are investigating traffic accidents. Now, no one's asking them for their identification in those scenarios. My question is, if you're in a driving rainstorm and you're handling an accident, would this bill technically, under those circumstances, could they be held liable for a violation of this section for a misdemeanor crime? Because in that scenario, they didn't prominently have one on a raincoat while investigating a traffic accident in a driving rainstorm.
But I believe that this bill requires intent. In that kind of situation, there's no intent. He's getting out, grabs his raincoat, puts it on.
He knowingly and willfully got out of his vehicle and didn't put a name tag or something on a raincoat.
I think the intent is to not display or not let someone know. I'm actually putting on this raincoat because I don't want them to see my name tag. Not that I'm getting out my car to shield myself from rain. That's what intent means in this particular bill.
I'm just trying to worry about unintended consequences, what could happen. That's my only concern. That's my problem, or my concern. Thank you.
Members, any further questions? Seeing none, that excuses this panel, and we're going to move on to Chief Yates, unfavorable. Okay, Chief, whenever you're ready.
All right. Good afternoon again, Chair Bartlett and committee members. Once again, I'm Steve Yates, President of the Maryland Chiefs Association here, representing Maryland Chiefs and Maryland Sheriffs Association. And we oppose House Bill 1415. First, Maryland law enforcement agencies already have policies governing officers under previous stated the House Bill 670 that was passed in July 1st of 22. And it does say in there that you have to display your name and badge number, which if you can clearly see on my dress blouse today, I have to wear it because I'm in uniform. I have to have this displayed at all times. Because policies already exist, House Bill 1415 would require agencies to redesign or replace uniforms with identification systems that are already in compliance with current standards. Not only that, we'd have 2 different standards to identify ourselves with. And if we gotta display both of them or pick one, or we could be in violation of a law or be charged criminally if we don't have the right one. It creates so much confusion, it's just imaginable. The bill also creates serious legal exposure for officers and agencies by attaching criminal and civil penalties for potential violations. Officers are already subject to internal investigations and administrative discipline if they violate House Bill 670. The bill could also impact out-of-state officers assisting Maryland agencies. Once again, I'm up in Cecil County. We deal with Delaware and Pennsylvania officers weekly, usually one or the other. For these reasons, we believe existing policies already provide appropriate oversight and accountability for regarding officer identification. House Bill 1415 will create unnecessary costs, legal uncertainty, and overlapping penalties without improving current practices. We already have the practice in place to identify ourselves. For these reasons, the Maryland Chiefs Association, Maryland Sheriffs Association respectfully ask for an unfavorable report on House Bill 1415. And I'll take any questions from the committee.
Thank you, Chief. Just two quick questions, and I'll go to Delegate Cardin. So currently, are there administrative consequences for not properly identifying?
Yes, there are. It's a referral to the PAB with, if the officer is found to violate it, there's charging by the ACC. Yeah,
And
that's.
Are there any criminal penalties associated with failure to identify?
No, they're administrative.
Okay. Delegate Cardin?
Question number one. Question number two.
Yes.
If a Delaware or Pennsylvania officer don't comply with Maryland standards, what happens to them?
According to the new law, they could be charged criminally.
I understand, but what happens to them now if they don't? So if you're working with a Delaware police officer who comes across state lines, is in Maryland, doesn't identify themselves, and somebody is harmed, what are the consequences to that officer?
I'm sure there would be an investigation. Are you talking about them not having the identity?
Can Maryland do anything at this point to try and police that person? No pun intended.
Are you asking if the out-of-state officer would get in trouble? Is that what you're?
Right. Would the out-of-state?
Yeah, most certainly. If something would.
By a Maryland, some sort of Maryland tribunal. At all?
I don't know. It's administrative penalty under the PAB and the ACC now. So.
Okay.
And that wouldn't extend to.
I'm going to stop. And if they did if there was some sort of administrative penalties that were associated, let me I'll step back. You've already answered that. The last question was about the bill itself. It specifies that you have to both demonstrate and verbally, if asked, verbally say who you are and who you represent. That's the way the bill is drafted right now.
That's what House Bill 670 does too. You have to verbally say who you are.
That's what the bill. That's what
and it has to display. They're the same thing.
If the bill was amended to say that you either had to show it or say it, would you still be opposed?
I'd have to see how it would be written. It may be more confusing.
Okay. Thank you. Thank you, Madam.
And so we are just on the same page, because I was going to ask, isn't it true that an officer from Delaware who is helping officers in Maryland has to obey Maryland law? And the answer is?
Not with this, because it's through the ACC, and that
no,
doesn't.
they do. The answer is yes. So if an officer is here from another state helping officers in Maryland, they have to abide by Maryland law. And so that's just fact.
Sorry, I thought you were going off the 670. Sorry.
No, yep. Okay, so the other thing is, I wanted to ask you, would you be surprised to know that we had a contracted security guard down in our garage, and he was standing there, I don't know, it was 28-16, something crazy cold. And he didn't have on anything but his uniform or some sweater that had, that he was a security guard. And I said, "Where's your coat?" And he said, "They made me, I can't wear it because it is not the correct coat." And the coat that he had was his own personal coat that had no identification on it. And so for the benefit of us in the General Assembly so that we would have our reassurance and know that the individual standing there is actually someone who's contracted by the security company. He had to stand out there in the cold in just his uniform. Would you be surprised to learn that happened?
No.
Right, because our officers, and by no doubt, our officers go to extreme, but the point of this particular bill seems to be that it's something to give other people some level of reassurance and some level of trust. Isn't that so?
It is, but House Bill 670 already has that. It has 5 lines in there.
But it doesn't have any criminal charges, right?
It does not, no.
Okay. Okay. Delegate Valentine?
Thank you, Madam Chair, and thank you, Chief, for being here. I did have a question with the out-of-state component that you talked about. And that was, is there a circumstance with your agency that you would have agencies from Delaware, Pennsylvania, or any other state for that matter, that would come into your jurisdiction or into Cecil County and not already be notifying the Sheriff's Office, MSP, or your agency? So they're not going to be there by themselves to begin with, correct? They would be with your agency or one of your allied agencies?
Yes.
So identification, okay. That's what I wanted to make sure. So they're not coming in without notifying anyone?
Yes, that's correct.
Thank you.
Delegate Moreno?
Would you agree that all law enforcement agencies should have clear identifiers?
Yes.
And if this bill was to pass and the law enforcement agencies followed 670, the old one, and this bill, then there would be no violations across the board, correct?
There should be no violations now because you have to display your name
and your
ID number.
If you were to answer my question, if 670 is on the books and then mine was to pass and all law enforcement officers identify themselves properly, there would be no issue, correct?
In a perfect world, but there'll always be some type of issue. So.
Okay.
Okay, members, do we have any other questions? Seeing none, thank you, Chief, for being here. Is this your last bill for the day?
It is, yes.
All right,
Thank
have
you.
a great evening.
You too, have a good evening,
Thank you
Madam
for
Chair.
waiting around. Delegate Moon, House Bill 907. Oh, guess I should get the phone. Okay, I'm going to call up Brian Shefferman and James Johnston. James Johnston, I think, is virtual.
And Christine DeFore.
Okay, and if Mr. Fore, you can come on up. If that's acceptable with Leader Moon, then that's acceptable with me.
All right, everybody. House Bill 907. This is a repeat bill. Actually, we've had a version of this for many years. Former Chair Valerio and Vice Chair Dumais, in a bipartisan bill with Deb Ray, had a version of this bill many years ago. Basically, it's trying to create more gradations in the state's assault law. So just for your brief reminder, the assault law in Maryland is pretty sweeping and harsh on paper. We have first-degree assault, which is the serious assault, but that requires a serious physical harm, use of a firearm, strangulation, something of that nature, and that therefore comes with a maximum of 25 years, and it's a felony. But if you do anything else, you poke someone, you spit on them, you give them a little bit of a shoulder check, or you conduct a serious assault that's, again, short of a gun, strangulation, or whatever. Everything else gets lumped together in second-degree assault, which is a misdemeanor, but it carries up to 10 years. So this bill attempts to create a third category, third-degree assault, to split out the more minor cases into a maximum 90-day penalty, and that would just be your unwanted touching and what have you. The bill also attempts to remove some of the domestically related cases out of this third-degree orbit, so it really is more of the frivolous cases. I see in the testimony that appears not to have worked because some of those groups are not satisfied, but I will point you to the language in the Maryland Network Against Domestic Violence. They have proposed amendment language that would further narrow out the domestically related cases, and I'm certainly open to continuing that conversation, especially to get something moving on this topic. So why do we care about this and mixing all these different types of cases together? Well, there are a lot of collateral consequences for being convicted of a crime that might carry up to a 10-year sentence, especially if what actually happened was pretty minor. For one, in Maryland, if you're trying to be a nurse, that kind of a conviction is automatically going to flag you for additional review, where they're going to look at whether you're fit to be a nurse based on that conviction. Same thing might happen for housing or other benefits that you're applying for. If you're a firearm owner, I'm not, certainly you're going to have your firearm rights suspended as a result of a conviction like this. And if you're an immigrant, you may have status, actually, but you might have that status in jeopardy on the basis of a second-degree assault conviction, again, just on the basis that that conviction might have carried 10 years. So this bill's cross-filed in the Senate by Chair Smith, so there is a very serious effort to get a conversation going here. It might not be perfect, but again, that's what we're trying to do, and I'm happy to turn it over to my panel.
Thank you. Thank you. Madam Chairman, my name is Brian Shefferman. I am the current president of the Maryland Criminal Defense Attorneys Association. Under Maryland criminal law, maximum penalties are set normally to fit the severity of the crime. I think you can see this throughout the code. Theft is a good example. You have, the lower the amount of the value of the property that was stolen, the lower the penalty is, and it goes, and it's graded up to going up to over $100,000 to as low as under $100 when the penalty is only 30 days or 60 days. Forgive me if I have that, if I'm mistaken about that. But this offense of misdemeanor second-degree assault is an exception to the normal rule in Maryland. Maryland is a rather wild outlier when it comes to this offense. You can do a survey of every state in the country, and Maryland stands out for the penalty for misdemeanor assault. No other state even comes close. So this House Bill 907, it should be remembered, gives prosecutors discretion to dispose of an assault charge at this lower level called third-degree assault when the prosecutor is satisfied that it is a relatively minor offense and it does not involve domestic violence, sexual offense of any kind, and it therefore empowers the prosecutor to dispose of the case in district court. It is not jury demandable, so it will provide a lot more efficiency, and we would urge the committee to report this bill out favorably.
Thank you. Good afternoon, Madam Chairwoman, Vice Chairwoman, members of the committee. I come before you as the immediate past president of the Maryland Criminal Defense Bar Association, and we urge a favorable report to HB 907. So what are we trying to do with this bill? We're trying to eliminate the pushing, the shoving, the tapping between neighbors, between a bar fight that doesn't end up in an injury, and that there's no intent to cause serious physical injury. This is the minor assaultive or battery behavior. Battery is the offensive touching that's unwanted and not legally justified. I had a case that I might have talked to you about last year where I had an individual with severe intellectual disabilities at his program, and he wanted to throw away his lunch, and his peer-to-peer caseworker was not happy about that. So he threw his styrofoam cup at her, or plate. It was a styrofoam. She went and took a citizen-generated complaint and filed assault charges against him. I can't tell you the anxiety that this man in his 20s, perhaps, but intellectual ability of a child, the stress of facing 10 years in jail, because he thought he was going to jail. He thought you're charged, you go to jail. Fortunately, my advocacy with the prosecutors, and they're looking at this case and the nature of the assault and the contact, resulted in null pros or dismissal. I want to expand on Delegate Moon's Second Amendment impact. I come from the Eastern Shore now, having moved from Montgomery County, and my husband hunts, my friends hunt, and because second-degree assault is classified in the public safety article as a crime of violence, it automatically precludes you from getting any type of firearm. So someone who pushes his neighbor and gets convicted, whatever, he loses all rights to hunt. We think that's somewhat extreme, and I hope our supporters of the Second Amendment would find that agreeable. Finally, the non-citizen, with that, thank you. The non-citizen impact is great because, let me just, under federal immigration law, the classification of offenses as misdemeanors or felonies is primarily based on the maximum sentence. Despite this being a misdemeanor, because it carries such a loaded sentence of 10 years, it could have a severe collateral consequence on people pending their immigration status. Thank you.
Thank you. Mr. Johnston?
Thank you very much, Madam Chair, members of the committee. We want to thank the sponsor very much for bringing this bill. I am a co-chair of the Legislative Committee at the Maryland Criminal Defense Attorney Association. I'm an attorney in private practice. We strongly support this bill, and let me just give an example of what this does. I think the other witnesses covered a great deal of important ground. But if a person is charged in a very minor assault case, one where still a jail penalty of up to 3 months is allowed, but excluded, as Delegate Moon pointed out, sex offenses, domestic violence, excluded from this. Any serious physical injury or attempt to cause physical injury, those are excluded. So we're talking about de minimis assault cases in that scheme of assaults. That person will be, in this case, charged, handled in district court with a trial date set 30, 45 days out, go in front of a district court judge. The witnesses will appear one time, whether they're civilian witnesses, police officers, et cetera. They'll have one court date. Public Defender's Office will assign one lawyer. If they hire an attorney, that'll be one lawyer involved. The case will get resolved in a matter of weeks instead of a matter of months. I read the opposition to this, and they read almost identically. It's not so much that this is a bad concept, it's that too many cases are being steaded in null pros. If you're concerned about the efficiency of administering the justice system, getting cases in, minor cases, but important cases, getting them resolved quickly is very important. And this bill does that while excluding those top tier offenses. So you're not looking at injuries, an attempt to cause injury, sex offenses, or anything related to domestic violence. So we think this is a terrific bill. We strongly support it, urge a favorable report. It has been the product of many years of effort, and I think it addresses all of the concerns that the state's attorneys and other individuals have, or other groups, by making this a relatively narrow subset of offenses. We think it will significantly improve the administration of justice in this state. Thank you.
Thank you. Delegate Valentine.
Thank you, Madam Chair, and thank you, Delegate, for bringing the bill and the panel. And I agree with you, Delegate. I've always felt that there was a missing degree here for many, many years. To that point, and I believe some of my questions were already answered, because the intent, obviously, it's not going to go into 14101 of crimes of violence, but it's not intended to go into the Public Safety 501 or 5101 either, correct? For crime of violence. My only question is, how did you land on 90 days? What's the reasoning behind 90 days as opposed to, say, 6 months or something like that? I just was curious if there's a specific reason how you landed on that number.
Well, we definitely want to be in local detention. I'll start there. So you go under a year. I mean, after that, honestly, we can talk. But just to give you some context here, because these are currently in district court and circuit court, we at least have circuit court data, so you can get a sense of some of the where the more serious cases land. But the Sentencing Commission, and I confess I'm a member here, but they put out a report. Only 5% of the circuit court cases generate more than 5 years to begin with. So if you take the second-degree assault cases and you sort them into district court and circuit court, and you get the more serious ones in circuit court, even of the cases, 95% of them are under 5 years. 45% of them are under 1 year, and 27% of them are no sentence or sentence fully suspended. So that's almost 80% are going to be under a year or no sentence whatsoever. So to begin with, the most serious of these cases anyway, it's a tiny number of them that are getting into that, even above the 5-year mark. And so, what are we doing here? You're hitting the nail on the head here. The vast majority of these cases are not deemed by anyone to be anywhere close to the 10-year mark.
One consideration on the 90-day number. Above that is the charge is jury demandable from the district court.
Okay.
But I agree with Delegate Moon. I don't think that the 90 days versus 180 or some other number is necessarily written in stone, but that is a consideration. Okay. The prosecutor could, by keeping it at the third-degree assault, could say, this case is getting resolved
in district court.
Today in district court. Okay.
Thank you. Thank you, Madam Chair.
Sure. Delegate Cardin?
Thank you, Madam Chair, very much. Thank you for bringing the bill. You don't bring many bills, so it's always, I know that there's lots of thoughts put into it. The 90 days, as far as I'm concerned, if I'm in front of the wrong judge on a bar fight or a shove, I'm praying a jury trial. And think about the waste of time and money, because I'm going to wind up, that case is either going to be steaded or it's going to be disposed of with a probation for judgment in circuit court. But I've spent a lot of time and money, a lot of people's time going up to the circuit court. So maybe 90 days is smart. Mr. Ford, if I'm sitting on a bar stool and I get into an argument with the guy next to me and I shove him and he falls over and cracks his head, that would be a second-degree assault that we're talking about that shouldn't be included in this.
I think the prosecutor, who has wide discretion, would agree with you.
Okay, but if I'm sitting, let me just give you the second page. If I'm sitting on the bar stool, I get into an argument, or we start talking about, let's say, ice or something, and he's on the other side, and and I'm on one side, he's on the other, and I kind of just hit him, or I threatened to. I said I'm going to hit you. Threatened to hit him. Don't even touch him, which could be an assault as well if he really thinks that he could be in serious threat of bodily injury. That would be the kind of thing that we're talking about here. Is that fair to say?
Yes, I would expect that that's what we're contemplating. In addition, I think it's very important to note this is not contemplating that third-degree assault is a lesser included in offense of second or first degree. I think that's important because how a jury trial sheet would read if you're charged with all three, if you're charged with 2, assault in the first degree and assault with the second degree, the jury can't be informed that it's a lesser included offense. The state would have to specifically charge that crime third degree. So I think that's a fine point, but one that needs to be made.
Great, thank you.
Thank you. Members, do we have any other questions? Seeing none, I'm going to excuse this panel, and I'm going to call up William Kachif for unfavorable panel.
Madam Chairman, members of the committee, my name is William Katzif. I'm an Assistant State's Attorney from Anne Arundel County, here on behalf of the Maryland State's Attorneys Association in opposition to House Bill 907. The current assault law, I think, came into effect like around 1996, if I remember correctly. I was around here at the time that the bill was passed and the law went into effect. This was at a time when there was code revision taking place. Arson had already taken place, so had burglary. It took 2 years before the legislature finally came up with an assault law that would get passed. And what had at one time started out maybe up to 4 categories was finally determined that 2 would be the appropriate ones. Prior to that time, assault and battery had been common law offenses with a common law penalty, meaning the only restriction was that it not be cruel and unusual. The current law, I think, is entirely appropriate, and I think it's to properly survive the test of time. You've got the first-degree assault, which involves either a general intent component involving the use of a firearm or a specific intent component if it involves an intent to cause serious physical injury, as is defined in the statute. The serious physical injury is based on the old maiming law, which we used to have prior to the assault revision. And then we have second-degree assault, which is essentially common law assault and battery that encompasses everything else with a penalty of 10 years. Now, understand something. People don't get 10 years. As a matter of fact, in many of these cases, perhaps in most, especially if it's a first-time offender, the disposition will be a probation before judgment. I mean, I think it really, it's incredulous to think that 10 years is really what the going rate is for a second-degree assault. It clearly isn't. There's no justification, no compelling reason to change the existing law, as I said before, that has served us well for the past 30 years. I urge the committee to give the bill an unfavorable report.
Thank you. Delegate Phillip?
So there was testimony, I think you heard it, that if we look at this from a federal perspective, with a sentence of 10 years or up to 10 years, it could be viewed differently at the federal level. What's your response to that?
Well, I mean, it may very well, because under the federal law, I believe just about any crime that has a penalty of in excess of 1 year is considered to be a felony. Obviously, we don't have that law here in Maryland. I mean, I've gotten questions over the years with regards to our assault laws and some other laws that have that are misdemeanors, but have penalties far in excess of 1 year. I mean, that's just the way we do it. I don't think we have to base our laws on what the feds do. Let them take care of their business, and we'll take care of ours.
But our business has an implication on that.
Oh,
so shouldn't we have something that addresses this that doesn't meet the federal standard of a felony?
Well, I think the feds ought to recognize the fact that if some state classifies a crime as a misdemeanor, that they should respect that classification.
But they don't do that today, correct?
Well, obviously they don't. I mean, if a conviction for second-degree assault does have implications for a possible deportation, but they should respect our laws. They don't, but that doesn't necessarily mean that that's okay. They should respect our laws. We respect theirs, and they should respect ours.
Okay.
Delegate Embry.
Hello.
Nice to see you.
So what I'm confused by, if, as I read it, this is entirely within the discretion of the prosecutor whether to avail themselves of it, and it does reduce jury trial prayers, which for some offices, that's a benefit. I don't understand why oppose it if it's completely up to your discretion whether to use it.
Well, I understand that. I'm opposing it because I think if we're going to change a law, there ought to be a compelling reason to do it. I don't think that anyone has made the case that after 30 years, there's a needed change in our assault laws. Now, maybe if the issue was up for grabs, like it was 30 years ago, maybe we might view it somewhat differently. The question is, when we're changing the law, we have to, I think, set a standard, and that is the current law is not working and that we need to replace it, and there shouldn't be any unintended consequences with regards to the replaced law, with the new law.
Well, we've heard testimony about unintended consequences, including Delegate Phillips' point about federal consequences, but there's also consequences for state regulations and licensing, and so there are consequences to people of having a sentence, a conviction for something with a 10-year sentence versus a 90-day sentence. I think that
well, the consequences may exist at the time that the person is sentenced. Now, realistically, I could in my real life, I do felony screening. Okay, so I write up indictments. In those indictments, if there's a first-degree assault charge, for instance, I'll put first-degree assault charge, assuming I think the facts are strong enough, second degree. Now, the question is, do I put in this? Okay, if I want someone potentially exposed to 6 months or 90 days, I guess it's in the bill, I might say, no, I'm not going to do that. This is what the indictment's going to do. It's going to have first-degree assault, second-degree assault, and maybe reckless endangerment. But I'm not giving them a 90-day misdemeanor.
But you might, on the other hand, you might review a misdemeanor that comes in and is.
I can give them a 5-year misdemeanor with reckless enderangerment, or a 10-year misdemeanor.
You might say, oh, this really feels like a.
Well, listen.
Very minor touching.
The case that Mr. Ford talked about, if that were brought to my attention, that case would be gone long before it ever got immediately after it got to my desk.
All right, well, I appreciate it. Thank you, Madam Chair.
Delegate Cardin?
Thank you, Madam Chair, and I think you proved my point. So when people are praying up these minor touchings to the circuit court, what do you generally do when you review that case?
Well, I don't review those cases. I review cases that are charged as first-degree assaults, attempted murders. You know,
But you just said that if you saw some of those kinds of cases, you would just.
I said if something like that came to my desk, suppose, for instance, I got a call from the commissioner, I got a call from someone, a defense attorney, okay? Maybe the case in district court, but they called me, okay? I would look at the facts of that case, and I would say, well, listen, I'm jumping in, and this case is going away.
Okay, very good. So if you're reviewing a case, or maybe in your previous practice when you're actually trying cases.
Just to do that, yeah.
If somebody, a serious assault, somebody hurts somebody, no deadly weapon, but they hurt somebody, they got into a fight and they hurt somebody. First time offense, no record, pretty good kid, had potential, probably a PBJ, right?
Let me sorry, said somebody got seriously hurt?
Not hurt. They were in a fight and broke the guy's nose. Probably a PBJ.
Well, let's put it this way. It's certainly, I broke the nose. I might not even, if it came to me, I might reduce it to.
First time offense.
Delegate Cardin, when I screen a case based upon what charges I believe the facts support. If I think they support first degree, I write them up for an indictment. If I don't think they support first degree, I send it back to district court and let them decide what to do with it.
Well, so you said that generally speaking, first time offense, you're going to give somebody a PBJ.
I said judges typically do for assault.
So I'm giving you, so for an assault, it wasn't intending to really hurt the guy. He hurt him. Whatever it was, the guy fell, he hurt himself. First time offense, a judge is probably going to give the guy a PBJ, right?
Probably.
Okay. Guy, unwanted touching, no injuries whatsoever, but they decide the victim really wants to pursue this. Probably a PBJ, right?
Yes.
Okay. So now you have a second charge, he's got a PBJ on his record. On the one who's a much more serious one, that should matter. But on the one that was an unnecessary touching, do you think that he should just be disqualified from perhaps getting another PBJ simply because, I mean, that's what happened, but he's really upset with me and he wants to take me out now.
Exactly.
Well, let's put it this way. If I put on my screener's hat, I'm not going to look at the person's record. I'm going to look at the facts of the case, as I said, and determine what charges I think are appropriate. When the case is given to the prosecutor who's going to handle the case, he or she is going to have to make a determination as to what charges to pursue and what the appropriate penalty is.
So do you think that if you have a third-degree assault on your record versus a second-degree assault on your record, when you're determining what to do with this next case that happened, would that make a difference on what they're going to try and do on that next case?
Well, if I were put in the position of being a line prosecutor, which I no longer am, okay, obviously I would take that into account. What was their prior conviction for, second degree or third degree?
Okay, thank you. Perfect.
Thank you. Members, do we have any other questions? Delegate Valentine?
Thank you, Madam Chair, and thank you for being here today. I as someone who was here and was present when we changed over from common law to statute back in the 90s, I can appreciate a lot of the testimony today. My question is, because I've often thought we needed a third degree for various reasons, but my question to you is this. For these very simple offenses, these brushings, we've seen people charged for merely touching people, spitting on people and such. And for whatever reason they plead to that second degree assault, whether it's probation before judgment, for whatever reason, is that your opinion that it's truly justified to prohibit them from owning a firearm for the rest of their life because of a case where someone spit on someone?
Well, that's up to the legislature as to what offenses should prohibit somebody. I don't want to get into the issue of what should qualify somebody disqualify somebody from possessing a firearm. If that person is disqualified, then I charge that person accordingly. But it's really not for me to determine whether or not a person should be disqualified simply on the basis of that conviction. I just simply work with the law.
Well, because second-degree assault does prohibit you from that.
It absolutely does, yes. But if a person gets a probation before judgment, unless it's in a domestically related case, that person is not prohibited from possessing a firearm. And most, I think, unless somebody has a serious record or the facts are particularly egregious, is going to get a probation before judgment for second-degree assault.
Okay.
At least in Anne Arundel County, anyway.
Okay. I thank you. Thank you, Madam Chair.
Anne Arundel County is the place to be.
I agreed. I've lived here all my life, 75 years.
Well, thank you very much for your testimony, members. I don't see any further questions. That concludes our panel and concludes our testimony for House Bill 907. I'm going to move on now to Delegate Phillips with House Bill 1054. Delegate Phillips, I also have Steve Trostel. Yep, okay, great.
Thank you, Madam Chair.
You're welcome. Yes, please.
We'll try to keep this very simple. Oh, yeah? Yeah. Chair Bartlett, Vice Chair Davis, and members of the hardest working committee in Annapolis, Judiciary Committee. I'm here to present House Bill 1054 and respectfully ask for a favorable report. This bill makes a targeted and practical adjustment to Maryland law. Under current law, prosecutions for ethics violations and misconducts in office, such as malfeasance, misfeasance, or nonfeasance by public officials, must be brought within 2 years. House Bill 1054 simply extends that statute of limitations to 3 years. It is important to note that this bill does not These are the things it does not do. It does not create new crimes, it does not expand criminal liability, and it does not change the standard of proof. It simply provides an additional year for prosecutors to investigate, bring cases involving misconduct by public officials. These cases are often complex and difficult to uncover. They may involve internal audits, whistleblower complaints, or lengthy investigations that unfold over time. In many situations, misconduct is not discovered immediately, and by the time it surfaces, investigators are already working against the clock. I'm going to stop, and I'm just going to introduce Mr. Steve Trostel, Division Chief of the Public Trust and Police Integrity Unit in the Office of the State's Attorney for Baltimore City. Mr. Trostel is a recognized expert in prosecuting cases involving public corruption and police misconduct, and he will provide the committee with more background on this particular piece of legislation. Thank you, and I respectfully ask for a favorable report on House Bill 1054.
If I may, thank you. Madam Chair, Madam Vice Chair, to all the delegates and the representatives, and I want to thank the delegate to my left for sponsoring and the introduction. On behalf of the Baltimore City State's Attorney's Office, I am here to testify in support of House Bill HB 1054. As noted, misconduct in office by government officials, including police officers, already exists. It is a common law misdemeanor. The statute of limitations for misdemeanors is, by default, 1 year. However, Maryland's article on courts and judicial proceedings, Section 5106, extends the statute of limitations to, quote, within 2 years after the offense was committed, close quote. Prosecutors who handle misconduct in office investigations and prosecutions against police officers, we often learn of alleged misconduct long after the incident actually occurs. Unlike more common crimes such as murder, theft, drunk driving, wherein the offense is usually discovered nearly contemporaneously with the committing of the crime itself, misconduct is rarely discovered at the time that it occurs, or at least it isn't discovered immediately by those people who are responsible for the investigation of or the possible prosecution of the misconduct. Misconduct in office investigations generally start in one of two ways. A citizen or designee of the citizen, like an attorney or family member, reports misconduct to the police department or other law enforcement agents, such as the state's attorney's office or the attorney general's office. Or the respective police department identifies misconduct itself through its own auditing process, triggering an internal affair investigation and potentially a referral to the local state's attorney's office for consideration of criminal prosecution. Baltimore City has the largest police department, and the City State's Attorney's Office has the largest police integrity unit in Maryland. As the chief of the largest police integrity unit in Maryland, and as your witness here today, I can speak of the following with specificity. What my team and I have found is that significant numbers of allegations of misconduct lodged against police officers come to our attention near or after the expiration of the statute of limitations. There are several reasons for this. If I may, Madam, thank you. In the case of citizens or their designees reporting misconduct, some citizens who wish to file complaints are unaware of how to do so, are afraid to do so, or are incarcerated and unable to do so. In the case of law enforcement agencies discovering possible misconduct by their own officers, while frequently the complaints are made by first-level supervisors who do immediate frequent audits of their subordinates, several instances of misconduct are not unearthed until the upper-level commanders perform random and sometimes mass audits, and such audits frequently occur months or even a year or more after an act of misconduct occurs. By the time audits are completed, referrals to internal affairs could be a year or two after the incident occurred. In my nearly 8 years of handling police misconduct investigations and prosecutions, I'm encountering more frequent situations where my team and I are not learning of an alleged act of misconduct until it is too late to initiate a prosecution given the current 2-year statute of limitations. And while not every discovery after 2 years can be cured by extending this statute by 1 year to the 3-year limit that we seek, those of us who handle cases like this on a daily basis do believe strongly that the simple addition of 1 year to the statute of limitations will allow us to fully investigate and, when necessary, initiate a prosecution for most acts of misconduct by police officers that were not brought to our attention within the first 2 years after the incident occurred. I do have one more paragraph if I have time, Madam Chair.
A whole paragraph?
I'm reading as fast as I can.
Did you submit written testimony?
I did.
Okay.
I could defer to the written testimony. I thank you for your time.
Thank you. We also have Robert Hill.
Yes, good afternoon, Madam Chair. I don't know if you can see me on the screen or not. My camera was not working earlier, so.
Well, we can't see you, but you can go ahead and testify because we don't want to, wait, hold on.
Thank you very much. I don't know what's wrong with it, but at any rate, good afternoon, Madam Chair, Vice Chair, and members of the committee. I'm Robert Hill. I'm an assistant state attorney with Montgomery County, and I am the chief of the Special Prosecutions Division. And among the types of crimes that we prosecute include misconduct in office by public officials. And I want to echo what my colleague from Baltimore City has told you, that essentially these investigations are often multi-layered, and we'll find not infrequently that they have been investigating something in the Inspector General's office or with the Internal Affairs Division for some time before it ever comes to the surface and we become aware of it. And then we may be in a position where we have to conduct a grand jury investigation that can be very time consuming, including possibly trying to seek records from out of state, bank records, agency records, tax records, records from payment apps, records involving communications, texts, and that can be very, very time consuming. One of the things now that we are in the modern age, forensic downloads from computers and cell phones can take months and months. And so, this is a very serious crime, as I don't have to tell the panel this. It is, a breach of the public trust. And I think that the additional year that we're asking for is appropriate. It's not disproportionate to the crime we're talking about. And it'll ensure a thorough investigation and will ensure that perpetrators who breach the public trust will be held accountable. I thank you for your time, and I urge a favorable report.
Thank you very much. Members, do we have any questions? I see no questions. So that concludes this, concludes this panel.
Thank you.
The bill hearing for House Bill 1054. Delegate Coley, I'm sorry. He is very cool. That's why I thought Cooley was appropriate. Very good to see you.
Good to see you as well.
Welcome to Judiciary. I believe this is your first time in this committee. Is that correct?
This is my first time in Judiciary.
Well, very good to see you. So House Bill 1387. I have everyone present. Okay, whenever you're ready, Delegate.
Chair Bartlett, Vice Chair Davis, and members of the Judiciary Committee, thank you for the opportunity to present House Bill 1387. My name is Delegate Derek Coley. Maryland Auto operates to ensure access to required automobile insurance coverage for Maryland residents who are unable to obtain coverage in the private market. House Bill 1387, as introduced, removes the statutory 10% minimum commission requirement while retaining the existing 15% maximum. In carrying out that mission, the fund must operate within the statutory framework that supports sound governance, financial stability, and responsive expense management. As you know, in these tough times, there are a lot more uninsured Maryland residents who need automobile insurance. Under the current law, Maryland Auto is bound by a commission structure that includes both a statutory minimum of 10% and a maximum of 15%. The existing framework has remained in place for years, despite significant changes in the insurance marketplace and the manner in which policies are issued and also serviced. This legislation provides Maryland Auto with greater flexibility to manage this operating expense while maintaining the existing statutory safeguards on commissions. Allowing the fund to manage these expenses more effectively supports responsible operations and strengthens its ability to continue fulfilling its statutory mission. This is a measured and deliberate statutory update that modernizes the Commission's framework while preserving appropriate protections and maintaining the important role producers play in assisting Maryland drivers. For these reasons, I respectfully request a favorable report on House Bill 1387. Also, just so you'll know, and we'll go further in detail also, the cross-file in the Senate was passed on third reader today as well. Chair Bartlett and Vice Chair Davis, committee members as well, and we're looking forward to a favorable report. Thank you.
Good evening, Madam Chair and Vice Chair and members of the committee. I'm honored because they say save the best for last. Obviously, we really appreciate it, but in the convenience of time, just trust me, this bill is great. Vote for it if you can. And with that said, I want to introduce our Executive Director of Maryland Auto Insurance, Mr. Al Radmer, who will give our official testimony on HB 1387. Thank you.
Devon's right. Trust us is good. Madam Chair, members of the committee, you've had a very long day, and thank you for what you do. Because it's been busy, I'm not going to read my testimony. I would appreciate it if you would look at it when you get a chance. I'm going to go and say what I wasn't even going to say. We've been in here a couple of times, and we've talked about the MIAs requiring us to have adequate rates. We have to raise rates dramatically to cover our expenses and our losses. Every dollar that we can save in expenses is a dollar premium that we don't have to increase in some low-income community. So as the sponsor said, and thank you to the sponsor for leading the effort on this, this gives us the flexibility to align our interest, the interest of our policyholders, as well as the interest of our producers, considering the significant operational changes that have taken place and will continue to take place in this industry. We've done business with insurance producers for 50 years. We're not going to change that. Any modifications that we might consider making before we make them, we will meet proactively and collaboratively with insurance producers and their representatives to make sure that we are all on the same page. And with that, Madam Chair, we'd appreciate, I will mention the bill just went from second to third reader in the Senate. It's got 2 amendments. This bill, as introduced, would eliminate the floor. An amendment in the Senate would take the floor from 10% to 5%, and we're okay with that. That still gives us plenty of flexibility. The other amendment from the Senate would require us to not pay a commission if there's no producer involvement in the transaction, and we don't anticipate that occurring, so we're okay with that as well. And again, happy to answer any questions.
Good afternoon. My name is Joe Danahy. I'm the Associate General Counsel at Maryland Auto, and I am just here for questions. Thank you.
Great. Delegate Coley, I'll let you know that when you leave here, if you go to our reception, if you haven't already put in the amendments, they can tell you what you need to do to make sure that the committee members get a copy of your amendment. Members, do we have any questions? This is his first time, yes. Everybody has questions.
We're not going to be collateral damage, are we?
Thank you all. Thank you all. Thank you all.
We actually have a legitimate question. Delegate Embry.
Thank you, and Delegate, thank you. This bill makes a lot of sense. I'm curious where the 10% came from, why it was legislated, and why 10%, if you know, and how long it's been in law.
I think it's been, how long has it been? The whole 50 years?
No, not all 50 years. I think since about 2010.
2010.
I don't. I'm sorry. I can look into that and get back to you.
Probably somebody who owned an insurance agency.
Members, Delegate Phillips.
So I want to make sure I'm clear. In terms of producers and how people were signed up to secure MAFE, at one point in time, were there a number of individuals or brokers that were providing that service for you and for the potential users?
So that's a great question. Every policyholder that comes to us, it has an insurance producer. And the insurance producer is typically involved in the front end in bringing them to us.
Right.
But also, they're all engaged on the back end, making sure that our policyholders get the customer service that they expect and deserve.
So they are providing a service.
Absolutely.
Is it possible for someone to come directly to MAFE without an insurance producer today?
No, they can come to us and they can get a quote.
Yes.
And they can request coverage, but everything is completed with a producer.
And if you think about today versus 2010, how automated is the process today versus what it was in 2010?
It is a lot more automated today than it was in 2010. In a whole variety of different areas, both with underwriting and pricing and all kinds of, and on the claim side as well.
And so you would agree that there's probably far less for the producer to do today than they had to do in 2010?
Potentially on the front end, particularly with marketing and, even the marketing and prospecting has completely changed over the last 10, 15 years.
Okay, thank you.
Delegate Conaway.
Thank you for coming in. So with this MAFE policy, you can't sign up for this MAFE policy online without going through an agent?
Yeah, everything goes with a producer. Yes, sir.
So even if you go online, you'll be assigned a producer?
Correct. Mm-hmm.
And the producer now gets 10%, but it could go down to 5% if this passes?
We have no contemplation of doing that, but if the bill passed as amended in the Senate, we could go down to 5%. And I'll point out, there is no other insurance organization in the state that has mandated compensation of any kind.
Could you point out that if you do take your commission down to 5%, it pretty much means that most agents would have a reduction of income by half.
If we did that,
That's pretty much the math, right?
yeah.
Thank you very much.
Thank you.
Thank you, members. Delegate Congolo.
Thank you, Madam Chair. So I know now, you know, in today's world, most insurance companies, or you can go directly to the website and just, you know, get a quote and get a policy, and that's a fraction of a cost versus, I remember way back when you would have to use an insurance agent, you know, to apply for a policy. So why is it that we're not able to just cut out the middleman altogether and have people go directly to you to have the policy produced?
Yeah, that's a great question. I can't emphasize enough the quality and the value that producers provide to the customer. You know, all too often folks consider this to be a commodity. It's not a commodity. People that don't have professional help end up making the wrong decision to save money. So most folks need the counseling to go along with it. So the value of a producer on the front end of providing front end information and education is invaluable. Also on the back end when things go bad. So that's my perspective on producers. The other thing is from a operational perspective. So any business has fixed costs and you have variable costs. And, you know, for the most part, bodies are a fixed cost. And our business is volatile. We can't go out and produce business. We can only provide insurance to somebody that, as we've discussed, they've been canceled by their current carrier and were turned down by others. So we can't go out and generate business. We are relying on serving folks that are not wanted by the rest of the industry. For us to all of a sudden say we're going to do business without producers, we would have to hire a number of employees. I don't know the number, but it would be an extensive number of new employees just to do the back office customer service work to make sure that they are treated the way that they should. I will also add, because of our policyholders, they're with us because there are challenges for whatever reason, financial challenges or driving challenges. They require more help and more service than other folks. The other thing is, if you talk to the industry, they will tell you that our role is to be a temporary solution for folks, and we are. Our cancellation rate is over 50%. More than 50% of the policies we get are canceled by the end of the year. Now, some folks leave because they go drive around uninsured, but many folks go back into the standard market. To send these folks back out into the market without them having a professional that they can rely on, you know, I believe is a disadvantage for them. So what happens, an insurance producer will bring them to us. We will have them for a period of time, and at the appropriate time, that insurance producer will take them and they will graduate and go back out into the standard marketplace.
Right, okay, so this bill, okay, so you're saying they're coming to you from the market. So we're not talking about people who are novice, who don't know anything about insurance policies, liability versus full and deductibles. They have once upon a time been in the market. So I feel like I'm hearing you say that this bill is assuming that they need more help because they don't know, but they did know because they once upon a time did have insurance with another carrier.
I can assure you, having been in this business 40 years, just because somebody has had insurance in the past absolutely does not mean that they're capable of making decisions without professional advice. In my opinion.
I would believe they would have some knowledge. I wouldn't say they're not totally incapable. I mean, I know plenty of people that are actually, you know, in circumstances, and they're very resilient and resourceful. So I would challenge that.
So, some are better than others, but you can't undervalue professional advice.
Okay, thank you.
Thank you, members. Delegate Woods.
Thank you so much. So could there be a circumstance where a young person was insured through their parents and not really understood the system? And now as an adult, you know, because we know that our young people unfortunately don't always, you know, mature to the rate that we want them to. Could it not be that a young person who had that instruction or that support from a parent now finds themselves in a situation like this, so that they may not, even though they've had insurance coverage, may not completely understand?
And it's not just young people. And I'll give you a real example. You all may remember Brian Penick, the CEO of Care First. He had somebody call me, and this gentleman owns a business where he drives CEOs around with security and all this, and they were a client of, Care First was a client of his. This gentleman was in his mid-40s, owned 2 fancy Mercedes, and again, his job is for corporate America, picking up executives and driving them around. He contacted me because his rates for 2 vehicles went to $48,000. And he sends me the insurance information, and he had, his limits were $1.5 million, and I found out that that's a requirement from the corporate contracts that he signs. And I'm looking at it, and he had minimum limits of liability. Of uninsured motorist coverage. He had 30,000, 60,000, 15,000. So what that means is if he gets hit by an uninsured driver, his fancy Mercedes, the insurance company will write him a check for up to $15,000. And my first question to this gentleman was, do you know what these numbers are and what they mean? And he said, no, he didn't know. So that's just an example of one person in his 40s. This is a successful business guy driving around CEOs all day that had no clue what that number was. And I don't know why he didn't know. He may have bought it online, or I just don't know the circumstances. But that's just one example of somebody that didn't know and has had insurance for years.
I have a follow-up, Madam Chair. Thank you. So in the same vein of the question that I asked, it could be a young person that was insured by their parent. Could it not also be a parent who is now having to add a young person to their insurance and completely cannot understand, you know, why the double of their insurance or other processes take place that now put them out of a position to be able to comfortably pay for that insurance?
Lapses their insurance, and they can't get
insurance. That's a good point. Yes, I mean that's a good example. There are, you know, age is not a barometer of how knowledgeable. This is a complicated industry, and as the delegate reminded me, you know, a lot of the folks that we insure, they have financial challenges, and if you and you know, let's Doge goes out and they start slashing the federal workforce and contractors, so you get laid off. And after a couple of months, you're deciding what bill is going to get paid, and rent and food and prescriptions outweigh the car insurance, and unfortunately, you lapse. Now, if you've lapsed your insurance for any period of time, I don't know that every insurance company is going to deny you, but almost every insurance company is going to say, no, we do not want you. Now, the carriers will take you again if you've been insured for 6 months. Some are maybe 9 months. Others might be a year. So that's the role that we play. Somebody becomes uninsured. Their agent, State Farm, Progressive, whoever it is, brings them to us. They're insured, and at the appropriate time, the producer will say to the client, now we can graduate out of Maryland auto and go back into the standard market. That's why our cancellation rate in part is at, over 50%.
Thank you so much. Thank you, Madam
Thank
Chair.
you.
Thank you. Okay, members, that concludes our testimony for House Bill 1387.
Thank you.
Thank you. Thank you. Thank you,
So,
Madam Chair.
members, I have good news and news. The good news is that we're about to hear our last bill for the day. The news is that we have several witnesses. So I'm going to call for a 30-second to 60-second recess so that we can stand up and stretch for a moment, and then we're going to come right back. This is not a full 5 minutes or anything like that. Thank you very much. Thank you very much for that brief recess. We're going to call up our last bill, 1386, Delegate Tomlinson, and I have a panel for you. Scott Broadfoot, James DeWeese, this country lawyer. State's Attorney Shoemaker, and Stuart Welch.
All right, I know the line is save the best for last, or is it save the former Judiciary Committee member for last? It's good to be back. Thank you, Madam Chair Bartlett, honorable member, and Madam Vice Chair Davis, and honorable members of the House Judiciary Committee. For the record, my name is Delegate Chris Tomlinson, and I'm testifying on House Bill 1386. I am once again here to introduce Victoria, Scotty, Ashley, and Jader Law. This bill is named in honor of 4 young Marylanders who passed away as a result of a fentanyl overdose. Victoria was 18 years old in 2022. Scotty was 21 years old in 2019. Jader was 16 years old in 2022, and Ashley was only 15 years old in 2023. Now let's talk about what the bill does. A lot of you have heard this before, so I'll go over what the bill still contains. So the bill still creates a new felony for the distribution of heroin or fentanyl, which results in the death or serious bodily injury of another, with a maximum sentence of 20 years. The bill still includes language that will allow law enforcement to go up the chain. This bill still does not allow state's attorneys to bring charges in a situation in which the fentanyl or heroin was just a contributing cause of the death. The bill still makes it clear that it is the death or serious bodily injury. The death or serious bodily injury had to come from the result of using the heroin or fentanyl. I don't believe in reintroducing the same exact bill year after year expecting a different result. Because of that, I've listened to the opposition year after year, and I've made some major changes to this year's piece of legislation. The bill now makes it clear that state's attorneys will have to show that the drug dealer received remuneration. Previous versions of the bill included an exchange of goods and services. That part has been removed. The bill no longer references our existing Good Samaritan laws, which was a big concern for the opponents in prior years. And the biggest change in this year's bill is that prosecutors will only be able to pursue this enhanced penalty if the drug dealer has a prior felony conviction of distribution of a CDS, possession with the intent to distribute a CDS, or manufacturing a CDS. And I just want to repeat that one more time. So now law enforcement will only be able to pursue this charge if the drug dealer has a prior felony conviction for selling or manufacturing drugs, and they've now been busted a second time. Oh, and guess what? The second time now you've been busted, you killed somebody with what you sold to them. So for the opposition, who you'll hear from shortly, they'll come up and they'll say that the legislation targets innocent addicts who are not necessarily drug dealers. My response to that is that with this significant change to the bill, if you find yourself being charged with this enhanced penalty, you're either the world's most unluckiest, ill-fated son of a gun, or more likely than not, you're an actual drug dealer. I'm introducing this bipartisan bill along with Senator Mary Delaney James. There are a number of co-sponsors on the bill from both sides of the aisle. The bill has support from Montgomery County council members, including the council president, state's attorneys, chiefs and sheriffs, the Office of the Attorney General, and several others. The opponents of this bill will say that the families who are pushing for this are out for revenge and that no legislation will bring back their loved ones. I would like to push back on that notion. This bill is about providing justice for the families of the victims. It's about recognizing, acknowledging that there is a difference between distribution and distribution that results in the death of their customer. Thank you to the members of the committee, and I ask for a favorable report.
Thank you. And whoever would like to go next is fine.
Good afternoon. My name is Scott Broadfoot Sr., and I fully 100% support House Bill 1386, Victoria, Scotty, Ashley, and Jader's Law. This bill was named after my son, Scotty. On April 12, 2019, I lost my 21-year-old son, murdered by a drug dealer who sold him drugs laced with fentanyl. Scotty purchased what he thought was cocaine. The cocaine had 2 forms of fentanyl mixed with it. The dealer who sold to Scotty was never charged or even arrested. The dealer had several prior arrests with charges relating to fentanyl. With this bill, the dealer would have been charged with my son's death. This bill represents hope and accountability. It offers a necessary tool to hold drug dealers responsible for the harm they cause. Fentanyl is a deadly substance, and those who distribute it must be held accountable for the lives lost and the family shattered. It would penalize the dealers and take them off the streets to prevent them from selling these deadly drugs. I fully understand that there's a lot of important topics this session. Everyone in this room chose their position to help create laws to better Maryland. I have also chosen my role to make Maryland a safer place to live. Please help me understand why this is my third year presenting and testifying on this bill. Why hasn't it even been brought before committee for a vote? Madam Chair, you have an opportunity to bring this bill to vote before the committee your first year in chair. Drug dealers must be held responsible for murder. Everyone has consequences for their actions. Since birth, we are rewarded or punished for our actions. Drug dealers are selling poison to our loved ones. Drug dealers must be held accountable. I would never see my son smile again. Thank you.
Thank you, Madam Chair, Vice Chair, members of the House Judiciary Committee for allowing me a few minutes to speak favorably on behalf of HB 1386, distribution of heroin or fentanyl causing serious bodily injury or death. I'm Carroll County Sheriff Jim DeWeese. I oversee both law enforcement and corrections for my county. I'm a retired captain with the Maryland State Police, where I served 25 years as a state trooper. In support of HB 1386, as a matter of full disclosure, my office worked closely with the Maryland State Police and local law enforcement to investigate the death of Scotty Broadfoot Jr., the Scotty part of this legislation. Even though a suspect was identified, the current laws made it impossible to charge the suspect criminally, and certainly no specific law existed to specifically charge a dealer with the death of an individual they knowingly dealt death to. My county, your county, or city have countless citizens dying of drug overdoses from heroin or fentanyl, dealt by dealers that know their product is going to kill their clients. It's not a matter of if, it's a matter of when you'll die from using what they're selling. We must hold individuals accountable for selling a substance that almost instantly kills its user. Local law enforcement and prosecutors must have a tool to hold these individuals accountable. We're all naive if we don't think drug dealers know exactly what they're doing or why they're doing it and how they can get away with doing it. Pass this legislation to make sure the message is sent that we will hold you accountable for intentionally selling heroin or fentanyl that kills our citizens, our loved ones, and for killing Victoria, Scotty, Ashley, and Jader. Thank you.
Madam Chair, Madam Vice Chair, it's great to be in front of my favorite legislative committee. Of course, this will likely be the last time that I'm in front of you because some of you may have heard that I'm retiring, so it's good to be here, but this bill is incredibly important to me, so here I am. I'll direct your attention, of course, to my written testimony, which you should have in your packets, where I discuss the challenges presented under State versus Thomas regarding going after drug dealers for gross negligence or involuntary manslaughter, in particular proving that the dealer's actions were wanton and reckless. But that brings up a point that I think is worth highlighting. This bill goes after dealers. It doesn't go after users. And while it's certainly true, thankfully, that fatal overdoses have gone down, they're still happening. They're happening in my jurisdiction, and they're happening in yours. Fentanyl continues to be mixed in with other drugs to increase their potency. They've appeared in nasal sprays and pressed into pills to look like legitimate prescriptions, and they've even shown up in vape products. And it doesn't take much to kill someone, just 0.00007 ounces, in fact, is enough to kill somebody, and the drug dealers know that. So, ultimately what this bill would do is it would provide another tool to deter and prosecute the purveyors of deadly poison in the state of Maryland. I believe it's time to pass this bill, so I respectfully request a favorable report.
Good afternoon, committee members. My name is Stuart Welch, and I'm an Assistant State's Attorney with the Harford County State's Attorney's Office. I'm also the Senior Contact Attorney for the Felony Guns and Drugs Unit and assigned to our County Drug Task Force. In 2025, for the first time in Maryland history, I convicted a drug dealer of second-degree depraved heart murder for distributing a fatal dose of drugs. I'm here today to request the committee to provide a favorable report on House Bill 1386. Handling fatal overdose cases, I regularly meet with the families of overdose victims who carry a tremendous amount of pain. Had their loved ones died in West Virginia, Pennsylvania, Delaware, New Jersey, Virginia, or even DC surrounding us, or any of the other 38 out of 50 states that already utilize drug-induced homicide-related laws, I would be able to pursue specific drug-induced homicide charges against the dealer. In Maryland, however, I will have to go for either manslaughter or attempt depraved heart homicide charges, which is much harder to convict than if we had specific charges like the ones introduced by House Bill 1386. As part of my job, I often sit down with drug dealers for what are called proffer sessions. I have interviewed dealers from small-time to large quantity narcotic traffickers. One thing that they have in common is that they're well aware of the dangers of fentanyl and how common it is for fentanyl to be mixed in with other drugs that they're selling. These dealers continue to sell these dangerous drugs anyways, despite knowing the risk. I also personally provide expert courses on fatal overdose prosecutions, investigations, different jurisdictions across the U.S., including recently in New Orleans, Louisiana, Chicago, Illinois. As I travel to these different states, I've seen the various drug-induced homicide laws that these jurisdictions already utilize, and I can attest that House Bill 1386 is far more balanced and less strict than the great majority of the ones that I've seen. Even Illinois, with a major jurisdiction like Chicago, has a much stricter drug-induced homicide law with harsher penalties. In fact, my research shows me that at least 30 of the 38 states that already have these laws have harsher penalties than HB 1386 would allow, including many of them having mandatory minimum penalties. House Bill 1386 is extremely reasonable, and it is time Maryland joined the vast majority of states that already have laws like this. I respectfully request the committee to provide a favorable report on House Bill 1386. Thank you, committee, for your time and attention on this issue.
Thank you. I have a couple of questions and a couple of comments. Mr. Broadford, you have been coming here. I've seen you come here and share your story. I know that it is painful. I appreciate you for your advocacy, and thank you. And I'm so sorry.
Thank you.
My other comment is to State's Attorney Shoemaker. You will be missed. Although I do not think this will be the last time, because I'm sure you'll do some advocacy of some sort if you want to. Now, for my
Thank you.
Thank you for all your service here. My question perhaps is for Mr. Welch, because I never understood why a drug dealer would ever lace their product with fentanyl, because they're killing their user. But they're doing it because of the addictive nature. And is it a gamble that you put in a little bit and you hope that little bit will be the reason why they come back again and again? You know, thinking, I'm reading some of the testimony here from Carroll County, and I guess the thought is that the person thinks they're having Oxycontin or they're, something else, or cocaine or something, but it's really laced with fentanyl for that addictive nature. Is that what's going on?
I can say that does happen. I think the vast majority of times where we're having a case where where fentanyl is mixed in with another drug, it's very common now. Most of the cases I handle, it's what's called polydrug, where we have multiple drugs, including fentanyl, mixed in. A lot of the times, it's not necessarily the intention of the dealer to mix the fentanyl in with that, but it's happening so often that it's more that they just know the risks of that. I've handled cases personally, like I said, where we've had interviews with the dealers that have even themselves ingested drugs similar to that, and they know that it had that impact on them. We've even had cases where dealers are well aware that they were getting batches that had fentanyl mixed in. It just really happens to be, we get kind of waves that happen at a time. So in 2023 in Harford County, we had a big wave of cocaine that was being mixed with fentanyl, which led to a lot of overdose deaths in our county. So usually it's mixing with other drugs before it even gets to the dealer sometimes, or it just happens that they're preparing both drugs in the same location. And a lot of times it's very easy for the drugs to mix.
So that leads me to my last and final question, maybe, and that is the intent, because that is a part of the bill this year, is the intent. So how do you, and this could be for either Mr. Welch or Mr. Shoemaker, how do you prove intent here? And is it going to happen where the other person is saying, I got the drugs from party A, I didn't know that when I was giving the drugs to party C, that they were laced? I mean, do you, how would you prove intent here?
Sure. So a lot of times for any case, we're usually looking at messages and cell phones from the dealer to the victim. So it can be anything from the price of the drugs that they're selling to language that they're using. A lot of times we can tell from the lingo of what they're using, things like that give us an indication what their intent was. Or even if it's at the point where really they can act like they didn't know, but they clearly did know, things like that. We can look at that at the messages in their phones or other evidence, the surrounding circumstances of the case that lead us to that point.
Thank you. So basically what you're saying, if we pass the bill, you'll get to intent. You just need to have the mechanism.
Yeah, and that's the thing. So like I said, I already handle cases like this just with the limited manslaughter that I have now with these. So we already get to that point in these cases. Me personally, as a prosecutor in Harford County that handles these cases, if I don't have fentanyl come back in these cases, I don't even go for the manslaughter on top of the distribution. We'll just go for straight distribution at that point. It's virtually impossible to get even past a grand jury, let alone a jury, for manslaughter or depraved heart homicide charges if there's not fentanyl found in the system of the individual that ingested the drugs. So usually we already do that. We're already looking for someone that's usually specifically dealing fentanyl, and that's, and a lot of times, as I said, a lot of the dealers already know that they're dealing fentanyl or that they know the dangers of that. They proceed to do that anyways for profit. And that's a lot. Those are the vast majority of the cases that we're charging. We don't even charge unless there's fentanyl found in the system.
Okay, thank you.
Yes.
Delegate Mangio?
Thank you, Madam Chair. Thank you, Scott, for being here as well. I'm very sorry for your loss. We've met before, so I appreciate your advocacy. Obviously, so many, your lives, your family's life shattered, so many more lives, and I'm really worried about future lives being shattered, which is why I'm very supportive of this bill. And it appears that there's a lot of bipartisan support, but I wanted to ask the bill's sponsor, because I was just going through the testimony, and I have to be honest with you, I'm actually quite shocked to see that it appears the mayor of Baltimore is against this bill. And then Baltimore City obviously is the largest city in the state of Maryland, and by all these reports, even the New York Times talked about how the overdose numbers in Baltimore City are some of the highest in the country. Have you seen that testimony? And if so, what do you have to say about that?
Thank you, Delegate. I did see the testimony. I was reading it all last night. I'm disappointed. Obviously, I love the city. Obviously, they've been impacted by fentanyl probably just about more than any other area in the state of Maryland. It's concerning, especially considering between July and October this past year, you had down in the Penn North neighborhood, you had 3 mass overdoses over the course of those months. Approximately 42 some people ended up overdosing. Thankfully, none of them died. You still have a large number of fentanyl-related deaths every single year. You know, and especially Penn North basically operates as a 24/7 open air drug market, really. So I'm disappointed to see that he would come out against it. Do you want to chime in?
Yeah, I'm a bit shocked that any senator, delegate, elected official would actually come out so strong against legislation where you're looking to hold people accountable, not just the first time, but these are convicted felons that have done it once before. This bill's been amended 3 times based on the feedback that Delegate Tomlinson's got from his colleagues here, whether it's the judiciary or other parts of legislature. So I'm a bit taken back that the mayor of a city that is undoubtedly the East Coast hub for distribution of heroin and fentanyl to every part, probably east of the Mississippi, in this area that would go against something like this. It's just simply a tool for these folks that are to my right to hold individuals accountable. And unfortunately, the mayor's got an awful lot of them in Baltimore City that need to be held accountable.
Thank you.
Thank you, Madam Chair, and thank you, Delegate, for bringing this bill again, and to your entire panel. My question was originally for State's Attorney Shoemaker, but I think after some of the testimony, I might divert over to Assistant State's Attorney Welch. And we kind of touched on it because you touched about depraved heart, you've touched upon manslaughter. Is there a specific reason you can't pursue manslaughter as just in these cases as a default? What's the reasoning behind that?
Yeah, so you say that we can't pursue them?
That you can't? Can you pursue or can't you pursue? I was kind of confused in some of the testimony for these cases against dealers, like manslaughter charges.
Yes, we already do for involuntary manslaughter. Like I said, I already have charged some cases. I can tell you that without this bill, the amount of cases that I could have charged is much higher with the bill if it was in place than without it. Like I said, it's very hard to get past even a grand jury for these charges. Typically, right now, as it stands, I have to have some aggravating factor in order to get past that. So in the cases that I've charged, usually there's something that goes beyond even the distribution. Sometimes it can be where I've had cases where the individual knows that the victim has mental health issues and they still distribute to that person, knowing that even, I had one case where even other dealers wouldn't deal to this person because they knew about the issues. This individual knew that, continued to distribute for profit anyways, and led to that victim's death. So a lot of times we have to have aggravating factors. I had another case where they not only refused to call 911 until it was way too late, but by the time they did, they also lied to 911 and said that they didn't think the person could have ingested drugs, things like that, and really prevented this person from getting life-saving medical help. So it really is only the extreme cases now that I'm able to even pursue. We still get enough of that where I can get some every once in a while, but without this bill, it really is one hand behind my back as I'm trying to
Without this bill, it very severely limits your ability to prosecute.
Yes, absolutely. And even with the bill, like I said, or as has been said, there's a lot of restrictions on this bill that, as I look at other states, that they don't have in other states. A lot of states, it's any drug. A lot of states don't require you to prove that the individual has a past prior distribution conviction before you're able to bring these charges, or the remuneration part. So most of the time, in a lot of states, it's just that you distributed a drug, like in Pennsylvania, drug delivery resulting in death charges, things like that, where just showing that someone individual distributed a drug and that resulted in the person's death. So this has a lot more restrictions, even once it's passed, that really restrict us in what we can charge. And also, there's no mandatory minimum, so it really leaves it to the discretion in sentencing to the judge and the state's attorney, and us to request. So,
thank you, Madam Chair. Thank you.
You're
Madam
welcome.
Chair,
Yes.
may I direct an answer to your question? Okay. So you had asked a question about, why they're mixing with fentanyl. Okay. So basically fentanyl is one of the cheapest drugs that the dealer can get a hold of. And they're mixing it, and they're backyard chemists, basically. And that's why some might survive, some might be addicted, and some may die. And because my advocacy works in the streets and so forth, and some might not know this, that a true addict will, if they hear that someone is selling a drug where someone overdosed or even died, it's like a rush to buy that drug. So maybe as an addict, a certain drug, even mixed with fentanyl, they might get used to it or not get as high. So when the dealer, it's all about money for the dealer, because there's always going to be someone else in that line, even if one dies. And I've learned this through talking and communicating and trying to figure out how to cure this problem. So to help answer that, because it doesn't make sense to someone that's not addicted, and even if you thought something was the best thing, why would you go to someone where someone else died? It doesn't really make sense, you know? And what was the other question you asked? I had something to say.
I don't know if I remember my other question, to be honest with you. I think my main focus was, because I'm always wondering why dealers would lace with fentanyl. So that's the crux of
It's
what
cheaper.
Yeah, it's
And they can get a more amount of it for the price. And then they'll mix it, whether they do it straight or they mix it or however it is. But these aren't obviously chemists. But even so my son, in the $20 worth of cocaine he purchased with a friend, and the friend did a little bit, and he went to bed, he didn't feel good. And my son did the rest. So the autopsy showed, yes, there was cocaine, but it had two kinds of fentanyl, acetylfentanyl and fentanyl. There's certain kinds of fentanyl where it's a grain of salt could kill an elephant, let alone a human. So his friend did it with him. So it's really a gamble, depending on your chemistry and how much you intake, and your body responds to it.
I understand. Thank you. Members and panel, I am going to have to excuse myself for a meeting that I have to attend. I want to make sure that the panel knows, no offense to you all, but I do have to step away, and Madam Vice Chair is going to take over now. Thank you for being here again.
Thank you.
Delegate Moreno.
So this could be for sponsor or the panelists. According to data from states with similar laws shows that prosecutions disproportionately target people of color, even though a few of the investigated overdose deaths involve victims of color. With Maryland's prison population already standing at 70% of people of color, how can we be sure that this bill won't worsen the racial gap in our justice system?
So while the numbers might show that about on the distribution side or the conviction side, the numbers also show that the largest demographic of those who are dying and overdosing are also Black Americans or Marylanders.
And the last question, can you provide the current racial and ethnic breakdown of individuals in Maryland who currently have a distribution conviction on their record?
I've got some numbers here that shows that it's not necessarily fentanyl, but 77.6% of folks who are sentenced for felony narcotic offenses are Black, 19.7% white.
Okay, thank you.
You're welcome.
Thank Delegate McComas.
This may sound kind of stupid to you, but I'm not, it's been a long time since I took criminal law, but the question is there any way that it could be a strict liability issue in the criminal sense that, everybody knows fentanyl is very dangerous, and in fact, they're even afraid to bring in a search dog, if there's fentanyl in the crime scene, because just as you said, one little probably grain of, or maybe like piece of salt, a little tiny grain of salt or something, or pepper would kill the dog, or even a person. So I was just wondering, is there any way that a law could be done that it's like strict liability if you kill somebody and they have fentanyl in their, in the autopsy, that, hey, dude, you should have known better. It's like giving somebody arsenic. It's a poison, and they all know it's a poison. They aren't that dumb. So I just kind of wonder, is that an option? And so you don't have to do all this. I mean, I think this bill should pass, but what I'm saying is these guys should be put out of their, they should be jailed for a long time.
Well, I'll take that one. I mean, we don't have a lot of strict liability criminal offenses on the book. I mean, on the books, I think, statutory rape comes to mind. Other than that, not a lot. I think that would be a difficult pill for a lot of people to swallow, imposing strict liability for an offense of this nature. But, proving intent is a burden that the state virtually always bears, and it's one that we certainly don't shy away from. So, I mean, I think the bill is structured fine as it is.
If I could add to that, there are some states that have similar to what you're referring to. I know that As I mentioned, there are states that have what's called drug delivery resulting in death charges, or where it is more just that they distributed the drug and that caused the fatal overdose. And in those, there is no need to show any kind of intent or anything, just the fact that person A distributed drug to person B and that they died as a result of ingesting those drugs. So it does happen in other states as well.
But you just don't think it's ever going to happen in Maryland, right?
I mean, I think really some of the what's been added to this bill is more to kind of impose protections from what some of the other committee members or what some people have brought to the attention of the committee, which is that, you know, we're trying to restrict really to our more serious drug dealers, people that, as we mentioned, have prior convictions for distributing. So not someone where this was a first instance, not someone where they were just they were just sharing with their friend and they passed away. This is a situation where we've already proven in the past that someone has distributed dangerous drugs, and on top of that, even with the conviction, continue to do so for profit. So this is why we put these added protections in there, so that we are really, it's even taking more discretion away from the prosecutor, but in return, it's creating more protection for other people that, I know that other people have concerns about who we're targeting. So in this case, it would just leave it to really our more serious subsequent offending drug dealers.
All right. Seeing no questions, this concludes this favorable panel. Thank you so much for being here, and good to see you, Mr. Shoemaker.
Hey, it's always a pleasure.
All right, we're going to call the next panel, which is an unfavorable panel, and we have Anita Kennedy, Darcy Kerwin-Garber, Dan Rabbit, Jesse Dunleavy, Elizabeth Hilliard, Thomas Higdon. I'm going to call until we get them full up here. We can do at least 5. Let's do 5 for now. Okay, thank you for being here. Where do you want to start? How about we start from this end?
Absolutely.
Yes. Please say your name for the record.
Thank you. Committee members, Vice Chair, good to see you. My name is Darcy Kerwin-Garber, and I'm with the Baltimore Harm Reduction Coalition, and we are respectfully and strongly opposed to House Bill 1386. Now, I know it has been a long day, and I do want to acknowledge the pain and the loss that is in this room. I know on both sides, whether in opposition or for this bill, the majority of people in this room have lost loved ones to overdose. For some of that is as recently as a couple days ago. And I know that probably that loss affects your families as well. All of us want to prevent overdose deaths, and that is also explicitly why we are in opposition. At my organization, the organization I work with, we do daily street outreach with local churches, encountering 300-400 community members every single week, people who are actively using drugs. I can say I have engaged to reverse overdoses in my personal life and at work, and I can say people are genuinely terrified and panicked to call 911 in those situations. It is scary. They are trying to support their friend who is overdosing, doing everything they can in that way, while actively going against all of their instincts, saying that calling 911 is then associated with arrest. And they do that still. They still call 911, but that is fragile because people have been arrested prior to the Good Samaritan laws, and so that is part of their experience. So any additional penalties, and we are talking 20 additional years on penalties that already have decades, that is additional fear that people have to overcome in extremely important moments. Minutes that can be the difference between life and death. So I know that many of our participants, all of them are trying to improve their lives. Some of them do also sell drugs. They sell drugs for survival, for their own use. This difference between only drug users and drug sellers does not exist as clearly as that. I'm happy to answer any additional questions on what that looks like on a daily basis, but thank you for your time.
Thank you. Next.
Thank you, Chair and Vice Chair, committee members for letting me speak in opposition to this bill. I'm Jessie Dunleavy, My son, Paul, died of a fentanyl overdose in 2017. Paul had a language impairment that compromised his ability to communicate. His teachers loved him, praising his sensitivity and his kindness. Also loved at home, but otherwise marginalized and often bullied, Paul's feelings of inadequacy grew. And by his 20s, he discovered self-medicating, giving him relief, then leading to unimaginable suffering. At one point, he was incarcerated. He was hungry. He was robbed. And targeted by his vulnerability, he was sexually abused. A huge setback. But by 32, he had a job he loved, affording his first apartment. He was proud of the recognition that he got for his hard work. At 34, he relapsed. He used with another. There was an exchange of money, but I don't know who supplied the drugs. Had it been Paul, I do know he would not have had knowledge of any additives, nor would he ever have had a sinister intent. Had another overdosed, the thought of Paul in prison for the better part of his adult life is unbearable for me. It's worse than his being deceased. I thank God he spared a life where dehumanization is routine and the weak are exploited. He was a productive, tax-paying citizen with a heart of gold. Some violations, sadly prompted by the stranglehold of addiction, warrant incarceration, but a murder charge, regardless of naivete or intent, is extreme. It will victimize the marginalized, the poor, the Black, the disabled, as our laws have proven to do. Unfortunately, in reality, all drug users are breaking the law, but categorizing some as victims and some as criminals is a slippery slope that adds to the immeasurable harms of the war on drugs. I live and breathe the pain of every parent who lost a child to overdose. But the research is convincing. This bill will not save lives. Please vote against it. Thank you.
Vice Chair Davis, members of the committee, good evening. My name is Dan Rabbit. I'm the Policy Director at Behavioral Health System Baltimore. We are the local behavioral health authority for Baltimore City and stand in strong opposition to HB 1386. HB 1386 is a return to failed approaches from the war on drugs era, where we're trying to incarcerate our way out of what is a very difficult and very tragic problem of addiction. Levying higher and higher prison sentences will not reduce drug use, prevent overdose, deter drug dealing, or change the composition of the drug supply. It will lead us back to mass incarceration and spending millions of dollars on state prison costs. That is not the direction we've been heading in. To the question of why would the Baltimore City mayor be opposed to this, I think this is why, because this bill is not going to help reduce the number of people dying of overdose in Baltimore City. It is going to increase the number of Baltimore City residents spending decades in prison. HB 1386 is not only ineffective at its stated goal, but it could make our overdose problem worse. We're very grateful that the state, this General Assembly, has passed Good Samaritan protections for people who report overdoses in good faith. But people are skeptical to call 911 to begin with. This bill has no protections for people who call 911 in good faith and someone dies and then they're found to have been the one to distribute the drugs. The protections were taken out of this year's version. That was not on our behalf. I know the sponsor said it was like a concession. This just means that anyone who is found liable, regardless of whether they called 911 or not, is going to be subject to this law. I think the point that Delegate Moreno uncovered, that almost 80% of the people in the state of Maryland that have a distribution charge on their record are people of color, tells you this is only going to increase racial disparities that much more. We're seeing a dramatic reduction in fatal overdose right now. We've seen that drop by half in the last 2 years. It's because the fentanyl supply has gone dramatically down due to powers well outside the street level drug distributor. So let's not rock the boat. Let's stay the course, and please reject HB 1386.
Madam Vice Chair, members of the committee, thank you for this opportunity to testify. My name is Thomas Higdon, and I'm offering this testimony in strong opposition to HB 1386 on behalf of the Maryland Alliance for Sensible Drug Policy. We are a grassroots statewide advocacy group led by people with lived or living experience with substance use. And I personally am a survivor of addiction and the war on drugs, and I'm here to share my personal experience. I used illicit drugs for more than 2 decades, and during that time, I bought and used drugs in 11 states and the District of Columbia, so I've been around the block a few times. In that time, I've lost friends and loved ones to overdose, so I know the pain that the sponsors of this bill are trying to address. But what I learned throughout this process was that most people who sell drugs are not kingpins out of central casting. They're people like I was, people struggling with substance use disorder, selling to cover their own use. The line between using and selling drugs blurs fast when you're trying to avoid withdrawal, trying to make rent while still paying for your drugs, or just trying to survive. That's why drug-induced homicide laws like this one terrify me. They don't just threaten the so-called dealers. They threaten my friends, my partners, my family members. And they threaten the very people this bill is supposed to protect, people who use drugs. And my fears are justified, as the data shows. A 2021 study of all those other states that have drug-induced homicide laws found that half of DIH prosecutions were brought against friends, family members, and romantic partners of the person who died. 47% were brought against people who rarely sold drugs or only sold drugs in small quantities. So DIH laws do not work. So let's focus on policies that you all know work because you've passed them in the past. Let's remove criminal penalties for personal use of paraphernalia. Let's scale harm reduction programs, expand drug checking, make treatment easy and accessible to access, and invest in recovery support services, the things we know that work. So for these reasons, I urge you to give this bill an unfavorable report. Thank you.
Thank you, sir.
Thank you, Madam Vice Chair, members of the committee. Elizabeth Hilliard on behalf of the Office of the Public Defender. We strongly urge an unfavorable report for House Bill 1386. I had something planned, but what I'd like to highlight currently is 2 pieces of the legislation that I think are both operative and critical to understanding the opposition. First is Section C, which explains that, except as otherwise provided in this title, a person may not distribute heroin or fentanyl or a chemical analog of heroin or fentanyl without the lawful authority to do so, the use of which results in the death of or serious bodily injury to another. There is no intent in that phrasing. There's no requirement to intend harm. There's no requirement to know that there is fentanyl or an analog in the drug. Second, although there is an explanation that distribute under this law requires remuneration, I would, 1, highlight that remuneration is an incredibly broad definition, and 2, highlight that despite that definition, there is another way for someone to be convicted under this statute. Specifically, in subsection D, it explains, if possession of heroin or fentanyl or chemical analog of heroin or fentanyl is transferred more than once before the occurrence of the death or serious bodily injury, each person who distributed or delivered the heroin, fentanyl, or the chemical analog of the heroin or fentanyl shall be considered to have violated this section. I would be happy to discuss both my personal and professional experiences with addiction and why prevention and protection is the way to go, but we urge a unfavorable report for House Bill 1386. Thank you.
All right. Thank you. For this panel, are there any questions? Delegate Conaway.
Thank you, Chair. Thank you, panel, for coming in to testify. To the panelists on the end, can you finish your thought? A little bit.
Thank you. Thank you. Yes, I was just going to highlight the strategies that do work for prevention and protection are overdose prevention sites, fentanyl test strips, access to mental health and physical health care, including addiction services, and this is a big one, certainly, education and destigmatization of addiction.
And what about the part where a person who might be carrying it, the second person or something that might be carrying it gets the charge?
Yes, so the way I read the law is that each person who has delivered the heroin, fentanyl, or chemical analog of heroin or fentanyl shall be considered to have violated this section. So it's not dependent on the distribution, which requires the remuneration. It also includes delivery.
So that could be a significant other person that you and that person are sharing, but they bought it and they sharing with you, so they could get charged.
Absolutely.
Thank you very much.
Thank you. Delegate Embry.
Thank you. And this question or questions are for Ms. Hilliard. So by definition, if someone can be convicted of this, they can be convicted of distribution of heroin or fentanyl, exposing them to 20 years. Is that correct?
Yes, that's how I would read the way that this law operates and the way that 5603 and 5602 operate. An individual who would qualify under this would also qualify for possession with intent to distribute or distribution.
Which carries a 20-year
yes.
penalty, is that correct? And I know this is not identical to manslaughter, but manslaughter also involves arguably reckless behavior that results in the death, and the penalty for manslaughter is 10 years, is that correct?
Yes, that is correct.
So that they are currently exposed to a 20-year penalty, which is double the manslaughter penalty
yes,
under current law.
And if I may also clarify, I at least have handled cases where distribution can apply to different substances as well. And so if an individual has marijuana, even though cannabis is legalized, if they have cannabis in an amount sufficient to demonstrate distribution and also have another illicit substance like heroin or cocaine, those could be stacked on top of each other. I've represented people who have been sentenced to 40 years
for the narcotics related.
For separate types of drugs in their possession.
And is it also true that at sentencing you could bring up the fact that the person had caused the death of one or more people?
Absolutely.
So the judge could sentence to the maximum, which would be potentially 40 years even.
Absolutely.
I appreciate that. Thank you.
Yeah.
And if I could just also mention, fentanyl itself, this body decided it's so serious of a drug that it carries a 10-year enhanced penalty in and of itself.
I forgot that.
So fentanyl distribution is already 30 years, which a judge can consider where in that range would be appropriate.
Okay. Delegate Stinnett.
Thank you, Madam Chair. I guess my question is, and you know, I'm all for outreach. However, what if you have an individual that has a history of this type of act in terms of, you know, mixing fentanyl with whether it being cocaine, whether it being, you know, marijuana or whatever, but a history of it that they have, you know, I guess that comes into the intent or whatever, but what if the individual has a history of this? Would you feel that they should be held accountable?
I think that question is not related to this bill, because this bill specifically allows for the predicate offense to be any conviction under 5602. And as I mentioned, you could get a conviction for 5602 for sufficient amount of cannabis possession. You could get it for having other prior, and there's no time period on when the prior conviction was. There's no requisite that it had to previously be a conviction for fentanyl. There's none of those sort of what you're envisioning as guardrails in place in this bill. And I think while I understand the desire to punish someone who is putting people's lives at risk, I fear, and in my personal and professional experience, that binary between the person using the substances and the person distributing the substances does not exist. It's often, that line is blurred. Those people are often the same.
Thank you. Thank you.
All right, colleagues. Seeing no further questions for this panel, I'm going to call the last panel. Thank you all for being here.
Thank you so much.
I believe we have Heather Warnkin and 3 others who are on on the camera, and Lisa Hammer, Neil Franklin, and Barbara Allen. You don't have Lisa Hammer? Okay. Okay, we're going to start with Heather all alone. Thank you. You may proceed.
Good evening, Madam Vice Chair, members of the committee. Heather Warnken. I serve as Executive Director at the Center for Criminal Justice Reform at the University of Baltimore School of Law, here in opposition to HB 1386. The center recognizes the devastation and gravity of the pernicious harms of substance abuse, addiction, and overdose in Maryland, particularly those relating to fentanyl and heroin. Like all states, Maryland has seen an unfathomable number of lives lost and families destroyed. It is because of this devastation and not in spite of it that we oppose this bill. Appropriately, much has been said about the urgent need for a public health response to addiction and overdose. Instead, this bill doubles down on a failed, overly punitive approach of the war on drugs. It runs counter to evidence and lived realities of communities suffering from the burden of addiction. We cannot afford to and should not make these same mistakes again. But also important to emphasize is that for that punitive approach, we already have those tools. And I think the last panel covered that well. Several criminal laws and penalties currently exist in Maryland that states' attorneys may use when someone dies or experiences a serious bodily injury after purchasing heroin, fentanyl, or their analogs. Under current law, an individual who sells deadly substances to another person may be sentenced to 30 years. HB 1386 would allow that individual to serve up to 50 years in prison if the person who purchased the drugs experienced serious bodily injury or death. This runs counter to what we know through the research about long sentences, deterrence, and public safety. This is excessive. We already have the punitive tools necessary. These goals are also undermined by the fact that HB 1386 is susceptible to broad and variable interpretation, resulting in disparate and extreme enforcement. Under HB 1386, a person need not know that the controlled substance contained fentanyl or heroin to be liable under this bill. And lastly, I will just direct to our written testimony where we list the extensive research demonstrating the racial disparities in how these penalties will be used. As this committee has heard several times throughout this session over multiple bills, we have a serious racial disparities problem in our state's criminal justice system, and this bill will make that worse. For these reasons, we urge an unfavorable report. Thank you.
Thank you. We're going to hear from Neil Franklin.
Madam Vice Chair, back again. First of all, my heart goes out to those who have lost loved ones, which includes myself, from overdose. But I'm probably the only one that you're going to hear from today that has spent decades on each side of this issue. I worked undercover. I've made so many arrests of people selling drugs. The vast majority of those arrests are not major drug dealers. They are people who are selling to support their own addictions. And these are people who are at the last couple of links in the chain of all of this. And they have no idea what's in that packet that they're passing along. You've heard about the racial disparities that we're dealing with. You've heard the numbers, the percentages. That's one of the reasons why the mayor of Baltimore is against this. But in my past couple of decades, I've spent so much time collaborating with people who are dealing with this issue of addiction from a health side, a preventative side. I've learned about customs. I've learned about the environments of habits and the challenges and relationships and the stigma and the secrecy. There's no doubt in my mind of how this will play out in the policing world because I've been there, I've done that, I've made the arrest, sacrificing people just to try to work my way up the chain. This is not the way to go, and I'll end with this. In 2017, I personally worked 2 such cases in Maryland as an expert witness for the Public Defender's Office. And you know what? The bad part about that is that, yes, they were both convicted for manslaughter, and these were friends of the people who unfortunately died. So the laws are there, the tools are there, they can continue to be used. We've heard that, I'm not going to repeat that, but for these reasons and more, please give HB 1386 an unfavorable report. Thank you.
Thank you, sir. Ma'am, can you hear me? You're next. I can't see your name. Barbara?
Yes, I'm here.
You can proceed.
All right. Thank you, Madam Vice Chairman and the committee, and for staying all day. You have my undying appreciation for your energy. For the record, my name is Barbara Allen, and I'm the Executive Director of James Place. We're a nonprofit. The best part of what we do is provide scholarships for those folks that are transitioning from treatment for substance use disorders into recovery housing. Our focus is saving lives while working to improve options for hope and healing for this disease. For over 15 years, I've had the privilege of working with several thousand individuals working hard to rebuild their lives in spite of this disorder. My clients are not major dealers. They are those living day to day in the shadows, just trying to survive, just trying to live. In doing funding interviews, there's two questions that I ask everybody I want to share quickly. One is, knowing the potential of lethality for heroin, fentanyl, for example, can you talk to me about why you continue to use? And that's almost a facetious question, but I ask it anyway. But no one says it's a party. No one says that it's a lot of fun. What they say, it's survival in a situation to avoid being dope sick. The second question I ask on a regular basis is, if you were to die from an overdose, would you want the person who provided the medication or the substances for you to pay a penalty, to consider an incarceration for, say, 20 plus years? The answer is always emphatically no. And what I hear them say is they too are suffering from this disease. We're all just trying to find a path forward. As a parent, this is not a path forward that we want to hear. When my son Jim died almost 23 years ago, which is very hard to believe, I was devastated. Working through those early years of bereavement, I pledged to find a path forward for others who are suffering this disease. That's when our nonprofit was born. To learn about the disease, to track legal and medical history, this work has been life-affirming as I've been blessed to meet so many with substance use and thousands of other bereaved family members over time. The failed 50 years on the war on drugs has not stopped anyone from using or distributing substances. When we all, as a society, are we all as a society be willing to learn, or are we not willing to learn? Sending another family member's loved one into an incarcerated situation, is that what we want to be doing? Depriving them of their loved one? That's not going to bring my son back, my two brothers, or my niece back. It's not going to give me grandchildren. And ultimately, I will say that please turn your focus to proven evidence-based practices of treatment, harm reduction, sentencing, viable sentencing options. So for that reason, I ask for an unfavorable report on this bill. Thank you.
Thank you. Thank you, Barbara, for sharing. I think I overlooked Anita Kennedy? No?
Dr. Joseph Adams signed up to in-person testimony on Friday.
Okay, last person to testify, and then we're going to ask questions and go home.
Thank you so much.
Sure.
My name is Dr. Joseph Adams, and I'm testifying on behalf of the Maryland, D.C. Society of Addiction Medicine in opposition to HB 1386. I'm an internal medicine and addiction medicine physician. I want to mention how often people with opioid addiction distribute fentanyl to other people with opioid addiction, and it happens very, very frequently. A person who has opioid addiction has to use and obtain fentanyl an average of 4 to 6 times a day to avoid intolerable withdrawal, which causes vomiting, inability to sleep or move, severe pain, and naturally and understandably, people will do almost anything to do this and to avoid this for themselves, and also to help others, help family members or loved ones to avoid this. In fact, they are caught up in a cycle of addiction that they can't figure out how to get out of at that time. This is extremely dangerous, as we know. People can die from fentanyl at any time. To a large extent, it's unpredictable who will die. So, as you've heard, at least half of the people that are caught up in these types of laws are just friends and family of the decedent, no matter how many times they may have been convicted of doing this in the past. It makes sense to incarcerate actual drug dealers, but incarcerating people with opioid addiction makes our job as treatment providers harder. If this were a good idea, treatment providers like myself would be calling the police on probably most of our patients. We don't do that. Incarcerating people with addiction makes it harder, much harder for them to do the hard work of recovery. My heart goes out to parents on both sides of this issue, and I understand that proponents believe that this will reduce overdose deaths. I believe that it would have the opposite effect. People with opioid addiction will continue to do what they feel like they need to do, regardless of whether this pill passes or not. Thank you.
Thank you. Colleagues, this doesn't conclude the testimony on this last unfavorable panel. Are there questions? Seeing none, thank you all for staying and being our last panel. We really appreciate you. And this concludes the bill hearing on HB 1386. Thank you.